Court officer? Court officer? Court officer?
ಹೇಳಿ ಮೇಡಮ್, ಹೇಳಿ ಮೇಡಮ್, ಕೇಳಿಸ್ತಾ ಇದೆಯಾ?
ಹಾ, ಈಗ ಕೇಳಿಸ್ತಾ ಇದೆ ಮೇಡಮ್.
ಹೇಳಿ.
ಇದು ಫಸ್ಟ್ ಟೈಮ್ ಟೈಮ್ ತಗೋಬಹುದಾ?
ಏನ್ ಫಸ್ಟ್ ಟೈಮ್ ಅಂದ್ರೆ?
ಇಲ್ಲ ಇಲ್ಲ, ಇವಾಗ ಕಾಲ್ ಔಟ್ ಮಾಡ್ತಾರ ಫಸ್ಟ್ ಫಸ್ಟ್ ಟೈಮ್ ತಗೋಬಹುದಾ?
ಪೇಜ್ ವೈಸ್
ಅಡ್ಜಾರ್ನ್ಮೆಂಟ್ ತಗೋಬಹುದಾ?
ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಕಾಲ್ ಆಗುತ್ತೆ, ಅವಾಗ ತಗೊಳ್ಳಿ ಮೇಡಮ್.
ಓಕೆ ಮ್ಯಾಮ್, ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು.
ಕೋರ್ಟ್ ಮ್ಯೂಟ್ ಆಗಿದೆ.
Adjournments. Page 1, seal number 1. Page 2, seal number 2 and 3. Page 3, seal number 4 to 6. Page 4, seal number 7 to 9. Page 5.
Serial number 8. 1 week time.
Seal number
8.
This FC matter. Whom do you represent? You are in represent-
Respondent.
You only have filed application for vacating stay. ನಿಮ್ಮ ಹೆಸರೇನು?
Ravishankar. Madhusudan.
ರವಿಶಂಕರ್ ಅವರು.
Ravishankar ಅವರು.
You have filed application for vacating stay. You want adjournment? Adjourned at the request of respondents counsel. Yes.
Page 5, seal number 10 to 12. Page 6, seal number 13 to 15. Page 7, seal number 16 and
Serial
17.
number 16, 1 week time may be granted.
Oh, Mahesh.
Miss, ಅದು ಒಂದು ನಿಮಿಷ. Mr. Mahesh, we constantly keep getting disturbances from your system. We request our registrar computer to bar you from this digital appearance.
And this is what is happening is on the street somebody will be moving. That is the
See, you have to manage that.
yes.
ನೀವು ಅದೇನು ಸೌಂಡ್ ಪ್ರೂಫ್ ಏನಾದ್ರು ಮಾಡ್ಕೋಬೇಕು ಫ್ರಮ್ ವೇರ್ ಯು ಅಪಿಯರ್.
Yes, please. I'll do that, my lord.
ಇಲ್ಲಾಂದ್ರೆ ವಿ ಲಾಸ್ಟ್ ರಿಜಿಸ್ಟರ್. ಯಾಕಂದ್ರೆ ಎಷ್ಟು ಸರಿ ಹೇಳಿದ್ರು ಯು ಡೋಂಟ್ ಕರೆಕ್ಟ್ ಯುವರ್ ಸೆಲ್ಫ್.
ಇಲ್ಲ ಅದು ಇನ್ಸ್ಟ್ರೂಮೆಂಟ್ ಚೇಂಜ್ ಮಾಡಿದೀನಿ ನಾನು.
ವಿಲ್ ಆಸ್ಕ್ ರಿಜಿಸ್ಟರ್ ಕಂಪ್ಯೂಟರ್ ಟು ಬಾರ್ ಯು ಫ್ರಮ್ ಅಪಿಯರಿಂಗ್ ವರ್ಚುವಲ್ ಅಪಿಯರೆನ್ಸ್.
I'll get it corrected, my lord. I'll tell you.
Page 7, seal number 16 and 17.
I appear for serial number 16, 1 week crime may be granted.
ಇರ್ಲಿಲ್ಲ. ವೈ ದಿಸ್ ಅಪೀಲ್ ದೇ ಸೇ ಸೆಕ್ಷನ್ 47 ಅಂತ ಏನೋ ಹೇಳಿದ್ದಾರೆ ಅವರು.
Yes, I will correct it.
No, appeal doesn't lie and did you examine the provisions?
No, my lord, my colleague is presented.
No
1 week time may be
urgency, no?
granted.
After vacation ಹಾಕೋಣ ಹಾಗಿದ್ರೆ list as requested by appellant's counsel, list after 4 weeks. Yes.
Page 8, seal number 18 to 22. Page 9, seal number 23 to 27. Page 10, seal number 28 to 32. Page 11, seal
Lordship.
number
Yes.
27, list number 2, your lordship, serial number 27.
All list number 2 matters will be referred to Lok Adalat.
Oh, much obliged, your lordship. Much.
Page 10, seal number 28 to 32. Page 11, seal number 33 to 35. Page 12, seal number 36 to 38. Page 13, seal number 39 to 48. Page 14, seal number 49 and 50. Page 15, seal number 51 to 54. Page 16, seal number 55 and 56. Page 17, seal number 57 to 59.
57.1, 57 and 57.1. Now appeal have to file application for substituted service. Respondent number 2 is owner of the vehicle. I pray for a week time to file application.
2022 ಅವ್ರೇನೋ urgent. Any amount is released to them?
ಇಲ್ಲ 50%.
ಕರೆಕ್ಟ್ ಆದ್ರೆ ಯಾವ್ದು ರಿಲೀಸ್ ಆಗಿಲ್ಲ. ಅದರ್ವೈಸ್ ದೇ ಸ್ಟಾರ್ಟ್ ಎಲ್ಲ ರೆಕಾರ್ಡ್ ಮಾಡ್ಕೊಂಡ್ಬಿಡಿ. ಅವ್ರದ್ದು ಏನೇನಾಗುತ್ತೆ ಎಲ್ಲ ರೆಕಾರ್ಡ್ ಮಾಡ್ಕೊಂಡು ಕಳಿಸ್ಕೊಡೋಣ ರಿಜಿಸ್ಟರ್. ಅಲ್ಲ ಅಂದ್ರೆ ಅದು ಇರ್ಲಿ ಅಲ್ಲಿ ಸಿಸ್ಟಮ್ ಅಲ್ಲಿ. At request finally 10 days time is granted to the needful in respect of respondent, failing which appeal against respondent shall stand dismissed. If you do not file application within 10 days, it will be dismissed against.
Page 18, seal number 60 to 62.
Last. 63 from there.
Your lordship's leave, my lord. Serial number 55.
Yes.
Day after tomorrow, my lord. I'll request.
The appellant, my lord. Serial number 55.
What
I am
is
for
it?
the appellant.
Adjournment ಕೇಳ್ತಾ ಇದ್ದಾರಲ್ಲ ಏನಾಯ್ತು?
Day after tomorrow, my lord.
Right, sir.
ಇನ್ನೂ ಒಂದ್ಸರಿ ರಿಲೀಸ್ ಮಾಡಿ. 55. Dismissal of appeal ಅಂತ ಇದೆ ಅದು.
ಇಲ್ಲ ಸೆಕೆಂಡ್ ಸೆಟ್ ಹಾಕಿದ್ದೀನಿ.
There was some temporary order it seems. ನೋಡ್ತೀವಿ ಬಂದಾಗ.
ಅಲ್ಲ ಸೆಕೆಂಡ್ ಸೆಟ್ ಹಾಕಿದ್ದೀನಿ, ಅದು ಚೆಕ್ ಮಾಡ್ಬಿಟ್ಟು
ನೋಡೋಣ. Next.
Full ಕರ್ಸಿ. List number 1 for orders, seal number 1. Pratisha DJ, M. Ramakrishna, Prabhugot Tambagi.
This case, Miller, I'm sorry,
Go ahead.
we are unable to deposit the cost, Miller, in favor of the LRs of R1. Miller, directly I am paying 5,000 cost to my runner.
18/3/2025. Now, what is the order date?
2005 matter, my lord, decreed in the year 2012.
What happened, Miller, previous council, LS Krishna died. Miller, we could not be able to trace the own files, Miller, we are not in the office. Now, Miller, I requested my friend to give a paper book so that I will get
Correct. Now,
Not
5,000 ಕಾಸ್ಟ್ ಡೆಪಾಸಿಟ್ ಮಾಡ್ಬೇಕಲ್ಲ.
cost, I am paying directly, Miller, please.
ಡೆಪಾಸಿಟ್ ಮಾಡ್ಬೇಕು ಅಂತ ಆರ್ಡರ್ ಮಾಡಿದ್ವಿ ನಾವು.
ಯಾರಿಗೆ ಅಂತ ಗೊತ್ತಾಗಿಲ್ಲ ಸರ್.
ಡೆಪಾಸಿಟ್ ಅಂದ್ರೆ
LRs of R1 ಅಂತಿದೆ ಸರ್ ಅದಕ್ಕೆ.
Lord, the suit is for-
ಇದೆ ಅಲ್ಲ, ಪೇಬಲ್ ಟು ಲೀಗಲ್ ರಿಪ್ರೆಸೆಂಟೇಟಿವ್ಸ್ ಆಫ್ ಡಿಸೀಸ್ ರೆಸ್ಪಾನ್ಸ್ ಫಾರ್ 1.
ಯಾರಿಗೆ ಅಂತ ಗೊತ್ತಾಗಿಲ್ಲ ಅದಕ್ಕೆ.
ಅವ್ರೆ-
I am sorry, Miller.
ನಾವೇ ಇದೆ.
ಮತ್ತೆ ಇದಾರಂತಲ್ಲ.
I am paying,
ಯಾರು?
I am
This
paying.
is again unacceptable.
Lord, may I request not
Amendment ಆಗಿದೆ ಅಲ್ಲ, ಕಾಸ್ಟ್ ರೇಟ್ ಅಲ್ಲ.
ಆಗಿದೆ,
ಹಾಕಿದ್ದಾರೆ.
How is that you did not
ಹಾಕಿದ್ದೀವಿ.
ಏನ್ ಹೇಳ್ತೀರಾ?
Lord, the suit is not a partition and separate position.
ಬಿಲೇಟೆಡ್ಲಿ ಕಾಸ್ಟ್ ತಗೊಳಕ್ ಏನ್ ಹೇಳ್ತೀರಾ?
Because I leave it to my lords.
I am paying cost, please, Miller.
If you leave it, we'll send it to the High Court Legal Services Committee. Yes.
Cost paid, man.
Uh,
You lordship may kindly permit me
No.
to share.
Belatedly. Counsel for the appellant pays the cost through counsel for the loss of his phone number 1. Okay. Yes, next.
But a short matter, my lords, may I request my lord this?
You know, along with statement of non-filing of wakalat, Srinivas advocate for the appellant. ಯಾರೋ ವಕಾಲತ್ತು ಹಾಕಿಲ್ಲ ಅಂತ ಇದೆ ಅಲ್ಲ.
ಇನ್ನೂ ಹಾಕಿಲ್ಲ ಸರ್ ನಾನು.
ನೀವ್ ಯಾರನ್ನ ರೆಪ್ರೆಸೆಂಟ್ ಮಾಡೋದು?
I am but the appellant.
ಯಾವ ಅಪೆಲೆಂಟ್ಗೆ?
Appellant 1 and 2.
ನಿಮ್ಮ ಹೆಸರೇನು?
My name is not mentioned, Miller.
ಮತ್ ನೀವು ವಕಾಲತ್ತು ಹಾಕ್ದೇನೆ ಹೇಗ್ರಿ? ವಾಟ್ ರೈಟ್ ಆಫ್ ಆಡಿಯನ್ಸ್ ಯು ಹ್ಯಾವ್?
No, Miller, I
ವಕಾಲತ್ ಹಾಕೋದಕ್ಕೆ ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ಅಂದ್ರೆ
requested the previous councils to give.
ಕಾಸ್ಟ್ ಕೊಟ್ಬಿಡಿ. ಕಾಸ್ಟ್
ಇಲ್ಲ, ತಗೊಂಡೇ ಇಲ್ಲ ಸ್ವಾಮಿ.
ತಗೊಂಡೇ ಇಲ್ಲ, ಮತ್ತೆ ರಿಸೀವ್ಡ್ ಅಂತ ಬರ್ಕೊಳ್ತಾ ಇದ್ವಲ್ಲ ನಾವು.
ಇಲ್ಲ ಇಲ್ಲ ತಗೊಂಡೆ.
I undertake to
ಕಾಸ್ಟ್
follow
ನಾಟ್ ಪೇಡ್ ಆನ್
all the appellants.
appointed days. Even the wakalat for appellant number, how many appellants are there? 2005. sir. Huh? Nothing in the case ಅಂತ ಹೇಳಿ.
ಹೇಳಿ ಏನು? Please tell us the merits. Tell us about the merits of the case, Mr. Counsel.
ಪೇಪರ್ ಬುಕ್ ಇಲ್ಲ ಅಂತಾರೆ.
ಏನಿಲ್ಲ.
Paper-
Not necessary, please argue.
ನಮ್ಮ ಹತ್ರ ಏನು ಇಲ್ಲ ಸರ್, ಯಾಕಂದ್ರೆ ಸತ್ತೋದ್ರು.
ಯುವರ್ ಅಪೀಲ್. ನೀವು ಬೇಕಂದ್ರೆ ನೀವು ಪೇಪರ್ ಬುಕ್ ನೀವು ತಗೋಬೇಕು. ಅವ್ರಿಗೆ
ಅಪಾಲಜಿ ಕೇಳಿದೆ ಸರ್, ಫಸ್ಟ್ ಸಾರಿ ಅಂತ.
miss ಮಾಡ್ತೇವೆ ಬಿಡಿ.
We will ready in the next week.
Please address the argument just now. We'll hear you.
Next week ಮಾಡ್ತೀನಿ ಸರ್.
ಈ ತರ ಮಾಡ್ಬಾರ್ದಲ್ಲ.
ಅಂಡರ್ಟೇಕ್ ಮೇಲೆ ಯು ಲಾರ್ಡ್ಶಿಪ್ ಆಲ್ಸೋ
ಅವ್ರು ಡೆತ್ ಆಗಿದ್ದಾರೆ ಅಂತ ಹೇಳಿ.
ಮುಗಿಸ್ತೀನಿ.
They don't have a right of
PS
audience.
ಕೌನ್ಸಿಲ್ ಡೆತ್ ಆಗಿದ್ದಾರೆ ಅಂತ ಹೇಳಿ.
ಅವಾಗ ಇನ್ನೊಂದು 10,000 ರೂಪಾಯಿ ಕಾಸ್ಟ್ ಹಾಕೋದಷ್ಟೇ. But he has not.
ಡೆತ್ ಆಗಿದ್ರೆ ಇನ್ಕನ್ವೀನಿಯನ್ಸ್ ಅಂತ ಹೇಳಿ.
ಆಮೇಲೆ ಇನ್ನೊಂದು ತಗೊಂಡ್ ಬರ್ತಾರೆ ಅವ್ರಿಗೆ
ಎಲ್ಲ ಹಾಕಿನಿ.
ನಾಟ್ ಒನ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಅಂತ ಹೇಳಿ.
ಎಲ್ಲರಿಗೂ
This is all the tantrums they play.
ಮೇಲೆ ಎಲ್ಲರಿಗೂ ವಕಲಾತಾಗಿ ನಾನು ರೆಡಿ ಮೇಲೆ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಮೇಲೆ ಪ್ಲೀಸ್ ಮೇಲೆ ಐ ರಿಕ್ವೆಸ್ಟೆಡ್ ಮೈ ಫ್ರೆಂಡ್ ಟು ಗಿವ್.
What prevented you from filing wakalat now? Last time also you have undertaken.
He is bedridden, first respond is bedridden. That is the main problem.
You represent, you said you appear for the appellants.
Appellant.
ಅವ್ರ bedridden ಇದ್ರೆ ನಿಮಗೇನ್ ತೊಂದ್ರೆ?
Abide by the please Miller.
ಇಲ್ಲಂದ್ರೆ they don't know themselves. ನಾವು ಫರ್ದರ್ ಕಾಸ್ಟ್ ಹಾಕಿ ಎಡ್ಜನ್ ಮಾಡ್ತೀವಿ. ತಗೊಳ್ಳಿ, ಕಾಸ್ಟ್ ಕೊಡಿ ಅವ್ರಿಗೆ.
Next time I will undertake before the sun, I will argue Miller.
Your name is ಶ್ರೀನಿವಾಸ್ ಅಲ್ವಾ?
ವಿ ವಿಜಯಶೇಖರ್ ಗೌಡ.
ನಿಮ್ ಹೆಸರೇ ತೋರಿಸಿಲ್ಲ ಇಲ್ಲ.
ಇಲ್ಲ ಸರ್, ಇಲ್ಲ.
ಮತ್ತೆ ನೀವ್ ಯಾಕೆ ಯಾವ ಬೇಸಿಸ್ ಮೇಲೆ ಕೊಡ್ತೀರಾ?
I said, I have questioned my lordship.
ಯಾರು? ವಿ ವಿಜಯಶೇಖರ್ ಗೌಡ.
ಗೌಡ.
Visitation Gowda, learned counsel, undertakes to appear for the appellants, and he pays cost to the counsel for respondent number 1A2 The counsel for the loss of respond number 1. He seek further adjournment on the ground that he has not received the records. ಏನಿದು?
Appellants.
But he is appearing for the appellant mode, so I am appearing for the respondent.
ಅದನ್ನೇ ಹೇಳಿದ್ವಿ ನಾವು.
ಅಂತ ಒಂದು ಮಾತು ಹೇಳಿ.
Counsel for response 1A to 1F now. 1A to C, E and F. Opposes adjournment. Time granted and further cost of is 5,000. Yes, Tom? ಇಲ್ಲಿ ಕುತ್ಕೊಂಡು ಫೈಲ್ ಓದ್ಕೊಂಡು ಏನಿದೆ
Very sorry, my lord, this is old matter.
ಆರ್ಟಿಸ್ಟ್ ಅಂತದ್ ಏನೋ ನಿಜವಾಗೂ ಅಂತ ಕಂಡೀಷನ್ ಇದ್ರೆ ಶುಡ್ ಸಿಟ್ ಹಿಯರ್ ಅಂಡ್ ರೀಡ್ ದ
Morning
ಫೈಲ್
only the approach.
ಮುಗಿಸ್ಬಿಡ್ಬೇಕು ಮಾಡಿ.
Martin, sir.
Lord, they have denied relationship. Even in fact, not in evidence, they admitted that I am the not the one of the son of not. That is the case.
ಅದು merit ಮೇಲೆ ಮಾಡೋಣ.
17-4.
17 further cost of rupees 5,000.
17-4.
He is permitted to file wakalat in the registry within 1 week.
Serial number 2, O Mahesh, Asha Shetty for R1.
I appear for appellant, my lord.
Amount is deposited.
Lord, IA copy not served, my lord.
Why did you not file? Why did you file application if amount is not deposited?
I will file the copy, my lord.
Huh?
I will file the copy.
Copy only. See, according to the office note, they have not deposited they have not produced the proof of deposit.
Please,
We are asking you whether they have deposited before the tribunal.
no, my lord.
But ಹಾಗಿದ್ರೆ application for release ನೀವೇನು ಹೊಸದಾಗಿ ಬಂದಿದ್ದೀರಾ?
Listen, the
ನೀವೇನಾದ್ರೂ
first matter.
ಅದೇ ಫಸ್ಟ್ ಮ್ಯಾಟರ್ ಅಲ್ಲೇ ಸೀರಿಯಲ್ ನಂಬರ್ 2.
My memo of deposit has been filed, my lord, before this court on 4/1/21, having deposited in compliance of the stay order.
It is not filed, it is not placed before us.
I got acknowledgement, my lord, for having filed the deposit memo on 4/1/21.
You may be having, but we don't have the records at all here. Then produce that acknowledgement. We'll
Please, I'll do that, my lord. I'll do that.
ಅದೇ 2018 ಮ್ಯಾಟ್ರ್ 2021ರಿಂದ
What is the merits?
In the website, my lord, it will be disclosed. I'll check up and I'll let you know.
No, what is the merits? What are you challenging, Mr. Counsel?
My lord, I request negligence and quantum.
Please point out. Records are here. We'll hear you.
ಪಾಸ್ ಓವರ್ ಮಾಡಿ ಅದು. ಯು ಆರ್ ರೆಡಿ? ಯು ಹ್ಯಾವ್ ರೆಕಾರ್ಡ್ಸ್? ನಿಮ್ಮ ಹತ್ರ ರೆಕಾರ್ಡ್ಸ್ ಇದೆ ತಾನೆ? ಫೈನಲಿ ಇದನ್ನ ಹಿಯರ್ ಮಾಡಿ ಡಿಸ್ಪೋಸೇ ಮಾಡೋಣ. ಅವ್ರು 2021ರಿಂದ ಇಲ್ಲಿವರೆಗೂ ಡೆಪಾಸಿಟ್ ಮಾಡಿದ್ರೆ ಚಿಟ್ಟಿನಲ್ಲಿ ಫೈಲ್ ಮಾಡಿ 21 ವರೆಗೂ ಕಂಪ್ಲೇಂಟ್ ಮಾಡೋದಿಲ್ಲ.
Aye, sir.
ವಿಲ್ ಪಾಸ್ ಇಟ್ ಓವರ್. ವಿಲ್ ಹಿಯರ್ ದ ಮ್ಯಾಟರ್.
Day after tomorrow, my lord, may I ask for day after?
ಸಾರಿ. ಎಸ್
Passed over. Serial number 3, Manjula Tejasvi. Manjula Tejasvi.
Yes, Your
N. Gopal Krishna.
Appearing for the respondents. Your Lordship, I'll, 1 week time, I can only be given, Your Lordship, I'll take a paper publication because liability has been challenged here.
at door law. At request 2 weeks time is granted to them. Yes.
Serial number 4, Raghu Prasad BS.
Here for the appellant in this case, my lord.
For the respondent.
Vikesh Singh M.
You appear for the appellant.
Appellant has been, my lord.
But you have said in your memo to connect. How they are connected ಅನ್ನೋದೇ ಹೇಳಿಲ್ವಲ್ಲ ನಿಮ್ಮ ಮೆಮೋದಲ್ಲಿ.
Lord, what has happened is, she had filed
ಅವರು ಹೇಳಿದ್ದಾರೆ
petition for,
these cases arise out of execution cases ಅಂತ ಹೇಳಿದ್ದಾರೆ ಅವರು. But should you not tell in your memo how they are connected?
I'm sorry, respect of that.
ಇದೇ ಹೈಕೋರ್ಟ್ ಅಲ್ಲಿ ಇರೋದನ್ನೆಲ್ಲ ತಗೊಂಡು ಬಂದು ಕನೆಕ್ಟ್ ಮಾಡಿ ಅಂತ ಹೇಳಿದ್ರೆ ಕಾರಣ ಹೇಳ್ಬೇಕು.
This matter was, my lord, even before the single judge in writ petition, my lord, on 2 occasions, settlement was tried. She is neither coming forward to rejoin because that is also not possible during the interim period, my lord, between the decree and the challenge to the decree by her. I have remarried. She is aware of it. Because I remarried, she challenged.
How they are connected? They are not connected.
They are connected, my lord.
You may
because
say so.
the
You-
suggestion
Mr.
came
Counsel,
from the.
You are the officer of the court.
My lord.
Bari execution case ಮೇಲೆ ಒಂದು
True.
restriction ಹಾಕಿದ್ರೆ ಅದು
I'll just submit, my lord. The suggestion came from the judge when the settlement was offered and deliberated. The, my lord, the single
there is
judge said,
nothing-
why this
there
should
is
not be
nothing
connected
on
with.
record. How does it go before the single judge? You say suggestion came from
My lord, the writ petition, my lord, it is against. the-
petition ಅಲ್ಲಿ ಹೇಳಿದ್ರೆ ಅದು ನಮಗೆ ಹೇಗೆ ಬೈಂಡಿಂಗ್ ಆಗುತ್ತೆ?
my lord, the court suggested that this petition could be considered for alimony.
ಮೇಡಮ್ ಬರ್ಕೊಡಿ.
18, 17
Appellant's counsel has filed the above memo to connect WP number so and so to this matter.
Request, my lord, the matter could be listed for final hearing along with this writ petitions and disposed of.
In the memo, it's not even stated how those matters are connected to this appeal. In this appeal, the appellant has challenged the rejection of his petition for decree of divorce. ಅದಾದ್ಮೇಲೆ ನಿಲ್ಬೇಡಿ. From the statement of objection to the memo filed by learned counsel for respondent, it can be made out that the aforesaid petitions arise out of the execution proceedings filed by the respondent by ಎಲ್ಲಿ ಡೊಮೆಸ್ಟಿಕ್ ವೈಲೆನ್ಸ್ ಕೇಸ ಯಾವ್ದದು ಎಕ್ಸಿಕ್ಯೂಷನ್ 125
125.
5 CRP.
120.
Between the same parties.
125 proceedings. They have no bearing on this case, therefore the memo is rejected. Additional evidence. In objections ಆಯ್ತಲ್ಲ. Additional evidence has to be heard along with the main matter.
In fact, matter was listed for final hearing.
After
My lord, may I request for a date to be fixed for final hearing, my lord?
application fix ಮಾಡಿ.
5-6.
Grateful, ma'am.
Seal number 5, Rajanna BC, SPP.
Suspension. ಸೆಕೆಂಡ್ ಸೆಟ್ ಕೊಡೋದಿಲ್ವಾ?
Second set has not.
ಇಲ್ಲೇ ಕೊಡ್ತಾರೆ. ಆಯ್ತು. ಅದ್ರಲ್ಲೆಲ್ಲ ಸರಿಯಾಗಿರುತ್ತೋ ಅಂತ ಯಾರು ಚೆಕ್ ಮಾಡೋದು?
Did mistake.
Yes. Are you ready in this?
Please, madam.
Are you ready for hearing of the suspension application?
Ready.
ಹೇಳಿ ಹಾಗಿದ್ರೆ. Yes, you are ready, no?
My lord, being the aggrieved by the order of conviction passed by the learned session judge, the appellant has undergone, so appellant is convicted for the alleged offence under section 300 of IPC for imprisonment of life, pay fine of ₹5,000, my lord. So that the learned session judge has framed the charges against the accused. So the prosecution has been examined PW 1 to 23, my lord. So and got marked exhibit P1 to P30, my lord, and MO 1 to 8, my lord. So, my lord, exhibit D1, PW2, D1 has been marked, please, your honor, my lord. My lord, in this case, my lord, so there are PW 3, 4, 5, 6, and 7 are who are the eyewitness to the incidents, my lord. They turned hostile, they are not supported the case of the prosecution, my lord. PW 3, only the solitary eyewitness to the incident.
He is the daughter.
She is the daughter of the appellant, my lord.
His daughter. Who are the other two?
Other two are the neighbor witness, opposite house, so neighbor witnesses.
4 to 6, huh?
4 to 6, 4, 5, 6, and 7, my lord.
4 to 7.
Other recovering mazar witness also turned hostile, my lord. His appellant has been arrested on 23/4/2016, my lord.
Which place?
Madam?
From which place he was arrested?
My village, my lord. Had been to this spot by that time, my lord. I'm arrested.
23, 4 to
4, 2016. 9 years have been completed, my lord. In the Padina is on. Half of the sentence.
What was your, who are PW 1 and 2?
PW 1 and 2 are the relatives. Relatives.
Relatives andre ಏನು? Whether they were also eyewitnesses or?
No, they are not the eyewitness to incident. CW
He
3.
says, this
DW.
PW 1 says that PW 3 called him saying that father is assaulting, he goes there.
Yes, goes there.
ಇಲ್ಲ ಅಂತ ಹೇಳ್ತೀರಾ?
ಅಲ್ಲ ಇದರಲ್ಲಿ ಏನಾಗಿದೆ CW3 ಇದಾರಲ್ಲ ಸ್ವಾಮಿ, who is the daughter of the witness, she has intimated according to the
Relatives ಅಂತ
she has not been examined.
PW 1 is the brother ಅಲ್ಲ?
Brother swami, brother ಇದರಲ್ಲಿ
And
CW3
PW2 is mother. Who is PW2?
PW2 daughter,
data.
mother of deceased, mother of deceased,
Mother.
mother of deceased, my lord.
Yes.
My lord,
So
PW3.
soon after the incident, they go to the place and see this accused running away from the.
Yes.
So that place,
PW1.
that is the allegation.
And
Well,
this girl, this PW3 is the one witness who went and called her maternal uncle.
ಅಲ್ಲ CW3 ಅಂತಾರೆ. She has not been examined before the court.
He is not examined. One
She
of
is
the
not
court.
examined. She has been examined. She has not been examined. So the prosecution purposefully she has not been examined. She has intimated the so complaint. That witness has not been examined.
What is your defense?
My defense is not, but my lord, so I'm not committed any of the offense. So,
Correct. Your wife died an unnatural death.
so I'm the businessman. When ಊರೂರ್ಗೆ ಸಣ್ಣ ಇದನ್ನ ತಗೊಂಡು ಹೋಗ್ತಿ ಇದ್ ಮಾಡ್ತೀನಿ ಸ್ವಾಮಿ. ಸೊ ಸಣ್ಣ ವ್ಯಾಪಾರಕ್ಕೆ ಹೋಗ್ತೀನಿ ನಾನು ವ್ಯಾಪಾರಕ್ಕೆ
Correct.
ಬಂದು
Why were you falsely implicated? Why, if you were a very gentleman, why there were 4 children?
ಸೊ
Why
ಇದ್ರಲ್ಲಿ
they implicate you?
ಮೈ ಲಾರ್ಡ್ ಇದರಲ್ಲಿ ಏನಾಗಿದೆ ಸ್ವಾಮಿ ಆ ಮಗುನ ಹತ್ರ ಹೇಳಿಸ್ಬೇಕು ಅಂತ ಪರ್ಪಸ್ಫುಲಿ ದೇರ್ ಇಸ್ ಎ ಇಲಿಬಿಲ್ ಬಿಟ್ವೀನ್ ದಿ ಕಂಪ್ಲೇಂಟ್ಸ್ ಫ್ಯಾಮಿಲಿ ಅಂಡ್ ದಿ ಡಿಸೀಸ್ ಫ್ಯಾಮಿಲಿ. ಇವ್ರ ಮೇಲೆ ಇದಾಗಿದೆ ಸ್ವಾಮಿ. ಇದ್ರ ಮೇಲೆ ಇದ್ ಮಾಡ್ಕೊಂಡ್ಬಿಟ್ಟು ಇವ್ರನ್ನ ಆ ಮಗು ಕೈಲಿ ಒಂದೇ ಒಂದು ಮೈಕ್ ಅದರ್ ರೆಸ್ಟ್ ಆಫ್ ದಿ ವಿಟ್ನೆಸ್
What was that ill will?
ಇಲ್ಬಿಲ್ ಅಂದ್ರೆ ಸೈಟ್ ಇತ್ತು ಸ್ವಾಮಿ. ಅವ್ರಿಗೂ ಸೈಟ್ ಇತ್ತು. ಆ ಸೈಟಿನ ವಿಚಾರದಾಗ ಗಲಾಟೆಗೆ ನಡೀತಾ ಇತ್ತು. ಡಿಸೀಸ್ ಪರ್ಪಸ್ಫುಲಿ ತಾಯಿ ಮಗ ಸೇರಿ ಈ ಮಗುನ ಹತ್ರ ಹೇಳಿಸ್ತಾರೆ ಸ್ವಾಮಿ.
Have you stated so in your 313 statement?
313 ಹೇಳ್ಸಿಲ್ಲ ಸ್ವಾಮಿ. ಆ ಕೊರೋನಾ ಮೂಮೆಂಟ್
But
ಅಲ್ಲಿ
ಈಗ ನೀವು
ಅಲ್ಲಲ್ಲ ಕೊರೋನಾ ಮೂಮೆಂಟ್ ಅಲ್ಲಿ ಏನಾಗಿದೆ ಸ್ವಾಮಿ, ಕೊರೋನಾ ಮೂಮೆಂಟ್ ಅಲ್ಲಿ ನಂದೇನು ಏನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಹೇಳ್ಸಕ್ಕೂ ಬಿಟ್ಟಿಲ್ಲ ಸ್ವಾಮಿ.
ಇರೋ ಕೇಸ್ ಏನಿರುತ್ತೋ ಅದನ್ನ
ಆನ್ಲೈನ್ ಅಲ್ಲಿ ನನ್ಗೆ ಆಗಿರೋದು ಸ್ವಾಮಿ. ಆನ್ಲೈನ್ ಅಲ್ಲಿ ಈ ಜಡ್ಜ್ಮೆಂಟ್ ಇದನ್ನೆಲ್ಲ ಆಗಿರೋದು ಆನ್ಲೈನ್ ಅಲ್ಲೇ ಎಲ್ಲ. ಆ ಕೊರೋನಾ ಮೂಮೆಂಟ್ ಅಲ್ಲಿ ಏನ್ ಹೇಳಕ್ಕೂ ಆಗಿಲ್ಲ ಸ್ವಾಮಿ.
ಹೇಳಕ್ಕ ಕೋವಿಡ್ ಆಗಿದ್ರೆ ಟೈಮ್ ತಗೊಳ್ತಾರೆ.
ಅಲ್ಲ ಕೊರೋನಾ ಮೂಮೆಂಟ್ ಅಲ್ಲಿ ಅದು ಮೂಮೆಂಟ್ ಹಂಗಿತ್ತು ಸ್ವಾಮಿ. ಹಂಗಾಗಿ ನಂಗೆ ಪ್ರಾಬ್ಲಮ್ ಆಗಿರೋದು.
ಅಲ್ಲ ಅದು ಅಡ್ವೊಕೇಟ್ ಹೇಳ್ಕೊಟ್ಟು ಹೇಳಕ್ಕಾಗಿತ್ತು ಅಂತ ಅಲ್ಲ.
ಕೊರೋನಾ ಮೂಮೆಂಟ್ ಅಲ್ಲಿ ಆ ಮೂಮೆಂಟ್ ಅಲ್ಲಿ ಯಾರು ಓಡಾಡಂಗೂ ಇರ್ಲಿಲ್ಲ, ಏನು ಇರ್ಲಿಲ್ಲ ಸ್ವಾಮಿ.
ಮತ್ತೇನೋ ಸಾಕ್ಷಿದಾರರನ್ನು ವಿಚಾರಣೆ ಮಾಡಿ.
ಅದೇ ತಂಗಿ ಇದನ್ನ ಮಗಳನ್ನ ಮಾಡ್ತಾರೆ, ಇನ್ನೊಬ್ಬ CW3 ಮಾಡ್ತಾರೆ ಸ್ವಾಮಿ.
Correct. What is your explanation? How your wife died? Who has killed her? You suspected anybody? When you were produced before the magistrate, did you offer any explanation?
ಎಕ್ಸ್ಪ್ಲನೇಷನ್ ಕೊಡುವಾಗ ಅದೇ ಸ್ವಾಮಿ, ದಿಸ್ ಇಸ್ ದಿ ನನ್ಗೆ ಡೈರೆಕ್ಟ್ ನಾನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ರೆ ಕೋರ್ಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ರೆ ಎಕ್ಸ್ಪ್ಲನೇಷನ್ ಕೊಡ್ತಿದ್ದೆ ಸ್ವಾಮಿ. ಅಲ್ಲಿ ನನ್ಗೆ ಆನ್ಲೈನ್ ಅಲ್ಲಿ ಇದ್ ಮಾಡ್ತಾ ಇರೋದ್ರೂ ನನ್ಗೆ ಏನು ಗೊತ್ತಾಗ್ತಾ ಇರ್ಲಿಲ್ಲ. ಅಡ್ವೊಕೇಟ್ ಬಂದು ಕನ್ಸಲ್ಟ್ ಮಾಡಿ ಹೇಳ್ಕೊಡಕ್ಕೂ ಆಗ್ತಾ ಇರ್ಲಿಲ್ಲ.
17 ಸೆಷನ್ಸ್ ಕೇಸ್ ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ ಪ್ರೊಡಕ್ಷನ್ ಅದಕ್ಕಿಂತ ಮೊದಲಿರುತ್ತೆ.
ಅಲ್ಲ ಟ್ರಯಲ್ ಆಗಿದ್ದು, ಟ್ರಯಲ್ ಮೂಮೆಂಟ್ ಕೊರೋನಾ ಮೂಮೆಂಟ್ ಆಗಿದೆ ಸ್ವಾಮಿ. ನಾನು ಡಿಫೆನ್ಸ್ ಮಾಡ್ಬೇಕು ಅನ್ನೋ ಟೈಮ್ ಅಲ್ಲಿ.
Not a murder of a stranger. It is the murder of your wife.
ಪ್ಲೀಸ್
Right.
ಹೌದು.
You were produced. You say that you were falsely implicated.
ಅದ್ರಲ್ಲಿ
You were
at the
produced.
time of judgment there is a
When you
corona.
were produced before the magistrate first time. What did you explain?
ಆಗ ನನ್ಗೆ
Isn't it?
ಅದೆಷ್ಟೆಲ್ಲ ನಾಲೆಡ್ಜ್ ಇರಲ್ಲ ಸ್ವಾಮಿ. ಜಡ್ಜ್ ಮುಂದೆ ಇದ್ ಮಾಡುವಾಗ ಎಷ್ಟೆಲ್ಲ ಇದಿರಲ್ಲ ಸ್ವಾಮಿ. ಕೇಸಲ್ಲಿ ಎಂಡ್ ಆಫ್ ದಿ ಮೂಮೆಂಟ್ ಅಲ್ಲಿ ನನ್ಗೆ
You were not granted bail during the trial. Trial ಅಲ್ಲಿ ಇರ್ಬೇಕಾದ್ರೂ bail ಕೊಟ್ಟಿಲ್ಲ. Probably it was
ಅದ ನಾನು
rejected.
ಮೂವೇ ಮಾಡಿಲ್ಲ ಸ್ವಾಮಿ. ಮೂವ್ ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ ನನ್ಗೆ ಯಾರು ನೋಬಡಿ ವಾಸ್ ದೇರ್ ಅಟ್ ದ ಟೈಮ್ ಆಫ್ ದಿ. ಸೊ ಇದರಲ್ಲಿ ಮೂವ್ ಮಾಡಿರೋದು ಯಾರು ಇಲ್ಲ ಸ್ವಾಮಿ. ಮಕ್ಕಳದ್ದು ಬೈ ದಟ್ ಟೈಮ್ ಆಲ್ ದಿ ಚಿಲ್ಡ್ರನ್ಸ್ ಆರ್
ಯಾರು ಇಲ್ಲ ಅಂದ್ರೆ ಲೀಗಲ್ ಸರ್ವಿಸ್ ಅಥಾರಿಟಿ.
ಅಲ್ಲ ಚಿಕ್ಕ ಮಕ್ಕಳು ಸ್ವಾಮಿ. ಚಿಕ್ಕ ಮಕ್ಕಳು ಇರೋದ್ರಿಂದ ಯಾರು ಇದ್ ಮಾಡಿಲ್ಲ ಸ್ವಾಮಿ. ಹಂಗಾಗಿ ಆಗ 9 ವರ್ಷ ಕಳೆದಿದ್ದೀನಿ ಆಗ್ಲೇ. Half of the sentence has been.
ಆರೋಪಿ ಮಗಳು ಪುಷ್ಪ ಅನ್ನೋ. It's not that good. ಪುಷ್ಪ ಕಲ್ಲಿನಿಂದ ಜಜ್ಜಿ ಮಗುವನ್ನು ಎತ್ತಿಕೊಂಡು ಓಡಿ ಹೋಗುತ್ತಿದ್ದನು. Is it correct? They had not moved during the trial?
Lords, in fact, Lords, PW3 is the daughter of the deceased and eyewitness to the incident. She has supported the case of prosecution. Bloodstained clothes were there, my lords, which were seized at the instance of accused, lords, and stone. And clothes of deceased, they were subjected to FSL.
PW3, DW1 is also
You said
major.
PW3 has turned hostile. Hagilvalla.
No, my lords, it is, she supported the case of prosecution.
PW3 did not support.
Paragraph 21 of the judgment, my lords, in page 27, running page 27.
Her sister went to the house of her grand.
DW1 has, my lords, in fact,
She is
daughter,
DW1 is the daughter of the,
another daughter of deceased, she has been examined. That evidence has been discussed by the trial court.
21. She is eyewitness. She has supported her. Support ಮಾಡಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರು ನಮ್ಗೆ ಈಗ ಆರ್ಗ್ಯುಮೆಂಟ್ ಹೇಳ್ಬೇಕಾದ್ರೆ ಅವ್ರು ಹೇಳಿದ್ರಲ್ಲ ಇವರು PW3 to 7 did not support.
21 ಅಲ್ಲಿ, how is that you are saying?
Swami?
No, you said PW3 did not support. She has supported.
PW3 is the, CW3.
PWC.
CW3.
Correct. One of the daughter,
She is,
her presence at the house is natural because she is the inmate of the house.
ಅಲ್ಲಿ ತುಂಬಾ ಚಿಕ್ಕ ಹುಡುಗಿ ಸ್ವಾಮಿ. CW3 ಆಕೆ ಇದಾಳಲ್ಲ, ಆಕೆ ಹೋಗಿ ಅವ್ರ ಮಾವನ್ಗೆ ಹೇಳೋದು ಅಂತ.
ಓದಿತ್ತಲ್ಲ ನಿಮ್ಮ ಮಗಳನ್ನ ಹಾಗಿದ್ರೆ
CW3 ದೊಡ್ಡ ಹುಡುಗಿನ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿಲ್ಲ ಸ್ವಾಮಿ, ಚಿಕ್ಕ ಹುಡುಗಿ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿದ್ರು. ದೊಡ್ಡ ಹುಡುಗಿ ಏನಿಲ್ಲ ಆಕೆ.
She was also charge sheet witness.
She was also charge sheet witness. She has in CW3 has intimated the complaint. She has not been examined.
CW3 Pushpalata given. What was her age? 15 years.
12 years, my lords.
ಅಲ್ಲಿ charge sheet ಅಲ್ಲಿ 15 years ಅಂತ.
At the time of incident, my lords, 12 years.
CW 15 years. Probably ಅಷ್ಟೊತ್ತಿಗೆ ಮದುವೆ ಆಗೋ ಎಲ್ಲೋ ಬೇರೆ ಕಡೆ ಇರ್ತಾರೆ, ಮಾಡಿರ್ಲಿಕ್ಕಿಲ್ಲ ಎಕ್ಸಾಮಿನೇಷನ್, ಅಥವಾ this girl has supported ಅದಕ್ಕೆ ಮಾಡಿರ್ಲಿಕ್ಕಿಲ್ಲ. PW3 she was shown as CW4. Yes, you wanted to say something?
My lords, blood group is also there, my lords, blood stained clothes of accused have been seized. And stone has been seized, my lords, since PW3 daughter of the deceased has supported the case of prosecution. And FSL report, my lords, goes to show that, my lords, prosecution was able
Recovery
to.
has been.
Other than this eyewitnesses evidence, there was any other evidence, any other circumstance?
No,
FSL
no.
report, my lords.
FSL.
Yes, my lords. B group of blood, my lords.
ಯಾರು witness recovery not proved. Eyewitness have not been examined, my lord.
Memo, second set of I1 office in 25, office objections should come down. Orders and I1 office in 25, heard both sides. By the interim judgment and order, the appellant is convicted for the offense punishable under section 300C and sentenced. Sentenced to life imprisonment and fine of this 5,000. The charge against the appellant was that charge against the appellant and admittedly, relationship is not in dispute.
Not
The
disputed.
appellant was married to victim. What was her name? What was the name of the victim?
Lakshmi Devi, my lords.
Couple. I have 4 children. It is alleged that the appellant, it's alleged, the charge against the appellant was that he used to suspect the fidelity of the victim and subject her to physical and mental violence. Due to such in that background on 22/4/2016, in his house, 22/4/2016 at 10 PM, in his house, he picked up a quarrel with the victim, suspecting her fidelity and crushed head and crushed her head with MO4, the stone, and committed her murder. Next paragraph. The appellant did not have the benefit of bail during trial. The case was based on the eyewitnesses, evidence of eyewitnesses. PW3, none else but the daughter of the appellant, come eyewitness, has supported the prosecution version in the trial. Considering the gravity of the offense and the material on record, it's not a fit case to grant suspension of sentence, hence application is rejected. Admit the paper books model cash.
Maybe posted for final hearing place.
Paper book ಎಷ್ಟು ದಿವಸ ಮಾಡಬೇಕು ಅಂತ ಆರ್ಡರ್ ಮಾಡಿದ್ರು 3/3/2023 ನಾ prepare the paper books within 2 weeks ಅಂತ ಮಾಡಿದ್ರೆ registration prepare the paper books within 4 weeks without any delay within 4 weeks positively unless
Completed is
Stop.
9 years has been completed. 9 years completed.
ಲೈಫ್ ಇಂಪ್ರಿಸನ್ಮೆಂಟ್ ಅಲ್ಲ ಇಲ್ಲಿ 50% ಸೆಂಟೆನ್ಸ್ ಕ್ವಶನ್ ಬರೋದಿಲ್ಲ ಅಂಡ್ ಇಟ್ ಅಪಿಯರ್ಸ್ ನೀವೇನೆ 2022 ದಿಂದ ಇಲ್ಲಿವರೆಗೂ ಮಾಡಿಲ್ಲ ಅಟೆಂಪ್ಟ್. When did you comply the office of sections?
Earlier it came to you dismissed as not pressed
Hello,
notes, earlier
I
application.
withdraw the petition earlier, I filed bail petition.
Who is
I
responsible?
withdraw the petition, please.
Appeal
Appeal.
36. 36. Seal number 6, this is Shivannegowda, Nayak Krishna Venkatraman.
I appear for response.
Officers,
Second
write the
set.
objects. One set of appeal, the paper publication, the paper was not laid. Please get it ready, my lord, I will file it today.
ಕೊಟ್ಬಿಡಿ ಇದ್ರೆ
Index ಹಾಕಿಲ್ಲ ಅದಕ್ಕೋಸ್ಕರ. Memo mail ಇದೆ. Memo ಇದೆ.
you file it during the course of the day.
Please.
The appellant's counsel is permitted to comply. Produce the paper during the course of the day. ಯಾವ ಪೇಪರ್ ಅಂತ ತಗೊಳಕ್ ಆರ್ಡರ್ ಆಗಿತ್ತು?
Samyukta Karnataka. Page number 5 it is published.
The paper publication
Mati Lata,
taken on record. There is. Respondent number ಎಷ್ಟು?
4.
She is claimant,
No, my lord, owner of the vehicle.
owner of the vehicle.
Owner
Of the vehicle.
Service on respond number 4 is held sufficient. She is called out absent. She is absent. ಅಲ್ಲೇನು contest ಮಾಡಿದ್ರ ಅಲ್ಲಿ ಯಾರೋ ಇಡೋಕಿಟ್ ಅಪೀರ್ ಆಗಿ ಇದರಲ್ಲಿ what next is
I have
this?
filed the application, my lord. Application is pending, my lord.
For withdrawal.
It- Withdrawal of
Posted for
amount, my lord.
final hearing on any day, my lord.
ಎಲ್ಲ 2022 ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಅಂತೀರಿ. What is the defense here? Appeal is on what ground?
Passenger
My lord, only
vehicle,
ನಿಮಿಷ.
passenger in a goods vehicle.
Authorized passenger ಅಂತಾನ?
Risk is not covered under the policy.
gratuitous passenger, only contention that my lord insurance company.
ಸ್ವರ್ಣ ಸಿಂಗ್ ಕೇಸ್ ಅದೆಲ್ಲ ಕವರ್ ಆಗೋದಿಲ್ಲ.
It's not covered under that.
My lord,
Sure.
rule 100, my lord, it is covered by the judgment, my lord.
He is an employee, if he is an.
Karnataka
employee,
Motor
my lord, he is
Vehicle Act, my lord.
Covered, but here is the case, my lord, he is not an employee.
If there is any judgment, you bring and show us.
Well,
We
but-
were asking, we will release the amount, all it. He says his only defense is that he was an unauthorized
Yes, ma'am.
passenger. So he is not covered under Mukund Devangan's case ಅಂತ ಹೇಳ್ತಾರೆ ಅಥವಾ ಸ್ವರ್ಣ ಸಿಂಗ್ ಕೇಸ್ ಅಂತ. ಬೇರೆ ಇನ್ನೇನಾದ್ರೂ ಜಡ್ಜ್ಮೆಂಟ್ ಇದ್ರೆ ತಂದು ತೋರಿಸಿ ಅಥವಾ ಆ ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಎಲ್ಲಾದ್ರೂ these kinds of cases are also covered ಅಂದ್ರೆ ತೋರಿಸಿ. Have you gone through the judgment?
My lord, not forthcoming, my lord, kindly day after tomorrow, my lord.
Any day.
Response 1 to 3. Seek time to submit on IA number 1023-24. Next one.
Public.
17-4.
Please.
Seal number 7, Nagaya,
Please, brother.
Crew of the vehicle. The crew of the vehicle. Yeah, different reasons. You should be treated as.
Seven.
seal number 7,
Please.
That's- This is a case where, my lords, fraud has been committed by the respondent against the court, my lords, where the decree of divorce has been taken by impersonating the appellant herein. Appellant is the legally wedded wife, my lords. They got married in the year 2015, my lords. But after which, what happens? There was some
This is from Bangalore court only. So when did you come to know about this?
but I got to know about this in the year 2019, my lords.
Now he's served unrepresented.
My lords,
He's served unrepresented here.
please, my lords. He has not been represented. He has been placed as expert.
Police. Police report was called by the court. Police report ಅಂತ ಬಂದಿದೆಯಲ್ಲ
ಅದು ಏನಕ್ಕೆ ಅಂದ್ರೆ, my lords, I filed a PCR.
police.
Because when I got to know about the fraud that has been committed, where the divorce decree has been taken without my signature, that is the wife's signature.
No, on which order this report was submitted? Court had passed an order.
No, court has not passed any order, my lords.
But ಅವರೇ
During the
consider-
time of investigation, they want to verify, they want to send the signature to FSL to verify whether the signature that has been made by Sangeeta is original or not.
ಇಡುವಂತೆ score ಇದೆ. Oh, ಇದ್ರ copies ಬೇಕಂತ. They seek original documents.
Please, my lords.
Yes, SPP ಅವರೆಲ್ಲ. ಈಗ ಇವರು ಇಂಪರ್ಸನೇಟ್ ಮಾಡಿದ್ರೆ ಸಿಗ್ನೇಚರ್ ಅದಕ್ಕೆ FSL ಕಳ್ಸೋದಕ್ಕೆ ಒರಿಜಿನಲ್ ಕಳಿಸ್ತಾರೆ. We can hear this matter and then send the file. Otherwise, now if these records go, will not be.
I'm
able
ready,
to
my
hear.
lords.
Very
I'm
good.
ready.
When did you come to know about this?
But she got to know when she came back to Bangalore on 22/6/2023, my lords.
Where she resides?
She resides in Sirsi, my lords.
Mhm.
Let me give a brief of
Yes.
as to what has happened in this case. Well, they both got married on 11/6/2015 at Sirsi, my lords. After which she was brought back to Bangalore to her matrimonial house. But in the meantime, what happens? She was being chased out because of some problem that has happened between husband and wife. They both fought and she was chased out. She went back to Sirsi in the year 2016. And the husband files a case for divorce in Bangalore on 26/10/2016, which later got transferred to Sirsi. But in this case, the matter was compromised between husband and wife.
26 ಯಾವಾಗದ?
26/10/2016.
That was
That was the first decree. That was the first divorce petition, my lords.
MC number
Please.
4675/2016. Yes, you have stated. 4765 you have stated in your
Please, my lords.
synopsis. So that was withdrawn.
That is the first petition, my lords, that was filed by the husband,
Hmm.
which later got transferred to Sirsi, and the matter was compromised. And again, she was brought back to her matrimonial house.
What was the compromise?
What's that? She will reside with her
To
husband.
live together.
Live together, anta. It was again, she was brought back in the year 2019, on July 2019.
In Sirsi court.
16 alagi,
ಅಲ್ಲ,
it
he
was
filed that in Sirsi court.
ಇಲ್ಲ ಬೆಂಗಳೂರಲ್ಲಿ ಫೈಲ್ ಮಾಡಿದ್ರು. It was transferred to Sirsi later.
It was transferred to.
Please. Ali, the matter was compromised. She
ಅಲ್ಲಿ
was,
spring ಏನಾಗಿತ್ತು?
it is stated in the synopsis, my lords.
Synopsis ಅಲ್ಲಿ MC number 4765/2016 family court ಅಂತ ಹೇಳಿದೀರಾ? 6183. Segment. ಇದು ಬಡಿಯಲ್ಲಿ.
It's at page number 6, my lords. Page number 6 of the appeal. Para number 6. That is MC number 4765/2016. Yes. Which was later renumbered as 97/2017.
Interim stay ಇತ್ತಾ ಇಲ್ಲಿ? Interim stay was granted?
ಇಲ್ಲ.
You are staying with him? Where were you staying when the second petition was filed?
I was in Sirsi, my lords. I was not in Bangalore.
And where the compromise terms?
What?
Where's the compromise petition?
Records-
Order the compromise elite.
Please. But that has not been produced, my lords. The compromise petition was
What are the
not been
terms of the
produced.
compromise?
Return borrower notice.
Terms of the compromise elite.
That she will reside with her husband. He'll take her back.
Again, she did not come back here.
She came back to Bangalore again, and again she was chased out of the house. She went back to Sirsi again. At that time, my lords, somebody has represented her. Her signature has been forged and decree has been taken. Upon which I filed this MFA, my lords.
Where are the disputed signatures?
Once, please, it's at the TCS have been.
Mitra copy diya.
Please, once.
Put it.
Imitate ಮಾಡ್ಬೋದು ನಮಗೆ ಏನಿದೆ ಅನ್ನೋ ಪ್ರಶ್ನೆ. But because we do this in the because the criminal verifies in the
This is the forged signature, my lords. Lordship may compare that with the wakalat that has been filed.
ಬರಬೇಕಲ್ಲ One day either we can send it to the direction that it should be sent back to us. Soon after the public is over. ಅಲ್ಲಿ ಹೋಗಿ ಎಂಟ್ರೆನ್ಸ್ ಇರುತ್ತೆ ಹೋಗಿ ಅಂದ್ರೆ ಫೋಟೋ ಇಲ್ಲ ಅಂತಂದ್ರೆ ಇಲ್ಲ ನೆಕ್ಸ್ಟ್ ಕಂಟೆನ್ಷನ್ಸ್ ಇದಾವೆ ಕೋರ್ಟ್ ಅದೆಲ್ಲ ಅದ್ರ ಮೇಲೆ ಹೋಗಿ ಎಲ್ಲರಿಗೂ ಬರ್ಬೇಕು ಯಾಕಂದ್ರೆ ಇವ್ರಿಗೆ
Should not expire. So we need to give a reason to come up with this established for you. That is not going to be the reason. What the material?
We have to relegate him to that court. Go and prove it there and because he has not appeared here. He will consider, but condition that should be sent back to us only. But if it take its own name. ನೋಡಿ ಅವ್ರು ಯಾರು ಇಲ್ವೇ ಇಲ್ಲ ಹಾಕಿ SPPನೂ ಇಲ್ಲ ಯಾರು ಇಲ್ಲ. We'll get the SPP.
That's, please.
Even proceedings ನಮಗೇನು ಬೈಂಡಿಂಗ್ ಆಗೋದಿಲ್ಲ. Suppose SPP ಆಲ್ಸೋ ಇಲ್ಲ.
That's 2 seconds. Yes, some will believe our
ಈ ಕ್ರಿಮಿನಲ್ ಕೋರ್ಟ್ ನಲ್ಲಿ ಫೈಲಿಂಗ್ ಬರೋವರೆಗೂ ನಾವು now the police have called for the records. We were thinking the records, if they go once, it will take some time.
Please.
Whether to send them or interim stay will be there.
Please.
You have to wait for a longer time. They have children.
That's, there are no children. But she's aged 35 years. She's neither able to go back to her matrimonial house or not she is able to remarry again, my lords.
Where is she now?
She's in Sirsi, my lords.
What she is doing and he is doing.
My lords?
what she is doing and what he is doing.
She's doing nothing, my lord.
What
She's
is
at
the
her,
qualification of the couple?
she has completed her degree, I guess, my lord. I'm not sure.
What he is doing, husband?
He's into some real estate business, my lord. And also I have one more submission, my lord. After the summons has been served from this honorable court, he has remarried. Even before that, he has remarried. And after summons has been served from this honorable court, he has transferred all the property to the alleged second wife. Here is the gift deed, my lord. This is the gift deed which has been transferred in the name of second wife.
Why did you not file any application for at least Ashtadre they would have come back because recovery had to come in. You have not filed application for interim money here.
Malats, I'm supposed to file, Malats, but also at the same time, I suggested my client to file a suit for declaration to cancel all these documents. But they are poor people, Malats, they can't afford the court
Right,
fees.
that is a different
Please.
proceedings. This is not matrimonial, their status. So now though he is served, he is not coming forward.
Please.
If there is some such orders, at least you said she is not able to sustain herself.
Please, Malats.
ಹಾಗಿದ್ರೆ ಹಾಕ್ಕೋಬೇಕಿತ್ತು
But what I thought was, Malats, after the matter gets reverted back to the family court.
But reversion now he has not appeared.
Please.
Criminal case it's still pending.
Please.
Then we cannot record evidence whether there was any impersonation or not.
Please, Malats. I'll take your lordship's suggestion. I'll file the application for maintenance. Also, Malats, FIR has been lodged against him. His bail has been rejected in the Sessions Court as well as in the High Court.
Now he is
He has not been arrested, Malats.
Anticipatory
respondent-
bail is rejected.
Malats, yes, Malats.
Anticipatory bail.
Please. I doubt, Malats, the police people have been influenced by him.
He's from Bangalore. What is this?
Oops, shit.
This was on 29/8/2024.
Summons has been served to him on 5/6/2024. This has been executed on 29/8/2024.
What is the property?
It's one is commercial property and one is rented house.
No, situated in which place? Situated in which place? Bangalore or in their hometown?
Bangalore alla irodu. One is in
Renapalli village, Kerpuram.
Subbayan village ಅಂತಿದೆ. Site number 16.
Heard the appellant's counsel. Heard the appellant's counsel. Challenging the decree of dissolution of marriage. Granted by the trial court, wife has preferred this appeal. Depending that, before the trial court, she was impersonated. Before that, the respondent has managed to secure a decree by impersonating her before the trial court. It is submitted that regarding impersonation on the complaint of the appellant. CC crime number eಷ್ಟದು?
That's a crime number.
MFA.
It's the PCR, man. It's PCR number 3547 of 24.
Mediation again.
These photos are not your photos, the one which are.
Exhibit B2 3 ಅಲ್ಲಿ ಯಾರಿರೋದು?
ಮದುವೆ photograph
What
ನಿಮ್ದು.
people exhibit
ಮದುವೆ photographs ನಿಮ್ದೇನೆ.
Mother photographs.
Mediation.
That is Sangeeta. And
ಬೆಂಗಳೂರಲ್ಲಿ.
mediation was has taken place in Bangalore.
Not gone for mediation.
ಇಲ್ಲ mediation
Other
ನಾನು
person
ಬಂದಿಲ್ಲ.
gone.
No, madam.
ಅವ್ರು ಹೇಳೋದು. FIR crime number ಆಗಿದೆ.
But this is the copy of the FIR.
Compared. on the basis of her complaint.
FIR copy.
FIR in crime number 235/2024. ಅಲ್ಲ ಮ್ಯಾರೇಜ್ ಈ ಮ್ಯಾರೇಜ್ ಸರ್ಟಿಫಿಕೇಟ್
ಯಾರ್ದು ಫೋಟೋಗ್ರಾಫರ್ ಯಾರದು ಮ್ಯಾರೇಜ್
So that is Sangeeta and respondent.
ಯಾರದು who the other person can be so similar.
ಪಾರ್ಟಿ ಪ್ಲೇಸ್ ಗೊತ್ತಾಗೋದಿಲ್ಲ ಅಂತ
So casual.
We do not know about this side or that side. ಮೀಡಿಯೇಷನ್ ಸೆಂಟರ್ಗೆ ಹೋದಾಗ ಆಧಾರ್ ಕಾರ್ಡ್ ಎಲ್ಲ ಕೇಳೋದಿಲ್ವಾ?
That was during the time of COVID, Malats. I'm not sure whether they have been asked for the other card or not.
ಎವಿಡೆನ್ಸ್ ಎಲ್ಲ ಯಾವಾಗ ರೆಕಾರ್ಡ್ ಆಗಿದೆ? ಕೋವಿಡ್ ಪೀರಿಯಡ್ ಅಲ್ಲಿ ಆಗಿದೆಯಾ?
Please, Malats. Malats, once after she has filed her affidavit, Malats, she has remained absent. The alleged person, she has remained absent. She has not gone for. ಬಂದೇ ಇಲ್ಲ ಅವರು.
ಕಾನ್ ಫಾರ್ ಮೀಡಿಯೇಷನ್ ಅಂತ ಇದೆ. ಮೀಡಿಯೇಷನ್ ಅಲ್ಲಿ ಇದು ತಗೊಳ್ತಾರ ಇಲ್ವಾ ಅಂತ ಆಧಾರ್ ಕಾರ್ಡ್ ತಗೊಂಡ್ರೆ ಅವ್ರ ಮುಖ ಗೊತ್ತಾಗುತ್ತೆ.
Probably.
235/2024 of Wilson Garden Police Station is registered and investigation is going on. The investigating officer in the said case has submitted the requisition dated 11/3/2025. ಅವ್ರು ಯಾರು ಇಲ್ಲಿ ಕೋರ್ಟ್ ಮುಂದೆ ಬರೋದೇ ಇಲ್ವಲ್ರಿ, ಬರೀ ಕರೆಸ್ಕೊಳ್ತಾರೆ. SPP ಇಲ್ಲ, SPP ಅವ್ರು ಸಿಗೋದಿಲ್ಲ ನೋಡಿ. ಗವರ್ಮೆಂಟ್ ಯಾಕಂದ್ರೆ ನೀವು ಇಂಪರ್ಸೋನೇಷನ್ ಅಂತೀರಾ, ಈ ಲೆಟರ್ ಏನು? To send the affidavit and the following records ಅಂತ ಒಂದು 5 records ಹಾಕೊಂಡ್ಬಿಟ್ಟಿದ್ದಾರೆ. affidavit of affidavit ಇಲ್ಲಿ ಹಾಕಿರೋದ ಅಲ್ಲಿ ಫ್ಯಾಮಿಲಿ ಕೋರ್ಟ್ ಅಲ್ಲಿ?
Family court ಅಲ್ಲ.
Affidavit filed by affidavit purportedly filed by the present appellant before the family court in lieu of chief examination. Wakalat, her alleged wakalat number 2. 3, her copy application. 4, third party affidavit ಇದಕ್ಕೆ documents. 4, third party affidavit filed along with the copy application. Copy application. And ಇನ್ನೊಂದೇನು 10/8/23 ಯಾವ ಅಫಿಡವಿಟ್ ಕೊಟ್ಟಿದ್ದೀರಾ? ರೆಕಾರ್ಡ್ ಅಲ್ಲಿ ಇದೆ 10/8/2023. First affidavit we understood that it is chief examination affidavit. 28/2023 dispose on 2023 dispose ಆದ್ಮೇಲೆ ಏನೋ 28 ಒಂದು ಫಸ್ಟ್ ಅಫಿಡವಿಟ್ ಹಾಕಿದ್ದು ಚೀಫ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಅದು. ಅದೇನಿರುತ್ತಂದ್ರೆ 28/2020 ಡೇಟೆಡ್ ಅದಿರ್ಬೋದು, ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಹಾಕಿದ್ರೆ ಹಾಕಿರ್ಬೋದು. ಚೀಫ್ ಎಕ್ಸಾಮಿನೇಷನ್
application also.
copy application.
Paper application ತಗೊಂಡಿದ್ದಾರೆ.
ಇಲ್ಲ ಅವ್ರದ್ದಾಯ್ತು. She has filed.
Paper application.
Advocate engage ಮಾಡ್ಕೊಳ್ಳೋದಕ್ಕೆ ಹಂಗಂದ್ರೆ ಬರ್ಕೊಂಡ್ಬಿಟ್ಟಿದ್ವಿ, ಡೇಟೇ ಬರ್ಕೊಳ್ತೀನಿ. ಅಫಿಡವಿಟ್ ಡೇಟೆಡ್ 28/2020. ಇದು 28
8
28/2020, any affidavit is filed by you? First affidavit ಯಾಕೆ ಕೊಡ್ತಾರೆ ಅಂದ್ರೆ ಇದು advocate engage ಮಾಡ್ಕೊಳ್ಳೋದಕ್ಕೆ. Submit ಮಾಡಿರೋದು. Date correct ಇಲ್ವಾ ಹಾಗಾದ್ರೆ? 28/2020. ಆಮೇಲೆ 13/7/2023, third, that is after post disposal. ಇನ್ನೊಂದು 10/8/2020. ಇದ್ರೆ ಕಳಿಸಿ ಅಂತ ನೋಡಿ ವೆರಿಫೈ ಅಂತ ಮಾಡಿ ಬರ್ಕೊಂಡ್ರೆ. ಥರ್ಡ್ ಡಾಕ್ಯುಮೆಂಟ್ ಏನಾದ್ರು ಅದು ಅಫಿಡವಿಟ್ ಬರ್ಕೊಳ್ಳುವಾಗ ಡೇಟ್ ಬರ್ಕೊಂಡಿದೆ. ಅಫಿಡವಿಟ್ ಫಸ್ಟ್ ಒನ್ ಡೇಟೆಡ್ 10/8/2023, ಸೆಕೆಂಡ್ ಒನ್ ವಕಾಲತ್ ಡೇಟೆಡ್ 28/2020, then fourth one party affidavit dated 13/7/2023, fifth one party affidavit affidavit filed by the appellant on 10/8/2023 for the purpose of sending them to forensic science laboratory for investigation in the case. Registration and verify if those documents are found in the records. Send them to the IO. IO should personally appear and collect the records. Soon after the purpose is over, the IO should resubmit those records. List on. Once every barakkide. We have dictated our SPP or one math.
Let there be a time fixed for us for this. Let there be a time frame fixed for this. Because
the date here, and the interim stay was granted absolutely.
there is no interim stay, my lords, because by the time
Why did you not seek interim stay then?
because by the time we filed it, it was already remarried. Your lordship has said that in
That is all sufficient for that. But other consequences, sir? If he remarries, then
the matter came up before your lordships itself. Your lordship said, "Parvagila bidi or remarry ಆಗಿದ್ರಲ್ಲ ಇನ್ನೇನು interim stay ಬೇಡ ಅಂತ ಹೇಳಿದ್ರು."
ಹಾಕೊಂಡಿದ್ದೀರಾ ಅಪ್ಲಿಕೇಶನ್?
ಹಾಕಿದೀವಿ ಇದ್ರಲ್ಲಿ ಹಾಕಿದೀವಿ ಅಪ್ಲಿಕೇಶನ್.
ಇದೆ ಅಪ್ಲಿಕೇಶನ್ A number 5/2/2020. ನಾವೇ ಹಾಗ್ಯಾಕೆ ಹೇಳ್ತೀವಿ? Why are you putting us out?
ಇಲ್ಲ I'm sorry. Your lordship suggested that.
Interim stay of the interim judgment will decree till further orders. 5/2/2023 disposed of accordingly. List on. After vacation 4 weeks ಅಲ್ಲಿ ಬೇಕಾಗುತ್ತೆ ಟೈಮ್.
16/4.
ಅದು ಒಂದು ಅವ್ರು ಯಾರು
ಅಲ್ಲ, 16/6.
16/6. ಇದು ಜಸ್ಟ್ ವಿ ಹ್ಯಾವ್ ಡಿಕ್ಟೇಟೆಡ್. SPP ಅವ್ರನ್ನ ಕರೆಸಿ ಅವ್ರನ್ನ ಇಲ್ಲಿ ಬಂದು ತಗೊಂಡೋಗ್ಲಿ ರೆಕಾರ್ಡ್ಸ್ ಅನ್ನ.
Seal number 8 adjourned. Seal number 9 Shankar Narayan Bhatt, Harish HV.
ಕೊಡಿ ಅವ್ರಿಗೆ ರೆಕಾರ್ಡ್ಸ್. ಇದು ತಗೊಳ್ರಿ, ನಿಮ್ಮ ರೆಕಾರ್ಡ್ಸ್ ತಗೊಳ್ಳಿ.
Adjourned ಬೆಳಗ್ಗೆ ತಗೊಂಡು.
Serial number 9. Lord, 20,000 to the wife and 10,000 to the child, and 5,000 fine was imposed on me. Lord, 35,000 I am paid.
Not
I mean cost on me. 35,000 demand draft I am producing today, Lord. Can I?
Yes, yes. ತಗೊಳ್ಳಿ, ಇದೇ ನೋಡ್ಕೊಳ್ಳಿ ಕರೆಕ್ಟ್ ಆಗಿ.
And
ಕೊಡಿ ಡಿ ಅಂದ್ರೆ ನಂಬರ್ ಎಲ್ಲ ರೆಕಾರ್ಡ್ ಮಾಡಿ. Affidavit of assets and liabilities.
this I filed it on Saturday, Lordships. Before the registry, I have a acknowledgement, Lordships.
ಎರಡು ಡಿಡಿನ? Why 2 DD?
He has taken it some. He has taken it in her name only. 20,000 for her, 10,000 for the child, and 5,000 cost imposed.
ಅಂದ್ರೆ ಅಷ್ಟೇ. It was ordered maintenance ಇಲ್ಲೇ award ಆಗಿತ್ತು.
My lord, interim maintenance of 20,000 till next date. It was ordered for wife and 10,000 for the child.
How date ಹೇಳಿ? 14/3/2025.
I produced documents to show that she is working.
No. When this order was passed, you
Order
said
was
certain
passed,
amount. Is there any order passed like that?
Yes, ma'am.
Date ಹೇಳಿ ಆಗಿದ್ರೆ order.
We hearings report. Sorry.
24.
ಕೊಡ್ತಾ ಇದ್ರು ಅಂತ ಕಟಿಂಗ್ ಮಾಡಿ ಕೇಳಿದೆ ಅಷ್ಟೇ.
ಟ್ರಯಲ್ ಕೋರ್ಟಲ್ಲಿ ಟಿಲ್ ಡಿಸ್ಪೋಸಲ್ ಅಂತ ಆರ್ಡರ್ ಆಗಿತ್ತು.
20,000 rupees.
Lakhs, 20,000 rupees for the wife. And she had not.
Continue to pay 20,000 from the current month onwards, subject to further orders.
Oh.
20,000 is
For the wife.
Wife.
And 10,000 for the child.
30,000. This includes
This includes 20 plus 10, 30 and 5,000 cost also.
how much is it?
Cost last night will not.
Yeah, fast ಆಯ್ತದೆ ಯಾವ month ಅದು order ಆಗಿಲ್ಲ 312.
My lord, I'll file memo of calculation. Till date it is completed.
They paid earlier.
I paid before the court only I paid.
ಯಾವಾಗ previously?
Previous day also I paid.
DD Xerox copy.
DD.
Is it due of
1,30,000?
ಅದು if it is due, you can file a recovery petition there.
Please.
We'll give you that liberty.
ಕೊಡ್ತೀನಿ ಮೇಡಮ್.
Submits two demand drafts for rupees. Demand draft for rupees 20,000 drawn on ಎರಡು ಕೆನರಾ ಬ್ಯಾಂಕ್ ಏನಾ
35,000
plus 15,000 drawn on 20,000 and 50,000 drawn on Canara Bank Bengaluru. ಯಾವ ಬ್ರಾಂಚ್ ಇದು ಕೆನರಾ ಬ್ಯಾಂಕ್?
My lords, may I make
Respondent acknowledges the same. Yes.
one submission, my lords?
Hey.
My lords, the respondents have filed a new set of assets and liabilities, my lord. My lord, may kindly grant 2 weeks time to file a rejoinder, my
Yes.
lords. Yes, my lords.
2 weeks ಯಾಕೆ ಅದರಲ್ಲಿ?
Rejoinder, my lords.
Not disclosing the income, complete income. That's the reason.
When did you file?
10:30.
When you filed your affidavit of assets and liabilities?
Yeah, fine.
ಯಾವಾಗ ಮಾಡಿದ್ರಿ?
That is,
Whether you have stated all the things he possess?
Produced the statement itself I have produced, lordships. Salary certificate I have produced.
Correct.
Latest.
ಅಫಿಡವಿಟ್ ಹಾಕುವಾಗ ಅವ್ರದ್ದು ಏನಿದೆಯೋ ಎಲ್ಲ ಹೇಳಿರ್ತೀರಿ. ಅವ್ರು ಹಾಕಿದ್ಮೇಲೆ ಮತ್ತೊಂದು ರಿಸೈನ್ ಹಾಕೋದೇನು?
For the objection what they have filed, to that objection, we need to file a rejoinder. Kindly grant one.
Objection or affidavit?
my lords,
They have filed objection also.
And their
Objections to
maintenance
it.
application,
When did they file?
maintenance application, my lord,
Did you file objection?
last but before date only I filed objection.
See, this is not a recovery court. ನೀವು ಸುಮ್ನೆ ಅದಕ್ಕೆ ಟೈಮ್ ತಗೊಳ್ತಾ ಈ ಕಡೆಯವರು ಆ ಕಡೆಯವರು ಬರೀ ಇಲ್ಲೇ ಸೆಟಲ್ ಮಾಡ್ತಿರೋದಲ್ಲ ಅದು.
Weeks time.
my lord, may kindly grant 1 week time.
ಅಲ್ಲ ಅವ್ರದ್ದು ಪುಟಪ್ ಆಗ್ಲಿ, ಯಾಕಂದ್ರೆ ಅವ್ರದ್ದು ಪುಟಪ್ ಆಗಿಲ್ಲ. His affidavit is not put up.
Yes.
Respondent acknowledges this.
Yes, other copies.
Sir,
for
appellant is
WhatsApp.
present, appellant and her counsel are present, appellant acknowledges receipt of demand drafts. Appellant's response counsel submit that he has filed the affidavit of assets and liabilities in the registry. Appellant's counsel, response counsel, appellant's counsel seeks time to file his rejoinder to the said affidavit and counter file to I3 of 2024. List on. ಹಾಗಾದ್ರೆ after vacation ಹಾಕೋಣ ಬಿಡಿ.
Please.
4/6.
ಇದೊಂದು ಬರ್ಕೊಂಬಿಡಿ. Appellant's counsel submits that there is arrears of the maintenance awarded is in arrears. If that is the case, it is appellant is at liberty to recover the same by executing the order.
Xerox copy.
Interim order ಬರೀ ಇಲ್ಲಿವರೆಗೆ ಮಾತ್ರ ಇತ್ತಾ? Why limited by time? Last year very extend ಆಗಿಲ್ವಲ್ಲ, ಫುಲ್ ಕೊಟ್ಟಿರ್ಬೇಕು ನೋಡಿ, ಲಿಮಿಟೇಷನ್ ಕಂಡೌನ್ ಮಾಡಿದ್ಮೇಲೆ.
According to me, I paid as on date full, my lord. If they have anything,
ಇಲ್ಲಿ ಹೋದ್ರೆ ನೀವು ಮೆಮೋ ಆಫ್ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಏನ್
I
ಹಾಕೊಳ್ಳೋದಿಲ್ಲ
will take.
ಎಕ್ಸಿಕ್ಯೂಟಿಂಗ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ. Why these proceedings should be delayed for that?
divorce proceedings are granted
which was filed by husband and
Interim order was granted absolutely or ಅವ್ರೇನೋ extension ಅಂತ ಹೇಳ್ತಾರೆ ಚೆಕ್ ಮಾಡಿ.
till next date, my lord, because still filing of objections anta, I'd filed my objections.
Objections to?
Objections to interim maintenance stating that she is earning. That she has not stated anywhere either before this court or before the Supreme Court or before you.
Extended till
She is earning lordships.
55 ಆದ್ಮೇಲೆ ಇದೆ ಇವತ್ತೇ ಲಿಸ್ಟ್ ಆಗ್ತಿರೋದಾ ಇಲ್ಲ? ಇಲ್ಲಿದೆ. Why it is extended?
Only till next date anta ಆಗ್ತಾ ಇದೆ because I have filed objections, my lord.
No,
It
what
needs
is
to be heard.
decrease for divorce alva?
Interim maintenance, my lord, is extended till next date. Divorce that is stayed by this court.
That is already stayed.
Stayed.
Maintenance ಗೆ ಯಾಕೆ stay ಬರುತ್ತೆ?
Only till next date anta ಬರ್ತಾ ಇದೆ because I had not filed objections. I filed objections stating that she is earning.
Stay granted or is extended till further orders.
Well, till next date, my lord, because my lord, I have filed objection. I have taken contention that she is earning, my lord.
ಸ್ಟೇ ಇರೋದು ಡಿಗ್ರಿ ಫಾರ್ ಡೆಸೊಲ್ಯೂಷನ್ ಆಫ್ ಮ್ಯಾರೇಜ್ ಇರೋದು ಅವರ ಅಪೀಲ್ ಅಲ್ಲಿ ಅವರೇ ಇದು
ಅದು further orders that I have no objection, my lord. I will not remarry. Idu interim order, my lord, for maintenance is only till next date, my lord.
ಇಂಟ್ರಿಮ್ ಸ್ಟೇ granted earlier for ಅದು ಇರ್ಲಿಕ್ಕಿಲ್ಲ absolute ಚೆಕ್ ಮಾಡಿ ನೋಡಿ.
My lord, I am very sure, lord.
No, dissolution of marriage absolute.
That is that, my lord, this court can grant.
Extended till further orders ಅಂತ ಬರ್ತದೆ ಅಷ್ಟೇ.
But for maintenance, my lord, it's only extended till next date.
ಅದು ಬರೀ till next date ವರೆಗೆ ಅಂತ ಕೊಟ್ಟಿತ್ತಾ?
I2 ಏನ್ ಕೇಳಿರ್ತಾವ ಪೇರೆಂಟ್ ಕೇಳಿದಿರಾ I2 ಅಲ್ಲಿ? What is the relief you sought in I2?
My lord, they have filed, appellants have filed.
ಏನು ಏನ್ ಕೇಳಿರೋದು?
Maintenance.
ಈ ಆರ್ಡರ್ ಇದೆ ಅಲ್ಲ, ದಿಸ್ ಇಸ್ 20,000 ಕೊಡ್ಬೇಕು 10,000 ಕೊಡ್ಬೇಕು ಅದು till next hearing date ಅಂತ ಹೇಳಿ. The interim order dated 21/2025 is extended till further orders ಅಂತ ಮಾಡ.
Next date, my lord, because she is earning, my lord.
ಹೇಳಕ್ ಬರ್ತಾ ಇಲ್ಲ, ಪೇರೆಂಟ್ಸ್ ಕೌನ್ಸಿಲ್ಗೆ ಹೇಳಕ್ ಬರ್ತಿಲ್ಲ. ಇದು ನೋಡಿ
Produce records.
21/2025 ಗೆ you shall go on paying maintenance of this 20,000 and 10,000 ಇದು interim stay granted earlier.
27/9 ಗೆ I2 ಮೇಲೆ interim order been granted. Interim order sought with the stay of the or judgment decree. This is the no stay on interim order as such.
Interim order ಇದೇನಿತ್ತಲ್ಲ ಇದು 21/2025 ಗೆ this arrangement shall continue till
next date.
ಅವರು ಅದು ಹಿಂಗೆ interim order granted interim order granted.
Yes, that is ನೋಡಿ 27/9 order.
27/9 ಅದೇ ಅದಕ್ಕೆ ಬೇಡ ಅಂತ ಹೇಳಿದ್ರಲ್ಲ, interim stay is granted for marriage dissolution it is absolute. ಇವ್ರು ಏನ್ ಇಬ್ರು ಹೇಳ್ತಾ ಇದಾರೆ, that is interim order dated 21/2025 to pay maintenance ಅದು till next hearing date ಬಗ್ಗೆ ಅಷ್ಟೇ ಇದೆ. Interim stay ಅಂತ ಆಗಿಲ್ಲ ಅದಕ್ಕೆ ನನಗೆ ಹೇಳಿ interim order date ಹೇಳಿದೆ. interim order dated 21/2025 date ಹೇಳಿದೆ. interim order dated 21/2025 regarding payment of interim maintenance is extended till next hearing.
Please, lordships. Madam, I'll give them.
ಬಂದಿದ್ದಾರೆ. ಅದು ಯಾವ್ದೋ ಒಂದು ಕೇಸಲ್ಲಿ ನಿಮ್ದು ವಿಲ್ಸನ್ ಗಾರ್ಡನ್ ಪೊಲೀಸರು ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಗೆ ರೆಕಾರ್ಡ್ಸ್ ಕಳಿಸ್ಕೊಡಿ RFS ಕಳ್ಸಕ್ಕೆ ಅಂತ ಕೇಳಿದ್ದಾರೆ.
Yes, ma'am.
But nobody is present. How do we come to know that it is sent by them only?
I will ask my lords concerned.
ಒಂದೇನೋ ಆರ್ಡರ್ ಮಾಡಿದ್ವಿ. If you take note of that, ನೀವು ಎನ್ಕ್ವೈರಿ ಮಾಡಿ ಹೇಳಿದ್ರೆ ವಿಲ್
I will inquire my lords.
ಪಾಸ್ ಓವರ್ ಮಾಡಿರ್ತೀವಿ.
It may be taken up.
ನಂಬರ್ ತಗೊಳ್ಳಿ.
Yes, my lords.
ಪಾಸ್ ಓವರ್ ಆರ್ಡರ್ ಮಾಡಿದೀವಿ. ಮೇ ಬಿ ಬಿಕಾಸ್ ಅಂಡರ್ ಹಿ ಸೀಲ್ ಅಡ್ರೆಸ್ ಟು ರಿಜಿಸ್ಟ್ರಾರ್ ಜನರಲ್ ಅಂತ ಇದೆ. But the allegation in that case is the wife was impersonated before the trial court. ಅದಕ್ಕೆ ಮತ್ತೆ ಇಲ್ಲೂ ಇನ್ನೊಂದ್ ಏನಾರು ಆಗೋದ್ ಬೇಡ ಅವ್ರಿಗೆ ಅವ್ರ ಪರ್ಸನಲಿ ಅಪಿಯರ್ ಆಗಿ ತಗೊಂಡ್ ಹೋಗ್ಬೇಕು ಅಂತ ಆರ್ಡರ್ ಮಾಡಿದೀವಿ ರೆಕಾರ್ಡ್ಸ್ ಅನ್ನು.
Till number 10, Chandrasekhar P. Patil.
Memo is filed for dispensation of notice to R1 and R2, my lord. The liability is fixed on the insurance company. R3 is the insurance company.
For dispensation to R1 and R2, no?
Please,
Claimants appeal.
claimants appeal for enhancement. Liability is admitted and they have also paid.
Central Insurance Company,
Pradeep is appearing.
Pradeep is there.
Pradeep.
Shri Pradeep, standing counsel for respondent is requested to accept notice for respondent. ಉಳಿದಿದ್ದೆಲ್ಲ ಹಾಕೊಳ್ಳೋದ್ರಲ್ಲಿ ಇದರಲ್ಲಿ 1, 2, 3
ಇಲ್ಲೇ ಮುಗಿಸೋಣ ಲೋಕಬಲಕ್ಕೆ ಕಳ್ಸೋಣ. ಲೋಕಬಲಕ್ಕೆ ಹೇಳ್ಬಿಡ.
ಇನ್ನೇನು ರೆಸ್ಪಾಂಡ್ 3 ಶಾಲ್ ಡೆಪಾಸಿಟ್ ಅಂತ ಮಾಡಿಲ್ಲ. Responds are jointly and severally liable to pay compensation amount with interest. Then they are liable. Respond number 3 ಅಂತ ಸ್ಪೆಸಿಫಿಕ್ ಆಗಿ ಇಲ್ವಾ ಆರ್ಡರ್ ನಲ್ಲಿ ಅವಾರ್ಡ್ ಅಲ್ಲಿ
ಬಟ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 3 ಪೇ ಮಾಡಿದ್ದಾರೆ.
Respondents are jointly and severally.
ಅವರಲ್ಲಿ ಅಂತ ಆಗಿದೆ.
ಹ್ಮ್
ಫೈಂಡಿಂಗ್ ಏನಿದೆ ಇದು ಜಾಯಿಂಟ್ಲಿ ಅಂಡ್ ಸೆವರಲಿ ಅಂದ್ರೆ ಅಕ್ಸೆಪ್ಟ್ ಮಾಡಿರ್ತಾರೆ ಇನ್ಶೂರೆನ್ಸ್ ಇದೆ ಅನ್ನೋದು. R1 absent, R2.
ಮಾಡಿದ್ದಾರೆ.
So R1 was the owner of the vehicle.
R3 has satisfied the award amount before trial.
Satisfy ಮಾಡಿದ್ರು.
Yes. Satisfied.
Owner and previous owner, 1 and 2.
Submits that respondent number.
1 and 2, owner and previous owner.
ಅಲ್ಲ ಇಲ್ಲಿ ನೀವು ಮೂರೇ ಜನರನ್ನ ಪಾರ್ಟಿ ಮಾಡಿದೀರಾ, ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ 4 ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ಇದಾರಲ್ಲ ಯಾಕೆ? In the trial court there are 4 respondents.
ಇಲ್ಲ
3 ಇದ್ದಾರೆ.
ಮ್ಯಾನೇಜರ್ ರಿಲಯನ್ಸ್ ಜನರಲ್ ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿ ಏನು ಅಂತ ಮಾಡಿದ್ದಾರೆ?
ಮತ್ತೆ
ಇಲ್ಲ ಕರೆಕ್ಟ್ ಯು ಆರ್ ರೈಟ್. ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 3 ಅದು. Now counsel for the appellant submits that respond number 1 and 2 has satisfied the award. Respond number 3 has satisfied the award. Response 1 and 2 are the registered owner and the policy holder of the offending vehicle. Consider the aforesaid facts in such cases. Notice respond number 1 and 2 is dispatched as paid. Delay ಎಷ್ಟಿದೆ? 88 days.
There is a delay of 88 days.
maybe condone.
Challenge is on what ground? ಏನು
In
ಕೇಸ್
quantum, only quantum. Conventional heads not properly given.
ಬರೀ
and
conventional head ಅಷ್ಟೇ.
ಹೌದು.
ಒಬ್ರಿಗೆ ಕನ್ಸೋರ್ಷಿಯಂ ಅಂತ 40,000 ಕೊಟ್ಟಿದ್ದಾರೆ. ಅಂದ್ರೆ ಸನ್ ಅಂಡ್
ಡಾಟರ್ ಅವ್ರಿಗೆ 40
ಅವ್ರಿಗೆ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ
ಇನ್ಕಮ್ ತಗೊಂಡಿರೋದು
ಅದೆಲ್ಲ ಕರೆಕ್ಟ್ ಆಗಿ
14,000 ತಗೊಂಡಿದ್ದಾರೆ.
conventional head.
ಬರೀ
ಸೆಟ್ಲ್ ಆಗ್ಬೋದು.
ಪ್ಲೀಸ್
Orders and I 1/2024. Hard accepting the reasons assigned to explain delay of 88 days in filing the appeal is condoned. In the interest of justice, I 1/2024 is postponed accordingly. As requested, matter report to local.
Please.
Seal number 11, Kavita HC.
Lordship, I am for the appellant, my lordship. While complying the office objection, I mistakenly applied the whitener on page number 2 of judgment.
Fresh certificate copy. ಅದೇ ಒಂದೇ ಅಬ್ಜೆಕ್ಷನ್
Yes, my lord.
accepting the counsel submission, office objection. Counsel submission is accepted, office objection. We are going to file the fresh copy.
I have informed the tribunal advocate.
How page ಅಲ್ಲಿ delete ಮಾಡಿದೀರಾ?
Page number 2 of the judgment, my lordship. Page number 10.
Certificate copy, xerox copy ಇದೆಯಾ?
Yes, my lordship.
With the condition that the appellant's counsel shall substitute the xerox copy of the substitute produce in addition. Additionally, the appellant's counsel shall produce a xerox copy of the certificate copy of the order.
I'll produce.
Page number 2 of the order. Office objection disposed of accordingly. Is really manager Reliance General. Reliance General or ಯಾರಿದ್ದಾರೆ? First, what about the first respondent?
The owner of the lorry, my lord.
Notice ಹೋಗ್ಬೇಕಾ ಅವ್ರಿಗೆ?
Actually, in findings,
One
the
and two
respondent
are
number
jointly
2.
and severally liable, respondent 1 and 2 shall deposit the compensation. ಇಬ್ಬರು ಮೇಲೂ ಆಗಿದೆ. Notice ಹೋಗ್ಬೇಕಾ first respondent?
Yes, my lordship. In findings, they have mentioned that
Srimati Malti T and Lawyers having counsel for respondent is requested to accept notice for respondent number 2. Issue notice to respondent number 1, list from
16-6.
much
Seal number 12, Ravi Samprati. Yes, Krishna Kishore.
My lord, I filed an application for paper publication for service of notice to first respondent today in the counter. My lord.
For the
The
respondent number,
other 3 connected matters, I filed the second set.
for respondent number 4, my lord.
You are seeking dispensation to organ.
No, my lord. I
you
have
paid
filed
the
an
fee.
application for paper publication.
Application ಹಾಕಿದ್ದೀರಾ?
ಹಾಕಿದ್ದೀನಿ, ಇವತ್ತು ಬೆಳಗ್ಗೆ ಹಾಕಿ.
Submits that application for substitution is submitted in the registry. Registry shall verify and list on the 2 days. ಒಂದು ವಾರ ಬಿಟ್ಟು ಹಾಕ್ಬಿಟ್ಟು ನೋಟಿಸ್ ಈಗ ಅವ್ರಿಗೆ ಪೇಮೆಂಟ್ ಆಗಿದೆಯಾ ನಿಮಗೆ?
For respondent number 4.
He is for the other insurer.
Other
Insurer, 2 vehicles are in.
ಅವರು ಸರ್ಡ್ unrepresented.
We already filed ವಕಾಲತ್.
ಬೇರೆ 3 ಕೇಸಲ್ಲಿ ಸರ್ವಾಗಿ ಅಪಿಯರ್ ಆಗಿಲ್ಲ. ಇದರಲ್ಲಿ ದಿ ಫಸ್ಟ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಇಸ್ ಎ ಕ್ಲೈಮೆಂಟ್.
But for the same claimants in the other
No,
cases,
no, other claims.
other claimants.
ಎಲ್ಲ ಇಂಜುರಿ ಕೇಸಸ್.
When those are those ಯಾವಾಗ ಲಿಸ್ಟ್ ಆಗಿದೆ ಅದೇನಾದ್ರು particular
ಇವತ್ತೇ
date?
ಇದೆ.
Other
Connected
claimants.
cases.
Please, my lord.
12.1,
2, 3. ಇದರಲ್ಲಿ 3ರಲ್ಲೂ ಸೆಕೆಂಡ್ ಸೆಟ್ ಹಾಕಿದ್ದೀನಿ.
Registry shall
ಇವತ್ತು.
verify and list on date. 10 days ಬಿಟ್ಟು ಹಾಕ್ಬೋದು. ಎಲ್ಲದಕ್ಕೂ ಸೆಕೆಂಡ್ ಸೆಟ್ ಕೊಟ್ಟಿದ್ದೀರಾ?
ಕೊಟ್ಟಿದ್ದೀನಿ. 3ರಲ್ಲೂ ಟುಡೇ ಮಾರ್ನಿಂಗ್ ಐ ಫೈಲ್ಡ್ ಇಟ್ ಇನ್ ದಿ ರಿಜಿಸ್ಟರ್.
ಯಾವ್ದ್ರಲ್ಲಾದ್ರೂ ಮೈನರ್ಸ್ ಏನಾದ್ರು ಇದಾರೆ? ಉಳಿದಲ್ಲಿ
ಇಲ್ಲ ಮೈನರ್ ಯಾರು ಇಲ್ಲ.
ಆಲ್ ಇಂಜೂರ್ಡ್.
Yes.
Seal number 13, BC Shivannegowda, B Pradeep Farare.
Lord, I appear for the appellant's counsel. An amount of rupees 5,85,617, white check number 593447, dated 1/3/25 is deposited before the trial court. Awaiting the acknowledgement. It may be taken up next week.
Appellant submits, counsel for the appellant submits that seeks time to produce the proof of deposit. ಅದ್ರಲ್ಲಿ ಒಬ್ರು ಯಾರೋ ಮೈನರ್ ಅಂತ ಕಾಣಿಸ್ತಾ ಇದೆ ಅಲ್ಲ? R2 and 3. R1 has not contested. R2 and 3 minors ಅಂತ.
R2 is minor.
The records show that respondent number 2 and 3 are the minors.
R2,
And
R3.
their mother respondent number 1 has not turned up to represent their interest. Therefore, appellant's counsel can file a necessary application for appointment of court guardian for respondent number 2 and 3. List after 2 weeks.
Seal number 14, Geeta R.
List after this.
For the appellant's matters. Kindly a stay may be extended matters.
Very limited by time.
Stay order this.
Delay it, huh?
Delay there.
List after service and respondent number 1 and 3 is completed. And last time we list on 10-1 ante ಇದೆ. Interim stay last time extension ಬಗ್ಗೆ ಏನು?
Delay ಇತ್ತು ಅಂತ extension.
Interim order granted earlier. Speak and modest compare. Granted earlier is extended till next year.
Grateful.
Seal number 15, B Pradeep, Sandesh TB, Manjunath Fetches for R4.
For the appellant, I will take steps to R3 and 5. In this case, challenging the liability aspect. Owner of the vehicle, respond number 3.
Request 10 days is time is granted to do the needful in respect of response 3 and 5. If needful is done, issue notice to R1 and 2 or appear ಆಗ್ತಾರೆ 4 sir. If you need.
Respond number is owner of the vehicle, my lord.
Response 3 and 5.
5 is the wife of the deceased.
17-6.
17. Days in the 2 weeks.
Seal number 16 adjourned. Seal number 17, GS Marlaya.
R1. Awaiting service of in R1 ಅಂತ ಇದೆಯಾ? Before the trial court also R1 was represented to guardian. List of the service and R1 is completed. Yes.
Hearing on IA. Seal number 18, Pawan Kumar Ji. K. Suryanarayan Rao, C. R. Ravishankar.
Respond.
Lordship has ordered. ಮಾಡಿದ್ದೀನಿ ಆಲ್ರೆಡಿ
ಕೊಟ್ಟಿಲ್ಲಲ್ಲ ನೀವು in advance.
ತಾವು ಮತ್ತೆ
Lord, in this matter, I need a week's time, Lord. And maybe taken up next week.
You are for
ಎಲ್ಲ ಮೆಮೊದಲ್ಲಿ
ಅದೇ ಅವ್ರದ್ದೇ ಮಾಡಿರೋದು ನಾವು ವಿ ಆರ್ ನಾಟ್ ಅದರ್ ಥಿಂಗ್
ವಾಟ್ ಆರ್ ದಟ್ಸ್ ಆಲ್ ವಾಟ್ ಇಸ್ ಸ್ಟೇಟೆಡ್ ಇನ್
ಸರ್ವ್ ಮಾಡ್ದಂಗೆ ಮಾಡಿದ್ರೆ we are not accustomed to that.
ಐ ಲೀವ್ ಟು
ಅಲ್ಲ
ಮೊದಲು ಕೊಟ್ಟಿದ್ರೆ ನೋಡ್ಕೊಂಡು ಬರ್ತೀನಿ.
ಇರುವುದನ್ನೇ ನಾವು
You should submit, no? You are also asked to submit that.
Please, my Lord.
For
I had
one
in
thing, you
the
are not
synopsis,
submitting and whatever they have submitted also is.
in the synopsis, my Lord, whatever
ಅಷ್ಟೇ
required, I had
ಅವ್ರದ್ದೇ.
filed it, my Lord. Now they have, your Lordship was direct, correct, your Lordship was,
In a tabular form.
please, my Lord,
Submit it in a tabular form.
tabular form.
ಇದು ಮತ್ತೆ receiver level ಇರೋದಲ್ಲ.
Not
ಯಾರು
this.
ಕೊಟ್ಟಿರೋದು?
ಐ ಹ್ಯಾವ್ ಫೈಲ್ಡ್
R1 ನಿಮ್ಮದು?
I only stated what in what item of this
What is
property stats were given.
ಅವ್ರ ಐ ಮೇಲೆ ನಾವು ಮಾಡಿರೋದು ನಾವೇನ್ ನಾಟ್
In the last page, I have stated in item number 1, 5, 6, 7, 9, and 10, and 1/3 sharing item number 8.
ಸ್ಪೆಸಿಫಿಕ್ ಆಗಿ ಒಂದು ಆರ್ಡರ್ ನಲ್ಲಿ ಕರೆದಿದ್ದೀವಿ. ಅವು 3 ಟೇಬಲ್ ಮಾಡ್ಕೊಡಿ ಅಂತ ಹೇಳಿ. ನಮ್ಮ ಹಿಂದಿನ ಆರ್ಡರ್ ಶೀಟ್
Respondent.
ಹೀಗೆ ಒಂದು ಕನ್ಸಿಡರ್ಡ್ ಪ್ರಾಪರ್ಟೀಸ್ ಅದು ಪ್ರಾಪರ್ಟೀಸ್ ಮೆನ್ಷನ್ ಇನ್ ದ ಅಮೆಂಡ್ಮೆಂಟ್ ಅಪ್ಲಿಕೇಶನ್ ಪ್ರಾಪರ್ಟೀಸ್ ರೆಕಾರ್ಡೆಡ್ ಇನ್ ದ ಜಡ್ಜ್ಮೆಂಟ್ ಆಸ್ ಕನ್ಸಿಡರ್ಡ್.
Amen.
ನೀವು ಫಸ್ಟ್ ಹೇಳಿದ್ದು IA3 ಅಲ್ಲಿ ಏನಿತ್ತು ಅನ್ನೋದು.
ಹೌದು. Last
ಸೀರಿಯಲ್ ನಂಬರ್ 1 to
1, 5 last page ನಲ್ಲಿ ಹೇಳಿದ್ದೀನಿ 1, 5 submitted that the original response
11,
1.
12 and 14.
properties mentioned in the
Yes.
application is 1 to 13,
ಹೌದು application 1 to 19.
1 to 19.
19. Out of that, item number 1, 5, 6, 7, 9, and 10, and 1/3 sharing item number 8.
So this was considered.
ಇಷ್ಟರಲ್ಲಿ ಮಾತ್ರ ಕೊಟ್ಟಿದ್ದಾರೆ as per the order.
So rest of it were done. Therefore, decree was not drawn for rest.
ಇಷ್ಟಕ್ಕೆ ಡಿಗ್ರಿ ಆಗಿದೆ. Decree was drawn to these properties.
What was not drawn is at page
ಒಂದ್
4
ನಿಮಿಷ
of the synopsis.
ಇದೆ ನಮ್ದು ಇದೆ.
And by consent, this order was passed.
It is also necessary to state that judgment granting share in the aforementioned item number 1, 5, 6, 7, 8. Third share in 9 and 10.
Total 7 properties.
This order was passed with the consent of the parties.
Where do we find that these were considered?
Yes, we considered and he accepted it also. On that basis, the judgment was passed.
Correct, judgmental, where do we find?
There is a
17.
there is a specific reference in the judgment, Miller.
Para 17.
Paragraph 17. ಇಲ್ಲ, ಇದು ಡಿಗ್ರಿ ಇದೆ ಲಾಸ್ಟ್ ಟೈಮ್ ಅದೇನ ಒಂದು ಎದ್ರಲ್ಲ
Noticing that
ಟ್ಯಾಪ್ ಮಾಡಿದ್ದಿತ್ತಲ್ಲ ಜಡ್ಜ್ಮೆಂಟ್.
In the synopsis page 50.
ಸಿನಾಫಿಸ್ ಅಲ್ಲ ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲಿ
Judgment.
The judgmental para 17, last sentence, para 17. Paragraph number 17, last sentence is very clear on this.
ಪ್ಯಾರಾಗ್ರಾಫ್ ನಂಬರ್
Paragraph number 17, last paragraph. It commences at page 11, it last, as agreed upon by all the parties.
ಆಟೋಗ್ರಾಫ್ ಎಲ್ಲ ಐತೆ ಹಾಗಿದ್ರೆ ಅವ್ರೀಗ ಇದು ರಿವ್ಯೂ ಕೇಳ್ತಾ ಇದ್ದಾರೆ ಆಟೋಗ್ರಾಫ್ ಎಲ್ಲ ಐತೆ Last time, whatever the photo and really
What has happened in this file is it was scanned.
See, you are taking us
So
to
it is
para 17.
Para 17, Mila. Para 17, last sentence.
Para 17.
Yes, I'll read the.
Please read entire para 17.
Yes, please. Accordingly, you observe that the final decree court, while dividing the properties by mates and bounds, shall consider the request of the second defendant to allot item number 12 and 35 of the plaintiff property in his favor by compensating the plaintiff any other properties, considering the valuation of the respective portions of the land. Since there is no dispute in regard to item number 1, in regard to the house property bearing assessment number so and so, Sherigonda village, Kasba Hobli, Chikamur Taluk, bounded on east private property, west property of the Nagaraja, north property of Timmegowda, and south road. 1 acre 35 guntas in survey number 358 P1, Muktahalli village.
Item number.
Adu 5, item number 5.
Item number 5.
Yes.
One by one.
Ever.
The first one is item number 1 of the
Yes,
application.
first is item number 1.
One by one.
Second is item number 5.
Item number
5, item number 5.
Item number 1 is assessment number 34, correct?
Yes.
Come to item number 5.
Item number 5. That is 358 bar P1.
1 acre 35 guntas.
Yes, 1 acre 35 guntas.
Yes.
Asboli bounded on so and so, so and so, so and so.
358.
Oh, sorry.
ಈಗ ಯಾಕಂದ್ರೆ ಈಗ ಆಗಿರೋದು 358, 5.
What we find.
ಇಲ್ಲ correct ಅದನ್ನ.
Yes, item number 5.
ಆದ್ಮೇಲೆ item number 6. Item number 6, 358 bar P2.
P2, 358 bar P2.
Yes.
3, 2. And then item number 7.
Number 7, 2 acres.
73.
Yes.
73, 2 acre 26 guntas.
Yes.
Then item number 8 will not.
8 ಇಲ್ಲ.
60.
Is it item number 1/3 share in item number 1, 8. So out of the 1 acre 10 guntas, first defendant is having 1/3 share in 65 bar 3. That is item number 8.
Yes.
65 bar 3. ಆಯ್ತಲ್ಲ?
Item number 8. And then item number 9.
7.
Yes, 87. Item number 8. And item number 10.
Survey number 79 is item number 10.
87 is item number 9, Miller. 79 item number 10. Yes, item number 10. That's all.
Item number 9 ಕೂಡ ಆಗಿದೆಲ್ಲ.
Also 9 ಆಗಿದೆ. 87 survey number.
Page number 12,
Bottom.
Yes.
And then item number 10.
60.
Yes.
79. So and so. In these properties, the plaintiff is entitled to 1/3 share as agreed upon by all the parties. This is all. This is consent order.
Page para 19 would go, this court would go a step further and consider the application and say what has to be given and not given. In the result, these appeals are disposed of modifying the judgment and decree of the trial court, holding the plaintiff also entitled to 1/3 share. The entire suit item number 12, the properties now added in this appeal. Now added in this appeal has to be read with respect to IA number 1 of 13. That is what is the properties now added in the appeal in the application.
No.
Appeal ಹೆಂಗಾಗಿದೆ? No, 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 no,
That is what is my lord, that is what is the Your Lordship, my lord,
Decree.
Your Lordship may kindly come to orders passed on 38/2019. Lord, Your Lordship may kindly come to order.
ಒಂದು ನಿಮಿಷ.
Now included ಅಂತಂದ್ರೆ consent
Yes.
ಏನಿರುತ್ತೆ ಅದಿರೋದು.
ಅಷ್ಟೇ.
See, item number 12, one thing, properties now included in this
This
appeal.
appeal.
Means what was,
Para 17.
we have to.
IA
read
number
it-
3 of
we have to
2011.
Read it with the
It-
previous
along with-
para 17.
Paras, Lordship, my lord, correct, my lord. It should be understood in the background of order passed on 38/2019.
If that is the case, after saying that these are the considered properties, where is the discussion that they are not considered, but still the.
For that
plaintiff
clarification,
entitled to check
please.
that?
Correct. Lordship may kindly go through order dated 38/2019. That would clarify the issue.
38.
2019.
Yes,
This appeal, if I read, my lord,
yes, yes.
this appeal was disposed of by a final order dated 28/1/2014. Various properties were assigned to various parties. In the interregnum,
IA 3 of 2011 was filed on 12/9/2011 under so and so with a prayer to amend the plaint as proposed therein. Ostensibly, the said application was considered and a judgment was delivered by including the said amendment, as would be seen at para 7 of the judgment. Decree was also drawn. However, the plaint was not amended. Therefore, unless the plaint stands amended, as a consequence to IA number 3 of 11, the plaint properties will not match the properties as mentioned in the decree. Consequent to the order dated 28/1/2014. Consequently, even though same was deemed to be allowed by the order, the properties were not included in the decree in view of the fact that the said properties did not form part and parcel of the plain schedule. There is no dispute so far as these facts are concerned. Before passing the order dated 28/1/2014.
That is only to include the property in
Correct.
the plain schedule,
And
but not granting share.
correct, Lord. If operative portion, there might not be a discussion, I admit. But in para 14, what the court,
Even if the amendment is allowed to grant the decree,
Lord, correct.
whatever the
Wha-
court intended to give you the share, they have
Lord,
to
my
include.
my understanding, my lord, is this, my lord. In para 19, there was concessions given by the parties, but this court went a step ahead and in para 19 said, we are going to give in entire properties. If did not confine itself to the consent. That is not
Last
written.
paragraph.
Last para 19, my lord, it did not confine itself to the consent of the parties. Is my humble submission, my lord.
It's put off in 2014, no?
Please, my lord.
For that, you came up before this court.
My lord, various stages, my lord, we
2015.
have filed applications, my lord, in the same matter, same difficulty. Multiple times we have come before this court.
That is only, this order is only with regard to allowing.
Allowing the
application.
IA.
Yes, yes.
Where is the statement even in this that the decree was granted in all the
Para 19 is the judgment, my lord.
judgment? See, when the application itself was not allowed, if
It was
application-
it's deemed to be allowed is what the clarification order says, my lord.
Read the last sentence, last paragraph.
Last, my lord,
Very, very clear.
my understanding,
Accordingly, registries,
allowing
IA is totally allowed.
IA 1 of 2015. what was IA?
That is the addition of properties in the this thing. And if we read,
Annex.
this is one order. Now, para 19 of judgment. This is read in the background of 38 order.
What was that IA 1 of 2015?
My lord, your amendment application, my lord, seeking addition of properties in the appeal.
It appears that application is not here.
IA 3 of 2011, it is found in synopsis of nature of property. There are movable and immovable properties.
So, sir, the properties which are excluded, para 17, what is the
Please.
nature of the property and what basis are you claiming share in that property?
Joint family properties.
it's like,
Evidence is laid down that matter?
no, no.
But this,
One second,
matter was not remitted back for,
one second, sir.
please.
Whether any evidence is laid on that matter?
No.
Any written statement filed on that matter? Have you contested that matter? Have you led any evidence in support of your claim?
No evidence was led, my lord. Similarly, my lord, the respondent have not filed any objection or nor opposed that this would not come.
Which is why para 17, sir.
Yeah.
That is consensus being recorded, my lord, but para 19 would say otherwise, my lord.
No, if your argument, it has to be read, para 19 has to be read.
In the background of
Properties, do you expect us to believe that though even in the contested matter, court has granted without even giving the opportunity of you proving whether the property is entitled or not?
para 19 would indicate so, my lord.
No,
Why
please
did
tell us, legally tell us, sir. Don't try to infer.
Interpret the
We are
order.
trying to be with you.
Please, my lord.
We'll accept your submission, provided point out that your contention with regard to other properties is excluded, not consented by them, were granted even without evidence in that matter? You want us to read that way?
Not
Can
read.
it be read that way?
Lord. As on that day, my lord, there are parties present.
Then you
No, you
step
please
to
tell us, sir.
No
years.
evidence was led, my lord.
So in the absence of evidence, in the absence of you proving that you are entitled to one-third share in this property, can this be, can we accept a submission saying that has to be included along with that?
Lord, it cannot be, my lord, but
After that,
my lord, it cannot be.
1 second.
It cannot be. Your lordship is correct. Lordship is correct.
Samadhana kelvi,
No issue.
we are trying to hear with you.
Please, my lord.
If that cannot be read, how is the review maintainable?
My lord, review is not to the judgment of.
Counsel,
Please, my lord.
there's no point in trying to be too clever in this matter.
Lord, not. My lord.
If it is an error apparent in the face of the record, We are with you.
Please, my lord.
Now let's go to the basics of it.
Please, my lord.
Para 17 deals with the consent given by them, some of the items of property. No difficulty.
Please, my lord.
If you want us to read para 19 to include the property which they have not consented it, which requires an evidence, appreciation of merits of your claim, you want us to review that order and to hold it? No, it amounts to including it.
One submission, my lord. Review is not with respect to the judgment, my lord. Review is with respect confined
But
to.
that is part of judgment, no? The election is part of judgment. Suit schedule.
Correct, my lord, but my.
That too you have.
Under
filed
you may
for
have
copy.
excellent case on what you're trying to say, but may not
They
fall
have
within
asked
within
it.
the purview of a review. This is what we're trying to tell you.
Apart from that, they have moved after 2019. That order was passed now. In 2023, they come up with its review.
You may have to have some other recourse.
And after some time, we may
Order.
feel like again coming up with some other idea.
As a matter of fact, on that day, we all considered because at the time, but my learned friend was not there. He has changed several advocates and by consent only this.
That advocate was different. Or this
Yeah.
is
I came up here.
He's not aware of what has happened on that particular day.
This order was passed, you are not there.
No.
Original order I was not
He's
there.
not there.
Original order was.
How can you file review?
Judgment can last order under review. I was the advocate.
No.
Order under review. I was the advocate.
How review at your instance can be included?
See, when the
Lord.
main judgment was passed, you are trying to interpret the
He's
judgment.
not there, Lordship.
If you were not
He's
on
not
the
represented.
record, then how are you entitled to maintain this review petition? A judgment ತಗೊಳ್ಳಿ, advocate.
Order, my lord, I understand a circular pass, my lord, who has argued the matter before this court should file a review petition. Correct, but my lord, here, my lord, order under review is a different order which I had argued the matter. Order under review is an application seeking amendment of decree.
Trying to interpret the original judgment of 2014. Were you there in 2014?
No, I was not there.
Then how are you entitled? ಅದನ್ನ ಅವ್ರು ಹೇಳಿಲ್ಲ, ಹೇಳಿದ್ರೆ ಅಲ್ಲಿಗೆ ಮುಗಿಸ್ತಿದ್ವಿ ನಾವು.
ಅಲ್ಲ ಹೇಳ್ಬೇಕು, ಬಟ್ ಅವ್ರೇನೋ 5-6 ಹೇಳ್ಬಿಟ್ಟು 5-6 ಬೆಂಚಲ್ಲೂ ಟ್ರೈ ಮಾಡೋದು. ನಾವ್ ಯಾಕೆ ಸುಮ್ಮನೆ
As a matter of fact, earlier also.
It is your duty.
ಅಲ್ಲ ಆಗಿದೆ ಸ್ವಾಮಿ, ಒಂದು ಕೋರ್ಟ್ ಅಲ್ಲಿ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ. ಅಲ್ಲ ಕೈಂಡ್ಲಿ ಲಾರ್ಡ್ಶಿಪ್, ಒಂದು ಕೋರ್ಟ್ ಅಲ್ಲಿ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ. Then you went to pay.
ಹೇಳ್ತಿರೋದು. Advocate who argued the matter at the time of disposal of the matter only can maintain the review petition ಅಂತ ಒಂದು
Correct,
judgment.
Lordship, but ಇನ್ನೊಂದು
Order and reviews on order passed with respect to item number 20, I can maintain it.
and also Lordship, immovable property, ಇದು ಮೂವಬಲ್ ಪ್ರಾಪರ್ಟೀಸ್, ಕಾರ್ಗಳೆಲ್ಲ ರಸ್ಟ್ ಹಿಡಿದು ಎಲ್ಲ ಅವ್ರ ಅಪ್ಪ ಇದ್ದಾಗಲೇ ಹೋಗಿದೆ, ಅದನ್ನು ಇನ್ಕ್ಲೂಡ್ ಮಾಡಿ ಅಂತ ಕೇಳ್ತೀವಿ. ಅದು ಇಲ್ವೇ ಇಲ್ಲ ಅವ್ರ ಹತ್ರ. ಕಾರ್ಗಳು, ವ್ಯಾನ್ಗಳು, ಹೌ ಕ್ಯಾನ್ ಇಟ್ ಪಾಸಿಬಲ್?
Bernard counsel for ಅದೊಂದು ಜಡ್ಜ್ಮೆಂಟ್. You are for ಎಲ್ಲರಿಗೆ ಯಾರ್ಯಾರಿಗೆ ಅಪಿಯರ್ ಆಗ್ತಾ ಇದ್ದೀರಾ ನೀವು?
I am
Petition
representing a
correct.
second respondent. My learned friend is.
I am appearing for soon and.
A and B, na?
Yeah, yes, your Lordship.
Counsel for respondent 1 and B and counsel for respondent number 2 submit memo with ಮತ್ತೆ ಇದಕ್ಕೊಂದು ಟೈಮ್ ಕೇಳ್ತಾ ಇದ್ದೀರಾ, ಟ್ಯಾಬ್ಯುಲರ್ ಫಾರ್ಮ್ ಅಲ್ಲಿ ಮಾಡ್ಕೊಡಿ ಅಂತ ಹೇಳಿದ್ರು. Memo with the particulars of the property in compliance with the order dated 24/3/2025. In full compliance ಇಲ್ಲ ಇದು, ಟೇಬಲ್ ಫಾರ್ಮ್ ಮಾಡ್ಕೊಳ್ಳಿ. Heard orders and number
Order under.
2 ಮಾತ್ರ ಅಲ್ವಾ? ಡಿಲೇ ಕಂಡೋನ್ ಆಗಿದೆಯಾ?
ಇಲ್ಲ ಕಂಡನ ಆಗಿಲ್ಲ.
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 ಮತ್ತೆ ಇಲ್ಲಿ ಬರೀ IA 1 of 2023 CD ಅಂತ ಎರಡು ಒಟ್ಟಿಗೆ ತಗೊಳ್ಳಿ. there is no merit in it. IA orders and IA 1 of 2023. This appeal was disposed of by the judgment dated 2000
January 2014.
14.
This was plaintiff's appeal only, no?
Plaintiffs and
Defendant.
Defendants,
This is plaintiff's appeal.
both appeals.
Connected are defendants.
Appeals.
Yes, two.
Connected. Two
One
appeals are
by
there.
the second respondent in this case filed.
And also
And another one. Of course, he has not certain clarification he wanted that he got it.
Represents plaintiff.
I represent the plaintiff.
ಇನ್ನೊಂದು ಅಪೀಲ್ ಯಾರು ಷಡಾಕ್ಷರಿ ಅನ್ನೋರು he was
He
defendant.
he is the second respondent in this present application and he was a appellant in that.
appeal ಅಲ್ಲಿ ಕೇಳ್ತಾ ಇದೀವಿ ಅಷ್ಟೇ.
ಹೌದು.
both appeals are clubbed together.
28/1/2014. Part B. This does not rest on the ಅಲ್ಲೊಂದು ಮತ್ತೇನೋ ಕರೆಕ್ಷನ್ ಮಾಡಿದಾರಾ ಜಡ್ಜ್ಮೆಂಟ್ಗೆ?
ಜಡ್ಜ್ಮೆಂಟ್ ಅದು ವಿಲೇಜ್ ತಪ್ಪಾಗಿತ್ತು.
ವಿಲೇಜ್ ವಸ್ತಾರೆ ವಿಲೇಜ್ ಅದಕ್ಕೆ ಹೊಸಬಾರೆ ಅಂತ ಬಂದಿದೆ. ಓನ್ಲಿ ವಿಲೇಜ್ ಇಸ್ ರಾಂಗ್.
The appellant in RF number 1590 of 2011 / plaintiff. Granting 1/3 share in the properties mentioned in the judgment. The appellant has filed above application seeking the review of the review ಅಂತಾರೆ ಡಿಗ್ರಿ ಒಳಗೆ ಸೇರಿಸಿ ಅಂತ ಹೇಳ್ತಾರೆ. It's not exactly review also.
Review order dated 1/2/2023, my lord, application, my lord. Passed on IA number 1 of 20. In our
2020. You are 2020. So that was another review application.
one review application.
IA number 1 of 20 was rejected.
IA number 1 of 20
he
was
is seeking
rejected.
a review of that
Review
order.
of that order.
Correct. 1/2/2023. Justice Suresh Kumar.
1/2/2023 order is under review.
Seeking review of the said judgment and the order, judgment and decree. The appellant plaintiff filed IA 1 of 2020.
Seeking amendment of decree.
This court by judgment dated 1/2/2023 reject ಮಾಡಿದ್ದಾರೆ. Rejected the said application. This is the successive application.
Not successive, my lord. My lord, you may kindly take the third page of the affidavit, my lord.
Yes, sir.
I pleaded.
Application
ಅಲ್ಲಿಯರ್ ಒಂದು ರಿವ್ಯೂ ಹಾಕಿದ್ದು ಅದು ವಿಡ್ರಾ ಮಾಡ್ಕೊಂಡ್ರು ಮತ್ತೊಂದು ಅಪ್ಲಿಕೇಶನ್ ಅದು ಇದೆ.
ಇಲ್ಲ.
In that application, he had sought to inclusion of properties.
Yes.
That was rejected.
Yes.
So it virtually this application is a successive
My
application.
lord, may kindly take up my application affidavit. I've narrated.
Against that he went.
But prayer ಅಷ್ಟೇ ಹೇಳಿ.
ಅಲ್ಲ prayer correct.
Prayer same ತಾನೆ.
ಅಲ್ಲ ಫಸ್ಟ್ ಇದರಲ್ಲಿ ಅಮೆಂಡ್ಮೆಂಟ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ವಿ, ಅಪ್ಲಿಕೇಶನ್ ರಿಜೆಕ್ಟ್ ಆಯ್ತು, SLP ಹಾಕಿದ್ವಿ, ಲಿಬರ್ಟಿ ತಗೊಂಡು ರಿವ್ಯೂ ಹಾಕಿದೀವಿ ಅಷ್ಟೇ.
ಲಿಬರ್ಟಿ ತಗೊಳ್ಳಿ ಆದ್ರೆ it is virtually the successive review application.
No. This is that was originally seeking amendment of decree only, no review application. Not successive.
Illi ನೀವು decree ನ amend ಮಾಡೋದಕ್ಕೆ ಕೇಳ್ತಾ ಇದ್ದೀರಲ್ಲ, even here you want.
Here the application is for review.
Correct.
20.
By review, what are you seeking?
Amendment.
Again to.
Consider my IA. Consider my IA number 1 of 20.
Virtually IA 2 of 2023 is the successive application for review. Though it is in the garba seeking the review of the order dated 1/2/2023, since there is a very 90 days delay ಆಗುತ್ತಾ ಇಲ್ಲಿ.
Also.
Actually, there is delay in filing the said application. Application. Liberty ಕೊಟ್ಟು ಇವರಲ್ಲಿ ಅವರು entertain ಮಾಡೋದಿಲ್ಲ ಅಂತ ತಕ್ಷಣ ಹಿಂಗೆ ಹೇಳಿ ತಗೊಂಡ್ಬರ್ತಾರೆ. ಅಲ್ಲಿ ಏನ್ ಮಾಡಿರ್ತಾರೆ, ಜಸ್ಟ್ ಇವರು ಇದನ್ನ ಡಿಕ್ಕಿ ಮಾಡೋದ್ರಲ್ಲಿ ಒಂದು ಎಂಬಿಗ್ಯೂಟಿ ಆಗಿದೆ ಅಂತ ಹೇಳಿರ್ತಾರೆ ಅಷ್ಟೇ. Also, it is submits that problem lies with the drawing of the decree by the registry, as despite the order passed, the registry was not including those properties in the decree. ಅಂದ್ರೆ ಮಿನಿಸ್ಟೀರಿಯಲ್ ಆಕ್ಟ್ ಅಲ್ಲಿ ಮಾತ್ರ ತೊಂದರೆ ಆಗ್ತಾ ಇದೆ ಅಂತ ಹೇಳಿರ್ತಾರೆ, ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಅಂತ ಹೇಳಿರೋದು. ಅಲ್ಲ, ಈ ಆರ್ಡರ್ ಯಾವತ್ತಾಗಿದ್ದು? SLP this order was SLP order ಆಗಿದ್ದು ಯಾವತ್ತು ಅಂತ ಕೇಳಿ.
1/2/23.
When this SLP order was passed?
8/5/2023.
8/5/2023. So ಇದು you had challenged this order dated 1/2/2023.
Yes,
1/2/2023.
Judgment ಅಲ್ಲಿ ನಾವೇನು ಚೇಂಜ್ ಮಾಡ್ತಾ ಇಲ್ಲ. ಡ್ರಾ ಮಾಡೋದ್ರಲ್ಲಿ ಮಿನಿಸ್ಟೀರಿಯಲ್ ಆಕ್ಟ್ ಅಲ್ಲಿ ರಿಜಿಸ್ಟ್ರಿ ಸ್ಟಾರ್ಟ್ ಅಕ್ಸೆಪ್ಟಿಂಗ್ ಅಂತ ತಕ್ಷಣ ಹಿಂಕಾಸಿದ್ದಾರೆ. Was not including in the decree. If that be so, that is not reflected in the impugned order. None of us. Successive review. Application 11 classification case with application seeks to withdraw the special litigation. I number 1 of 2023 is for seeking condonation of delay of 90 days. Heard both sides. By the there is no dispute that parties had filed IA number 3 of 2011
Oh, 2011.
pending this appeal for seeking amendment of the plaint to include
19 items of the property.
following including following the consent order once again clarity.
19 items.
19 properties. Some application is ಹಾಕೊಂಡಿದೆ 19 properties. Okay. Though while passing the judgment dated 25/1/2014,
24/1.
2014, this court did not dispose of the said application. Appeal was disposed of on merits. Reading of para 13, 17 of the other. Reading of para 17. Reading para 17 of the said judgment reads as follows. 17 have come down. 17. After 17, 19 ನಲ್ಲಿ 12 ಇದೆ ಅಲ್ಲ
19 ಅಲ್ಲೂ ಲಾಸ್ಟ್ ಪ್ಯಾರಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ
ಹ್ಮ್.
ಸ್ಪೆಸಿಫಿಕ್ ಆಗಿ ಮೇಲೆ ಹೇಳಿದ್ದು
17 and 19 ಅದೆಲ್ಲ highlight
right to draw modified decree incorporating the aforesaid property.
ಕೊಂಡ್ಮೇಲೆ ಇಲ್ಲೆಲ್ಲ ಅಂಡರ್ಲೈನ್ ಮಾಡ್ಕೊಡ್ತೀನಿ ಮಾಡಿದ್ರು ಅದನ್ನ ಸ್ವಲ್ಪ highlight ಮಾಡಿ ಅಂತ emphasis applied ಅಂತ ಮಾಡಿದ್ರಲ್ಲಿ ಮಾಡಿದ್ಮೇಲೆ ultimately it was allowed holding that appellant is entitled to 1/3 share in the said properties. It says that appellant is entitled to inverted common to 1/3 share in these properties. Now an attempt is being made to contend that the appeal was allowed granting the share in all the application schedule properties.
Para 12 of my
Said,
review application. The affidavit para 12 and 13 may be considered.
First of all, the counsel for the applicants is not the counsel who argued the matter in 2014.
2014.
Judgment for that.
Against which you practice the petition, the application. Then
38 2000
sheet
ಅಲ್ಲಿ ಇರೋದಿಲ್ಲ, ಅದು ಇರೋದು. ಇದೆ. ಇದು decree ಇದೆ. This is only decree, it's not allowing the application. No, this is not decree. Concept ಅಂತ ಹೇಳ್ತೀವಲ್ಲ. It's also ಅದಕ್ಕಿಂತ ಮೊದಲು ಹಾಕೊಳ್ಳಿ. Subsequent to the judgment, the applicant filed IA 3 of 2011 and 1 of 2015 and 1 of 2019. ಅದನ್ನ ನಾನು ಕೇಳಿದೆ ಅವಾಗ 1 of 2015 ಏನೋ 1 of 19 ಏನೋ ಅಂತ ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಬಂದಿಲ್ಲ. IA 1 dismissed as not pressed ಆಗಿದೆ. IA 1 of 2015 was for amending the decree, na?
ಹೌದು.
3 of 2011.
3 is original application.
3 of 2011 for amendment to include these 19 items.
In the
Then-
application, in the plain schedule. Correct. Subsequent. IA 3 of 2011. No, IA 3 of 2000 grounds 3 of 2011 seeking permission to amend the plaint in terms of
This IA 3 of 2011, he says, was not allowed.
ಹೌದು ಅದಕ್ಕೆ ಅಮೆಂಡ್ ಅಲೋ ಆಗ್ಲಿಲ್ಲ ಹಾಗೆ ಆರ್ಡರ್ ಮಾಡಿದ್ವಿ.
Pending.
I got the point. What he says is IA 3, so though it is bill is disposed of and some of it is considered, IA 3 was not allowed, disposed, plaint was not amended. ಅದಕ್ಕೆ plaint amend ಮಾಡೋದಕ್ಕೆ permission ಅಂತ ಹೇಳಿದ್ರು. IA 3 ತೆಗೆದು ನೋಡಿ ನನಗೆ IA 3 of 2011 ಇದ್ರಲ್ಲೇ ಇದೆಯಾ? You have the copy ಇದ್ರೆ handy ಇರುತ್ತೆ ಕೊಡಿ ನೋಡೋಣ.
IA number
3 of 2011.
3 is in the synopsis, my lord, I filed at page 22.
ಹೌದು IA 3 of 2011 is to amend the plaint only.
Amend the plaint only.
Correct only. So you sought permission to amend the plaint to
Originally.
include these properties.
Please.
Yeah.
Hello, sorry. IA 1 now. Yeah, 2011, as you said, right, it was pending, but IA 1 of 2019 was to amend those,
Carry out corrections accordingly.
you wanted to say that
It's a clarificate.
disposed of, but not disposed of.
It was deemed to be disposed of the clarificatory order with respect to 2019 order. IA was filed.
Please to accept the decree and annex to this application, direct the final decree to be proceeded. IA 1 of 2015.
This order is with respect to 1 of 2015. Order dated 38/2019 is with respect to 1 of 2015.
Filed IA 1 of 2015, seeking amendment of the decree. And IA 1 of 2019.
This is not pressed.
ಅಲ್ಲ ಏನ್ ಪ್ರೇಯರ್ ಏನಿತ್ತು ಎಷ್ಟು ಏನಾರ ಇದ್ರೆ ಅಪೀಲ್ ಮಾಡ್ಕೋಬೇಕಲ್ವಾ ಇದಾಗಿದ್ರೆ. You have the copy of IA 1 of 2019? 2021 ಸಿಗ್ತಾ ಇದೆ. 1 of 2015 ಇದೆ. ರೆಕಾರ್ಡ್ ಮೇಂಟೈನ್. You have the copy of IA 1 of 2019?
Yes.
IA?
IA number
1 of 19.
1 of 19 ಇಲ್ಲ.
What was your prayer in IA 1 of 2019? ಇದ್ರ ಮೇಲೆ ಇರ್ಬೇಕಲ್ವಾ? 15 ಆದ್ಮೇಲೆ ಬರ್ಬೇಕು 19.
So this is not pressed.
Expense ಆಗಿದೆ, but what was the relief sought in that ಅಂತ? Records ಕೊಟ್ಬಿಟ್ಟು ಅದು ಬರ್ಕೊಂಡು IA 1 of
Objection ಮಾಡ್ಬೇಕು ಅಷ್ಟೇ.
And IA? ಅದು 19 ಅದೇನನ್ನು ನೋಡಿ ಹೇಳ್ತಾರೆ ಸ್ಟ್ಯಾಶ್ ಹಾಕ್ಬಿಟ್ಟು ಹೇಳ್ತೀನಿ. This court by order dated 38/2019 held that court by order dated 38/2019 referring to para 7 of the judgment dated 2014. The judgment dated 28/1/2014 held that certain para 7 in sorry. Yes, out of the properties mentioned in IA 3 of 2011, certain properties were included in the judgment and However, the plaint was not amended. Therefore, unless and until the amendment is carried out in terms of I3 of 2011 to the plaint, those properties cannot be included in the decree. Therefore, the application was allowed. No.
Disposed of.
I3 of 2011 and IA1 of 2015 filed by the appellant plaintiff was allowed.
Not,
Allowed.
IA number 1 of 250 was not allowed, it was disposed of. Because allowed means we not allowed to give.
As a consequent to allowing IA3 of 2011, IA1 of 2015 filed by the appellant under section 152 to accept the decree annexed to the application is disposed of in terms of the other.
Because in the IA, he has sought to include all the these properties. That was not granted. True, but just I want clarification.
The applications were disposed of to accept the decree in terms of the said order. Said IA1 of 2019 was dismissed as not pressed. Please to allow to amend the application bearing number 1 of 2015. ಅದಕ್ಕೊಂದು amendment application application ಗೊಂದು amendment application ಅದು ಬರ್ಕೊಂಡಿದ್ರಲ್ಲ IA1 of ಕಾಸ್ಟ್ ಹಾಕ್ಬೇಕಾಗುತ್ತೆ ಇವ್ರೆ ನಾವು ಇದಕ್ಕೆ IA1 of 2019 ಅಂತ ಹೇಳಿದ್ವನಲ್ಲಿ ಅಂಡರ್ ಆರ್ಡರ್ 6 rule 17 CPC to amend IA1 of 2015. It includes certain properties. After subsequently, the appellant plaintiff filed IA1 of 2023 seeking 1 of 2023 review the order dated either 1 of 2023 CD ಅಂತ ಹಾಕಿರ್ತಾರೆ. He is seeking recalling of IA1 of 2023. Alva application.
IA1 20 is to amend the decree.
No. IA 2 of 2023 was to review the order.
True.
IA1 of 2023 was for condonation of delay.
Condonation.
He filed IA1 and 2 of 2023 for condonation of delay and seeking review of review of the order dated 1/2/2023.
Oh, the 1/2/2023 is the order and review.
Judgment was passed by Justice Dinesh Kumar our bench.
ಹೌದು
ಅದು ಈಗ ಹಾಕಿರೋ ಅಪ್ಲಿಕೇಶನ್ ಅಲ್ವಾ?
ಹೌದು.
ಅಲ್ಲ, IA1 of 20 was rejected.
ಅಪ್ಲಿಕೇಶನ್ ಹಾಕೊಂಡ್ರಲ್ಲ ಬಿಫೋರ್ ದಟ್ ವೆನ್ ದಿಸ್ 1/2/2023 ಹಾಕಿದ ಅಪ್ಲಿಕೇಶನ್ ಯಾವುದು?
That is to review.
No, that is not the review, that's an amendment seeking decree.
1 of 2020 sequence ತರೋದಕ್ಕೆ ಇಲ್ಲ ಅಂದ್ರೆ ಮತ್ತೆ 1 of 2023 seeking review of
He filed seeking amendment of the decree, which was disposed of.
sequence IA 1 of 2020 seeking amendment of the decree to include the properties mentioned in IA 3 of 2020.
Yes.
This court by judgment dated by order dated
1/2/23.
1/2/2023. Dismiss the application.
How are you getting it so fast? How are you getting it so fast? 1/2/2023 rejected the said application. Thereafter, the plaintiff has come up again with the above said applications seeking
He went to Supreme Court.
Supreme Court.
Challenging the said order, that is very inconsequential. The appellant approached the Supreme Court in special
SLP number 8574.
You have produced it along with these.
The application I have produced it, my lord.
Special leave,
Page 8.
leave to appeal into bracket C number 8574 of 2024. The said application, the said petition was disposed of on 8/5/2023. Reading of the said judgment shows that the appellant submitted before the Supreme, the Honorable Supreme Court that the registry is not drawing the decree ಅಂತ ಹೇಳಿದ್ರಲ್ಲ. Formally also. Which is evident ಅಂತ ಮಾಡು. ಏನು? Reading of appellant that not including certain properties, therefore review is required. The relevant para in page 2 of the said judgment reads as follows. Para 2 ನಲ್ಲಿ ಮಾರ್ಕ್ ಮಾಡಿರೋದಿರುತ್ತೆ ನೋಡಿ, ಅದನ್ನ ಹಾಕೊಂಡು. The Honorable Supreme Court held that ಎರಡು ಹಾಕಿದ್ದಾನೆ. The relevant paragraphs in page 2 and 3 of the said judgment read as follows. Reading of the above paragraphs clearly show that the Honorable Supreme Court reserved the liberty to file review application only to bring the decree drawn,
the judgment.
decree to be drawn in conformity with the judgment. After disposal of the appeal, the special petition, the above applications are filed. Again seeking condonation of delay and review of the order. Okay, next one. The first principle in case of review petitions is that indirectly he is speaking the review of the earlier. Along with the application. Submitted along with the application judgment.
Please, my lord.
This is your. ಕಾಪಿನ ಇದೆ, ಆಟೋಗ್ರಾಫ್ ಅಲ್ಲ. She so and so. Interpreting the judgment dated 2014 of the date. Submits that the appeal was disposed of. Para 19 ಅಂತ ತಗೊಳ್ಳೋಣಲ್ಲ ಇದಕ್ಕೆ. Para 19 of the judgment dated 28/1/2014 submits that the suit appeal was allowed in its entirety, including the properties which are sought to be included by way of amendment under I3 of 2011. Whereas she so and so counsel appearing for the respondent submits that para 19 has to be read in the context of the whole judgment. Para 17 and 18, para 17.
19 also, last para.
17 and 19 of the judgment shows that only the properties mentioned therein were, I'm sorry, the suit appeal was allowed, including only the properties which were conceded by the respondents.
He also agreed, plaintiff, appellant also, this petition also agreed at that point of time.
And the appellant agreed for the same. Agreed ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಅವರು agree ಆದ್ರು ಅಂತ plaintiff ಎಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ?
ಅಲ್ಲ, last parties, all the parties ಅಂತ ಹೇಳಿದ್ದಾರೆ. 17 para 17 last sentence Mila.
In these properties, plaintiff is entitled to 1/3 share. All the parties.
All the parties agree in 17 last sentence.
As agreed upon by all parties.
Okay, plaintiff also agreed only for those properties, those additional properties considered and reflected in para 17 of the judgment. Now it is not open to him to seek the review of the order. Review of the next one. The reading of paragraph 17 to 19 of the judgment shows that the parties, though how many properties were tried to be included? Though 19 properties were sought to be included by way of amendment, the respondents conceded only for the properties at serial number 1, 5, 8, 1.
Serial number 1.
5 to 9.
5 to 10 Mila, 8, 8 1/3 share.
5 to 10.
5 to 10, in that out of item number 8.
So 5 to 7, 9 and 10
Yes.
exclusively.
Yes, yes.
5 to 7, 9 and 10. 10.
And item number 8, 1/3 share.
ಅಲ್ಲ ಅವ್ರಿಗೆ ಇರೋದೇ ಶೇರ್ ಅಷ್ಟೇ ಅಲ್ವಾ? ಒಂದೆರಡು ಇದೆ.
ಅಲ್ಲ, ಉಳಿದ
These properties are.
ಅಲ್ಲ, ಹಾಗಲ್ಲ. In item number 8, the father, the Karta had only 1/3 share, and 2/3 share belongs to other members of the other family because his brothers, cousins were there. It's for that in item number 1, to include 1/3 share in item number 8. Adರಲ್ಲಿ 1/3 share he has got.
ಕರೆಕ್ಟ್. ನಾನು ಹೇಳ್ತಿರೋದು ಈ ಐಟಮ್ ನಂಬರ್ 7 ಎಷ್ಟರಿಂದ
8, item 8.
ಅಲ್ಲ 1 to 1 and 5 to 7. 9 and 10 ಅಲ್ಲಿ 1/3 share ಗೆ
Correct. And in item number 8, 1/3 share out of 1/3 share of the father.
Though he included properties 1 to
1, 5,
19, the respondents conceded for 1/3 share in item number 1,
5 to
5 to
7,
7,
9 and 10.
9 and 10,
And
1/3 share in
Suit item number 8.
1/3,
third share out of 1/3
yes,
in survey number in item number
8.
item number 8 property.
Lord, it reads like this, my lord. Out of 1 acre 10 guntas, first defendant is having 1/3 share in survey number 65/3 of Sirigunda village. This is how it reads.
First defendant is your father.
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 1/3 share out of 1/3. So first defendant there.
Asked.
First respondent was
Entitled.
held entitled to 1/3 share.
Correct.
Absolutely, there is no ambiguity in the order. And the judgment cannot be read to say that entire, I'm sorry, 1/3 share was awarded in entire item number 1 to 19 properties. Only to, only for the purpose, facilitate the drawing of the decree, IA 3 of 2011 was subsequently allowed only to include only those properties.
In the plain schedule.
Only those properties only. Considering the same, the review, IA 1 of 2023 is rejected. Rejected. It's also material to note that the counsel who is appearing, who has filed these subsequent applications, ಯಾವ್ದನ್ನು 1 of 2023 ಮಾಡಿದಾಗ್ಲೂ ನೀವೇ ಇದ್ರು ಕೂಡ you are not there.
ಇಲ್ಲ 20
1 of 23 ಅಲ್ಲಿ ಇದ್ರಿ ಆದ್ರೆ ಮೇನ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡುವಾಗ
ಮೇನ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ನಾನಿಲ್ಲ.
The counsel who has filed IA 1 of 2023 and the subsequent applications was not the counsel who argued the matter when the judgment dated 2014 judgment was passed. Therefore, he will not, he has no personal knowledge of what was considered and how, why, how the order has to be interpreted. Even in the absence of that, the reading of the main judgment shows that only the aforesaid properties were considered and judgment was passed, granting share to the plaintiff only in those properties. Absolutely. Deemed to be allowed. ಹೌದು, ಯಾಕಂದ್ರೆ ಪ್ಲೇಂಟ್ ಅಮೆಂಡ್ ಮಾಡ್ಬೇಕಾಗುತ್ತೆ ಅವರು. ಬಟ್ ಶೇರ್ ವಾಸ್ ಗಿವನ್ ಓನ್ಲಿ. ಅದಕ್ಕೆ ಅಲ್ಲಿ ಹೇಳಿದ್ದಲ್ಲ ನಾನು ಫೆಸಿಲಿಟೇಟ್ ದ ಏನಂತ ಹೇಳಿ. ಈಗ ಅವ್ರು ಏನ್ ಮಾಡ್ತಾರೆ, ಡಿಗ್ರಿ ಮಾಡೋವಾಗ ಪ್ಲೇನ್ ಶೆಡ್ಯೂಲ್ ಅಲ್ಲಿ ಇದಿದೆ, ಶೇರ್ ಕೊಟ್ಟಿದ್ದಷ್ಟು ಅಂತ ಸಪ್ರೇಟ್ ಡಿಗ್ರಿ ಮಾಡ್ತಾರೆ, ಎಲ್ಲಾದ್ರಲ್ಲೂ ಮಾಡೋದಿಲ್ಲ. ಹೌದು. ಯಾಕಂದ್ರೆ ಡಿಗ್ರಿ ಮಾಡಕ್ಕೆ ಬರೋದಿಲ್ಲ, ಅಲೋ ಆಗಿರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಅದ್ರ ಸಲುವಾಗಿ ಅಲೋ ಮಾಡಿದ್ದಾರೆ. ಎಂತ ಬರ್ಕೊಂಡ್ರಿ? ಓನ್ಲಿ ಟು ಬ್ರಿಂಗ್ ದ ರೆಕಾರ್ಡ್ಸ್ ಇನ್ ಆರ್ಡರ್ ಅಂತ ಹೇಳ್ಬೋದು, ಯಾಕಂದ್ರೆ ಪೇಂಟ್ ಅಲೋ ಅಮೆಂಡ್ ಮಾಡ್ಬೇಕಾಗತ್ತಲ್ಲ. ಆಯ್ತು okay. IA 3 of 2011 was by order dated 30/8/2019. It was said that IA 3 of 2011 was deemed to be allowed, apparently to bring the to facilitate the appellant to amend the plain only, and not for granting share in those in all the properties. All the properties. Absolutely, there is no error apparent on the face of record or any other ground to review the order. Okay, ಬರೋದಿಲ್ಲ, ಯಾಕಂದ್ರೆ once he had filed, he had lost. One he had filed, but ಇನ್ನೊಂದ್ಸತಿ ಹೋಗಿ ಹ್ಯಾಂಡಲ್ ಕೊಟ್ಟಂಗೆ ಇನ್ನೊಂದ್ಸತಿ ಫೈಲ್ ಮಾಡೋದಕ್ಕೆ ಬೇಡ. ಕ್ಲೈಂಟ್ ಅಲ್ಲಿ ಒಂದ್ಸರಿ ಬಂದ್ರೆ ಇಟ್ ಇಸ್ ಪಾರ್ಟ್ ಆಫ್ his remedies elsewhere ಅಂತ ಇವನ್ ಅದು ಬೇಡ. But in the guise of the review, in the guise of the review, the appellant is seeking the amendment of alteration of the judgment itself, which is impermissible. Therefore, ಸ್ವಲ್ಪ ಕಾಸ್ಟ್ ಹಾಕೊಂಡ್ಮ ಇಷ್ಟು ಕೆಲಸ ಮಾಡ್ಸಿದ್ರಿ ನೋಡಿ, 45 minutes. You go to the Supreme Court, come here, and you go to the Supreme Court and say that it's only a clerical or ministerial act.
That is what is my contention from the beginning, my lord.
Ministerial act.
My understanding was the judgment was para 19 you have given me.
the aforesaid facts and circumstances clearly show that the appellant plaintiff is driving the parties, the other, his adversaries to multiple
Lord,
proceedings,
we haven't, my lord.
which is nothing but abuse of the process of the court. Therefore, application is allowed and, allowed, rejected. Applications are dismissed on payment of cost of 10,000.
Lord,
Payable to respondent number
1 and 2 million. LRs of 1 and
one
Lord,
A,
cost
B,
may be waived off, my
and
lord.
two. Together you are entitled to 10,000.
But cost may be waived off, my lord. We will.
There should be some limit for
Lord,
doing anything. You can
whatever-
the process of the court like this.
Till number 19, Mushtaq Ahmad, Mohan Kumar T for R2.
Yes, sir. Climate, madam. Claimant's appeal, madam. Yes, of death. Death of bachelor, madam. The tribunal has awarded rupees 8,16,000.
R2 is United India Insurance. Sir.
And for the insurance company, my lord.
25 days delay there. What
Ah,
is
ಮಾಡ್ಬೋದು.
partly allowed? 8,16,000. Case of
Death, madam. Death of bachelor.
25 days is the delay condoned.
ಡಿಲೇ ಕಂಟ್ರೋಲ್ ಮಾಡು.
Lesson 2024. Not accepting the reasons assigned to explain the delay of 25 days in filing the appeal is condoned in the interest of justice. What is that RJ report? Report ಒಪ್ಪಾಲತ್ 6 ಗೆ ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ. The report of service beginning the report of service judicial is taken.
Lord, with regard to delay, my lord, may I make one submission?
One second. Concern is the registrar directed to be vigilant henceforth.
Lord, this appeal, my lord, was filed on 12/2/2018. My lord, the office objections file, my lord, was not complied with the appellant. My lord, it was dismissed on 13/2/2020 for non-prosecution. Thereafter, my lord, a review petition was filed, my lord, by the appellant. That came to be in review petition number 264 of 2022, which was allowed, my lord, on 21st June 2024. Therefore, my lord, is not entitled for, my lord, interest in the event of any enhancement in this case. My lord, is not
During that
entitled for
period,
it.
The appeal was dismissed on the ground of limitation instead of giving an condonation delay application. Correct. When they filed it in 2018, only 25 days delay was there, no?
ಅವಾಗ 25 days delay ಇತ್ತು. So subsequently, for 2 years, he did not comply the office objections. It was dismissed for non-prosecution.
2022 ಆದ್ಮೇಲೆ ಪುನಃ ಕಂಪ್ಲೈ ಮಾಡಿಲ್ವಾ?
ಅಲ್ಲ, ಈಗ 13/2/2020 ನಲ್ಲಿ
Complied,
was dismissed.
complied.
So thereafter complied, but review petition was allowed, my lord, after 4 years. It was filed.
It's allowed, man. It's allowed.
Because of his fault for that period, then he is not entitled from. ಇಲ್ಲ ಅದ್ರಲ್ಲ ಏನ್ ಮಾಡಿ.
Interest is not waived in that order.
ಇಲ್ಲ ಅದ್ರ ಬಗ್ಗೆ ಏನು ಹೇಳಿಲ್ಲ ಅಲ್ಲಿ. Since, my lord, the observation in that matter, my lord, there was no.
Cost ಹಾಕಿದ್ದಾರೆ 2,000 rupees.
Cost.
Have deposited.
To comply the office objection.
ಕಾಸ್ಟ್ ಒಂದು ಹಾಕಿದ್ದಾರೆ, ಅದು ಡಿಲೇ ಬಗ್ಗೆ ಏನು ಹೇಳಿಲ್ಲ.
Cost revoked petitioners are not entitled to interest if they succeed in MFA by enhancing the for the period of dismissal till restoration ಅಂತ ಮಾಡಿದ್ದಾರೆ.
ಹೌದು.
ಅಷ್ಟೇ ಅದು ಸಬ್ಜೆಕ್ಟ್ ಆರ್ಡರ್ ಅಂತ. Condone in the interest of justice, subject to the terms of interest as stated in order dated 21/6/2024. ಅಷ್ಟೇ ನಿಮ್ಗೆ ರಿಸ್ಟೋರ್ ಆಗೋವರೆಗೂ ಬರೋದಿಲ್ಲ.
Case of death, my lord.
To interest. Okay,
Case of death of 21 years by bachelor, my lord.
What is the point involved?
My lord,
ಏನು notional income
notional has considered.
ತಗೊಂಡಿದ್ದು ಕಡಿಮೆ
ಇಲ್ಲ.
ಇದೆಯಾ?
Notional has a considered, but he is a diploma. He studied diploma in information and technology, my lord.
Who did you examine to prove his
I produced the certificates, my lord.
certificate produce ಮಾಡಿಬಿಟ್ರೆ sufficient ಆಗುತ್ತೆ ಇಲ್ರಿ?
I completed me
Spot master, Aadhaar card, ration card. ID card ಅಷ್ಟೇ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ರಿ. ಯಾವ
No, no.
ಸರ್ಟಿಫಿಕೇಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ರಿ?
7 marks exhibit P12, 7 marks cards, my lord.
ಹಾ, ಮಾರ್ಕ್ಸ್ ಕಾರ್ಡ್ ಯಾವುದು ಯಾವ
Diploma those.
ಅದನ್ನ ಅವ್ರೇನು ಹಾಗಾದ್ರೆ admit ಮಾಡ್ಬೇಕಾ? solve ಮಾಡ್ಬೋದು. If he insists that his age was 17 years.
21 years.
21.
Actually,
He had completed diploma.
yes, my lord. Certificate copies produced, my mark right.
What was the diploma? ಆಯ್ತು ಹೇಳಿ, ಯಾವ ಡಿಪ್ಲೊಮಾ ಮಾಡಿದ್ರು ಅವರು?
Diploma in Diploma Information and Technology, my lord.
ಅವ್ರಿಗೆ ಇನ್ಕಮ್ ಬಗ್ಗೆ ಮತ್ತೇನಾದ್ರೂ ಪ್ರೂಫ್ ಏನು ಇಲ್ಲ ಎಕ್ಸೆಪ್ಟ್
ಅಲ್ಲ ಇನ್ಕಮ್ ಬಗ್ಗೆ ಏನಿಲ್ಲ. I have claimed 20,000, my lord.
ಲೋಕದಲ್ಲಿ ಸೆಟ್ಲ್
ಇಲ್ಲ
ಆಗ್ಲಿಕ್ಕಿಲ್ಲ.
ಆಗಲ್ಲ ಸ್ವಾಮಿ. ಇನ್ಕಮ್
Meet call parties. List of receipt of receipt.
Till number 20, Rajaram S. MV Punacha Pratri.
There is no liability against the respondent, one, my lord. I am filing dispensation memo. ಬರೀತೇನೆ.
Only R1 was not, sir. R2. R1 ಗೆ ನೋಟಿಸ್ ಹೋಗಿರ್ಲಿಲ್ವಾ?
ಇಲ್ಲ ಸರ್,
Notice was not ordered.
ಇಲ್ಲ 3 ಜನರಿಗೂ ನೋಟಿಸ್ ಹೋಗಿತ್ತು,
Appeal against
ಇದಾಗ್ಲಿಲ್ಲ.
R1 dismissed ಅಂತ ಇದೆ ಮೇಡಮ್.
ಮತ್ತೆ ಡಿಸ್ಮಿಸ್ ಆಗಿದ್ರೆ ಹೇಗೆ ಡಿಸ್ಪೆನ್ಸ್ ಮಾಡೋದು?
ಮೊದಲು ಬರ್ದೈತೆ.
ಹೋಗ್ಬೇಕಲ್ಲ ನೀವು.
ಹೌದು ಸರ್. LCR,
ಡಿಸ್ಮಿಸ್ ಆದ್ರೆ ನಾವ್ ಹೇಗೆ ಡಿಸ್ಪೆನ್ಸ್ ಮಾಡಕ್ ಬರುತ್ತೆ?
ಅದನ್ನೇ ಸಿಟಿ LCR may be called, my lord. LCR may be.
ಕಾಲ್ ಮಾಡೋದು. ಡಿಸ್ಮಿಸ್ ಆಗಿ ಸಬ್ಜೆಕ್ಟ್ ಟು ಇದು ಅಂತ ಮಾಡ್ತೀವಿ, ಬಟ್ ಯು ಹ್ಯಾವ್ ಟು ಫೈಲ್ ಅನ್ ಅಪ್ಲಿಕೇಶನ್ ಟು ರಿಕಾಲ್ ದಟ್ ಆರ್ಡರ್. ಡಿಲೇ ಇದೆ ಅಲ್ಲ? ಪೂನಚ್ಚ ಸರ್,
MV Punacha.
118 days.
Please, my lord.
Jury.
ಹೌದು, ಇಂಜುರಿ ಸ್ವಾಮಿ.
Orders and I1 of you file necessary application for recalling.
Please, my lord.
R1 is the owner of the vehicle.
Please, my
Is the owner of the vehicle. Liability ಯಾರ ಮೇಲಿದೆ?
there is insurance company ಮೇಲೆ ಇದೆ ಸ್ವಾಮಿ ಅವರೇ.
Third respondent is directed to depositor.
ಹೌದು ಸ್ವಾಮಿ.
For considering the reasons assigned to explain the delay, delay of 118 days in filing the appeal is condoned in the interest of justice. I1 of 19 is disposed of accordingly. Admit all parties, yes, list of receipt of cases.
Sivadasam A.
Application for early hearing, Manoj,
Who has filed?
filed by the petitioner.
Appellant or petitioner? Appellant. What is
Parties.
sufficiency?
Manoj, he wants to remarry. He's already 53-year-old. And they've been living separately for 12 years. As on date, Manoj.
But there are many other people who are in queue to remarry.
Please, Manoj.
In
No, Manoj,
other cases,
this matter,
they
Manoj, is covered by a judgment of the Delhi High Court, Manoj. Initially, they had filed a petition for mutual consent and the respondent withdrew that petition. Now, those Delhi High Court has held that if you withdraw a petition for mutual consent after agreeing to it, that itself is a ground for mental cruelty.
It was only cruelty, it was not. Just short judgment. Evidence ಆಗಿದೆ, ಗುರುಬಂದು. Records ಬಂದಿದೆಯಾ?
Petition was admitted in March 2022 and
Okay.
records was called for.
This for final hearing on.
There are only 4 documents that have been produced.
3-6.
3-6. I have 1 of 2021 to dispose.
Grateful.
Cell number 22. Varun Papi Reddy, Lakshmikant K.
ಇಬ್ರು ಇಲ್ಲ. ಅಪ್ಲಿಕೇಶನ್ ಇಲ್ಲೇ ಇದಾರಲ್ಲ, ಎಂ ವೆಂಕಟೇಶ್ವರ ಯಾಕೆ ಕುತ್ಕೊಂಡಿದ್ದಾರೆ ಅವ್ರದ್ದಲ್ವಾ ಅದು? 450
ಅಲ್ಲ, ಲಕ್ಷ್ಮೀಕಾಂತ್ ಕೆ.
6727 ಸರಿ.
Cell number 24.
ಇಬ್ರು ಇಲ್ಲ. ಟೋಟಲ್ ಮೂಡ್ ಅಂತಿದೆ, ಯಾರು ಮೂವ್ ಮಾಡಿದ್ದಾರೆ? ಇದರಲ್ಲಿದೆ ನೋಡಿ ಮೆಮೊ. ನನ್ನ PX ಯಾರೋ ಪಾರ್ಟಿ ಇದಾರೆ ನೋಡಿ. ಏನ್ ಹೆಸರು ನಿಮ್ದು? ಏನ್ ನಿಮ್ಮ ಹೆಸರು? ಎಲ್ಲಿ ನಿಮ್ಮ ಅಡ್ವೊಕೇಟ್? ಅಂತ ಆಗೋದಿಲ್ಲ ಬಿಡಿ. ಅಡ್ಮಿಟ್ ಆಗಿದಿಲ್ವಾ? ಬೋತ್ ಕೌನ್ಸಿಲ್ ಆಬ್ಸೆಂಟ್. ಲಿಸ್ಟ್ ಆನ್ ಆಫ್ಟರ್ ಅಪೆಲೆಂಟ್ ಮೂವ್ ಮಾಡಿ.
15-4. Cell number 23. AM Venkatesh, Shardamba AR, Sandhya D.
Claim for the impleading applicant, my.
Yeah, for the
I have
impleading.
received the copy, my lord. I want to file objections. I am furnishing the copy to the insurance.
I have received the copies. And
There are respondents 2A to B. Who was respondent number 2A? 2? Lakshmi. He was claimant number 2.
Please, my lord.
New record will ತರಬೇಕಾಗಿತ್ತು. When he died?
After the award, my lords, before.
ಹೇಳಿದೀರಾ ಇಲ್ಲ?
I have filed a memo, my lord.
Yeah, file.
I have filed a memo.
copy is not
ಅವ್ರು ಎಲ್ಲಾರ್ಸ್ ಅಂತ ಹೇಳ್ತಾರೆ ನೋಡೋಣ. ಡಿಲೇ ಅದು ಡೆತ್ ಸರ್ಟಿಫಿಕೇಟ್ ಅದನ್ನ ಮೆಮೊ ಹಾಕಿದೀನಿ ಅಂತ ಹೇಳ್ತಾರೆ.
In my appeal,
application, ಒಂದ್ ನಿಮಿಷ, including
I have also filed an appeal on behalf of the claimants.
to be died on 12/11/2021.
ನಾನು appeal ಹಾಕಿ.
Actually, ನೀವು ಇದು ಮೆಮೊ was filed in 2023. You should have filed application. ಅವ್ರು ಹಾಕೊಂಡಿದ್ದಾರೆ ನಿಮ್ ಬದಲು.
ಅಲ್ಲ, ತಾವ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಹಂಗೆ ಹಾಕ್ಬಿಡಿ ನೀವೇ ಒಂದ್ ಮೆಮೊ ಅಂತ ಆಯ್ತು. ಅವ್ರ ಸ್ಟೆಪ್ಸ್ ಬರ್ತಿತ್ತು, ಅದಕ್ಕೆ ನಾನೊಂದ್ ಮೆಮೊ.
Orders and number. You have any objection for allowing the LRs to come on record? ಅಲ್ಲ, ಡೆತ್ ರಿಪೋರ್ಟ್ ಆಗಿರೋದು 2021 ನಲ್ಲಿ.
One submission, my lord.
Death. Respondent number 2 was reported dead in 2021. She filed a memo in 2023.
No, one submission, my lord. I have filed an appeal on behalf of the claimants, my lord. One of the claimant died.
ನಿಮ್ಮ appeal.
ನಮ್ಮ appeal ಅಲ್ಲಿ ನಾನು ಅವ್ರನ್ನ ಪಾರ್ಟಿ ಮಾಡಿರ್ಲಿಲ್ಲ. Now the parents of that claimant wants to come on record. I want to file objections, my lord. Claim petition is filed on behalf of the parents and minor sister, my lord.
No, this Varadaraju, who was he?
Varadaraju was one of the claimant, father of the deceased who died in the accident.
Varadaraju was the father of the deceased.
Father of the deceased.
But if he dies, whatever was awarded to him, that goes to his heirs, alva?
ಅಲ್ಲ, ಆಲ್ರೆಡಿ ಆನ್ ರೆಕಾರ್ಡ್ ಮೇಲೆ ಹೆಂಡತಿ ಮಗಳು ಪಾರ್ಟಿ ಇದ್ದಾರೆ.
ಜಯಮ್.
ಹೆಂಡತಿ ಮಗಳು ಪಾರ್ಟಿ ಇದ್ದಾರೆ. ಅವ್ರ ಪೇರೆಂಟ್ಸ್ ಕಡೆಯಿಂದ ಹಾಕಿದ್ದಾರೆ ಅಪ್ಲಿಕೇಶನ್. ಅವ್ರ ಪೇರೆಂಟ್ಸ್.
His parents.
ವರದರಾಜು's parents.
Correct.
One submission, my lord. Compensation will be awarded for the loss of dependency, my lords. Dependents were the parents and the minor sister.
When award is passed, it becomes estate for him, for them.
Allah, let the application be pending. I will file my objections, my lord.
Application ಕೊಟ್ಟಿದ್ದಾರೆ ಈಗ, that is.
ಕಾಪಿ ಕೊಟ್ಟಿದ್ದಾರೆ ನನಗೆ, ಅವರಿಗೆ ಈಗ ಕೊಟ್ರು.
How much was awarded, paid, order to be paid to Varadaraj?
40% of the
40% of the award. ಅವ್ರ ಹೆಂಡತಿ
minor sister.
Wife was awarded 50% and the minor was
Jayalakshmi is his wife.
Varadaraj's wife.
Varadaraj's wife. How these people are?
ಅವರು claimants ಇದ್ರು, ಇವರು ಅವರು ತಂದೆ.
Varadaraj or Tande.
On the death of Varadaraj,
Please.
along with the wife, they also become legal representatives.
I will file my objections.
घर की
ಕ್ಲೈಂಟ್
कहानी
ಹೇಳ್ಬಿಟ್ಟು
ಅಲ್ಲ घर की कहानी daughter in law doesn't want to give it to the parents
ಇಲ್ಲ
in
ಇಲ್ಲ
law.
ಹಂಗಲ್ಲ ಅವರು ಅಲ್ಲಿ ಕ್ಲೈಮೆಂಟ್ ಇರ್ಲಿಲ್ಲ ಅದಕ್ಕೆ ಐ ವಾಂಟ್ ಟು ಫೈಲ್ ಆನ್ ಲೀಗಲ್ ಗ್ರೌಂಡ್ಸ್ ಐ ವಿಲ್ ವಾಂಟ್ ಟು ಫೈಲ್ ಅಪ್
Both counsels seek time file counter to IA 1 of 2020.
2 weeks time
List on
please
16 4. Till number 24, Kashinath JD, Kamraju.
Okay, there's so much of.
In this petition, my lords, GNWC petition has came to be dismissed on 3/6/2022, my lords. Against which, my lords, I have filed the review petition before the same court, my lords. Review petition number 1 of 2022 on 21/4/2023. That is came to be dismissed on 31 by
3/6/2022 was the date of judgment.
date of the order. Order.
Impugned judgment.
Impugned
When
judgment.
did you file the review petition? Have you produced a copy of that?
I have produced initially, my lords, but office has raised the objection that we have not.
What do you know?
Please.
RP number 1 of 2022.
1 of 2020.
When that was disposed of?
That came to
21/4?
post of on
21/4/2024.
24.
So High Court ಗೆ ಬಂದಿದ್ರಾ? 23. Confirmed by the judgment dated 3/6/2022. Correct? Adegi, you say here, thereafter family court by an order dated 21/4/2023 dismiss the review petition and confirm the judgment dated 3/6.
Please, ma'am, against which I have filed this MFA, my lords, but office has raised the objection that I have not.
Yeah. Appeal is filed on 31/5/2023.
31/5, my lords. That review petition came to be dismissed on 21/4/2023, my lords.
No representation from the respondent. Considering the explanation of the appellant for delay and the fact that he had approached. He was prosecuting the matter in review petition between
21/4.
3/6/2022, no? 3/6/2022 and 21/4/2023. The delay of 388 days in filing the petition is condoned in the interest of justice. IA 1 of 2024 is disposed of accordingly. Records call for madam.
Already records are
Admit list for final hearing of
final here.
after 4 weeks.
Till number 25, Govind Rai Kamath, Naveen Chandra V.
25 for the respondent and
Petitioner is
and
mother.
one
and the
minute,
respondent is the
father. And my lord's father has also filed number 27 cross appeal. Both can be taken together.
I'm not.
No, because it's come up for the first time.
Copy couldn't, you were ask your advocate.
No,
and
I'll
record
serve. No.
Same alwa, Gaussiya Begum.
Yes.
Yes, let's see.
27
Serial 27.
father has filed. I'm just handing over a copy. He can, my friend can.
Both counsels seek time to arrive at an understanding about.
Submission, my lords, as per the impugned order which both of us have challenged. Even if my lord sees my friend's petition, the operative portion is at page 33.
We'll ask him to take notice.
Yes,
By
please.
27. connected to each other. 2025. Is now.
Yes, I just want to make and the remaining 30 days, she can send the daughter or vice versa, whatever is convenient. If at least those dates can be decided, at least for the vacation, the children will be with each other and the other parent. And in the meanwhile, I'm sure with my friend, I can sit. Yes.
They're almost nearby, by the submission on to Abhishek, before this vacation is just now starting. Let the son be with the mother for the whole of the vacation, and
Yes, 30
Part
days.
of the vacation, they should be in another house. Yes. ಈಗ vacation ಎಲ್ಲ ಮುಗಿಲಿ ಆಮೇಲೆ
Yes, thereafter we can hear the matter.
when
They end in 25th May.
together, the children.
ಹಾಗೆ ಒಬ್ರಿಗೆ
are
ಯಾಕೆ
already
ಕೇಳಕ್
with brother and sister.
ಇಬ್ರು
And
ಎರಡು
father is in Mysore, he can
No,
travel
no,
to
no.
Bangalore. He
One
can
minute.
not stay. For
The
me, I don't have
vacation-
anything to stay in Mysore.
Vacations end on 1st of
With,
Jan, 1st of June.
ಅಲ್ಲ ಫಾದರ್ ಜೊತೆಗೆ ಯಾರು ಇರ್ತಾರೆ ಮದರ್
Father has the,
Son.
ಅವ್ರ ಫ್ಯಾಮಿಲಿ ಮೆಂಬರ್ಸ್
father has his parents. Father has his parents. In fact, if both children are sent 30 days, 30 days,
times you will repeat, no
Yes.
repetition. And mother, with mother who are.
I think her sister is there. I think her sister is there. There's no
Now,
difficulty.
let this arrangement with their, ಎಲ್ಲಿಂದ ಎಲ್ಲಿವರೆಗೂ ಇದೆ vacation, now it is started.
It started
Their vacation ends when?
1st of June, 2 months.
25 May 25th.
End of June.
2 months, whichever 30 days. In fact, the girls' vacation.
Next visitation arrangement soon after ಎರಡನೇ ತಾರೀಕಿಗೆ ಲಿಸ್ಟ್ ಮಾಡೋಣ.
Yes.
Now, let the half of time with one parent and the other half with one parent. And after second, we can make other
Yes.
arrangement.
Yes.
For weekend visitations. what
We
you
will,
say.
we can make our submissions.
I have not met my son on a regular visit other than festival.
You keep for first 30 days, sir.
Yes.
No, therefore.
They are offering
let me
now.
enhance the third son. I only.
No.
About 40
keep-
days.
you
at
keep
least
first 30 days.
At least for the first.
ಅಲ್ಲ, the same way.
Even I have not met my daughter.
It is not with the daughter. ಅಲ್ಲ ರೀ ನೀವ್ ಹೇಳೋದು ಈಗ ಸನ್ ವಾಸ್ ನಾಟ್ ವಿತ್ ಹರ್ ಅಂತ ಹೇಳಿದ್ರಲ್ಲ, ಸೇಮ್ ವೇ ಡಾಟರ್ ವಾಸ್ ನಾಟ್ ವಿತ್ ಹಿಮ್. ಯಾ ಪಾರ್ಟೀಸ್ ಗಿಂತ ನೀವು ಜಾಸ್ತಿ ಇದು ಮಾಡ್ಕೊಳ್ಳೋದು ಬೇಡ, ಹಾಫ್ ಆಫ್ ಟೈಮ್ ತಗೊಳ್ಳಿ. ಎಷ್ಟು ಡೇಟ್? ಫಸ್ಟ್ ಮೇ ಇಂದ ಫಸ್ಟ್ ಜೂನ್ ವರೆಗೂ.
They said they will send us. I sent my daughter and the order said it is a reciprocation. ಮೊನ್ನೆ ಕಳ್ಸ ಇಲ್ಲ ಸ್ವಾಮಿ.
My lord, now anyway, months are there. Let us,
Apart from the court order, let us have some.
no, 100%.
This time they are not sent.
ಆಯ್ತು, ಅದೆಲ್ಲ ಆಗಿರೋ
100%, some settlement must be worked out. I feel let the vacation finish. I will sit with my friend and try and see if we can work out some common. We have definitely no difficulty. So many other settlements we have
See,
coordinated.
In the 10 days, to send them extra 10 days, whether your client has any reservation?
No,
Or 5
whatever
days,
it
10
is,
days?
no, over and above that,
Okay.
no. In fact, over and above that, the schools start.
One thing, one thing. Now we are in May.
Even he has not seen his daughter.
Agree.
Even he has not seen his daughter. Let the 30 days happen. 25th, the daughters, sir, I'm not, if you don't even let me complete. 25th May, the daughter's vacation, school reopens. 1st June, the son's school will reopen. There is a,
You said both of them vacation.
No.
Will be over by June 1st.
no, 1st June, daughters is about 1 week shorter. Is about 25th of May, 1 week shorter. Now, let the, let,
If the first part they are with the father.
With the
second
father.
part they can be with the.
and then till 1st of June, he
She's
can be
She's
there.
studying in Mysore, girl is studying. Daughter
Girl is in Bangalore.
girl
Son is in
studying.
Mysore,
Daughter is in Bangalore.
Daughter is,
Yeah.
mother stays in
Bangalore.
Bangalore. Bangalore. Anyway, mother and both, she can be here with her sibling.
First 5 weeks may be granted.
No, why?
Not ಹೇಳಿದ್ವಿ ಅವ್ರಿಗೆ. If
So
they
why
are
should
very
they-
magnanimous, we.
No, why should there be, if in their own, if they agree, that's different. Why should it be unequal?
ಒಂದ್ ನಿಮಿಷ ಇರಿ. He was saying that even though there was an agreement that during festival days he should be sent, he was not sent.
Both
So
didn't,
send me for
both were
5 days.
deprived. My lords, both were deprived during the festival
Both are
time.
deprived.
Yes, ultimately both lost
Both.
out, which is sad. Let now the vacation be 50-50. As my lord said, since the girls' vacations are little short, let she come to the father now. Second half till 1st of June, he will send the.
That the vacation of the son has started. Both
Son's
children.
vacation has started now. It is till 1st of
Daughters
June.
started
Daughter
in
started 10 days ago. Daughter's vacation started 10 days ago.
Both children are in vacation now.
Yes,
School vacation now.
yes.
Learn counsel for Srimati So-and-so, learn senior counsel for respondent father submits that both children can stay with one parent for half of the vacation and the other parent in the rest half of the vacation. Learn counsel for the apparent mother submits that the son was not sent for Ramzan festival. Therefore, mother, I'm sorry, the children may be permitted to remain with the mother for a little longer time. The respondent is not agreeable for that. The daughter who is staying with her mother in Bangalore ends by 25th May, June.
Yes.
25th May.
25th May, the daughter's vacation ends.
Under the circumstances, the both children. The father let the father send first the son.
No, we don't mind, but because
Other-
her vacation ends
Her vacation,
early,
correct.
let her come,
Let-
then the son can be till 1st
Both
June.
children shall be in the custody of daughter's vacation ends early.
Early, so she can
The
come
custody
now.
of Respondent father, he is respondent.
Yes, 1st to
On
30th
father.
April,
From
1st April to 30th April.
April to 30th.
30th April.
31st in the.
Plans for initial holidays. Other had planned. So
ಏನದು
the first
what are the plans?
to take the children out.
ಏನದು what are the plans? ಇದೇ ದೇಶದಲ್ಲ ಇನ್ನೊಂದ್ ದೇಶದಲ್ಲ ಹೇಳ್ಬೇಕಲ್ಲ. They cannot have, I mean. ಏನೋ ಇದ್ರೆ ಏನಂತ ಹೇಳ್ಬೇಕಲ್ಲ. ನೀವ್ ಯಾವ್ದಕ್ಕೂ ಒಳ್ಳಿಲ್ಲ ಅಂದ್ರೆ ಆಗೋದಿಲ್ಲ. ನೀವು ಹೇಳಿ what are the plans? You please tell us what are your plans? Then we'll decide accordingly. That you do not know.
Based on her holiday also, the weekends plan or not put it. In that way I was making it.
No, weekend plan, they can do weekends in the second half when the daughter is, when the
Daughter's
son is
exam.
sent.
Daughter's holidays are limited, no 25.
No, but daughter's holiday, in fact,
But he is not able to tell what are her plans.
they don't have any
Weekend
plans, only
visa,
some
passport
weekend
visa
plans if they
ತಗೊಂಡು
have.
ಅದ್ ಹೇಳಿ. ಆಗೋದಿಲ್ಲ ಅದೆಲ್ಲ ಇಷ್ಟು. In Bangalore. She is in Bangalore.
She is in Bangalore, I am in Mysore. So she can be
Shall we-
sent to,
Respond mother, respond father. Okay, per so and so period. Okay. From 31st May ಇಂದನೇ ಶುರು ಆಗುತ್ತೆ. From 31st
from-
May. 31 days ಅಲ್ವಾ ಅವಾಗ May ನಲ್ಲಿ.
yes, yes.
From 31st May to till ಯಾವಾಗ ವೆಕೇಶನ್ ಆಗುತ್ತೆ?
Sorry. First May,
30th 31st April.
for her. Some 3-4 days she has to be early.
first May.
May ಅಂತ ಹೇಳ್ತಾ ಇದ್ದೀನಿ ನಾನು.
No, first May he can drop her back. with the son.
ಇವತ್ತು ಆಲ್ರೆಡಿ ಫಸ್ಟ್ ಏಪ್ರಿಲ್ ಇವತ್ತೆಲ್ಲ
He can go pick her up because if this month she comes, he's here, he'll go pick her up, take her till 30th May, April.
ಫ್ರಾಮ್ ಅಂತ ಹೇಳೋದಿಲ್ಲ, ಟಿಲ್ ಅಂತ ಹೇಳ್ತೀವಿ ಅಷ್ಟೇ.
Till.
Till 30th April 2000. Both children shall be in the custody of the father.
Father.
Till 30th April
Yes.
2025. Okay. On 1st May,
He'll drop them, both them back.
he shall drop both the children at the house of the mother. And
Till
the-
31st May, till
Both
30th May.
The son shall, daughter anyway with him. No?
Yeah.
Her.
Yes, yes.
Both children, both children. The son shall be in the custody of the mother till 31st May.
Yes, yes,
31st May.
yes.
Anyway, daughter is already in the
Yes,
custody of the
yes.
mother. On 1st June, the father shall pick up the son.
31st May he'll pick up because next day is the school.
On 31st May evening,
He'll pick up.
at 5 PM, he shall pick up
Yes,
the
yes.
children.
And today he can pick up the daughter.
I have to give them instructions for ENM.
Yes.
Please,
Yes,
just
today
timing
he can pick up.
Maybe tomorrow.
You can pick up tomorrow. He has come from Mysore.
Mysore is not in some
No,
other
no, I
country.
know.
Where is your?
No, but
See,
he's not staying here.
Staying there,
Sorry,
not
he is
here.
not staying
Okay.
here.
But
He can be
see,
No, no.
she doesn't come. What she is doing?
She's working. They both.
What is that work?
IT, they are both IT engine.
There are
IT.
no other complaints against each other.
In fact, there is nothing else, my lords. There is nothing. She has made the complaint. In fact, to be frank,
Pending.
she has filed a complaint of domestic violence. In fact, that domestic violence complaint states that nothing has been found.
Corrective merits were having.
No, no, we are not going on
No
merits.
coercive methods like police.
No,
498
no, no,
and that
no,
they-
none of
then
that is there.
Why don't they, why can't they patch up?
In fact,
Probably
we
senior
can
advocate.
definitely, we will work on it, my lords, 100%.
Try for a
We will
mediation.
definitely
Some
try.
Children.
Two children,
Then
we will
children.
definitely try, my lords.
It will
I'm
spoil the
only-
life of the children. ಈಗ,
Exactly.
See, when you come for practice to the bar association or when we come to the office, we have so many differences with so many people here, but still we come and go at least.
No,
like that
definitely
we
it can be
leave, no?
worked out. It can definitely be worked out.
Both of us are
Yes.
positive in-
100%. Let my friend, he
ಏನಾದ್ರು ಇದ್ರೆ ಅವ್ರಿಗೊಂದು ಹೇಳಿ
he
adjust
does not have a place to stay.
start.
He has come
Second,
from Mysore.
ಮಾಡ್ತಾರೆ.
Let him take the daughter today.
Not today. Have to
No,
inform them.
ಏನಾದ್ರೂ ಸ್ವಲ್ಪ ವ್ಯತ್ಯಾಸ ಇದ್ರೆ
We meet them itself in the evening.
ಈವ್ನಿಂಗ್
Evening only he'll go and pick up the daughter.
ನೋಡಿ
He has
ನಿಮ್
come
ಪಾರ್ಟಿ
from there.
ಬರ್ಬೇಕಾಗಿತ್ತು ಬಂದಿಲ್ಲ. She cannot impose so many conditions even to the court also. By evening ಅಂತ ಮಾಡಿ.
Yes, by evening.
ಯಾರು?
Yes.
Appellant mother shall hand over the custody of the children. So daughter, only daughter has to be picked up by.
Yes, yes.
By evening, today evening at 5:30.
Whatever time. Yes, there's no
5:30
difficulty.
27 is done.
Can be taken maybe second week of June.
After vacation, second.
Second week of June, sometimes second week of June.
ಬೇಡ ಅವ್ರ visitation ಎಲ್ಲ ಹೇಳ್ತಾ ಇದ್ದಾರೆ.
Very well.
Second.
Can be taken
At that
even
time, we try to mediate.
2-6, 2-6.
ಇದರಲ್ಲಿ ಡಿಲೇ ಅಪ್ಲಿಕೇಶನ್ ಇದೆ ಅಂತ ಹೇಳ್ತಾರೆ. If you agree with that can be condoned.
It can be condoned, my lords.
ಒಂದ್ರಲ್ಲಿ 67 days.
That is in mine. Yes, in 27, serial number 20.
ಅವ್ರೊಳಗೆ ಅಡ್ಮಿಟ್ ಆಗಿ TCR ಬಂದಿದೆ.
ಬಂದಿದೆ. ಅವ್ರಲ್ಲಿ ಏನಿಲ್ಲ ಸ್ಟೇ ಅಪ್ಲಿಕೇಶನ್ ಇದೆ. ಡಿಲೇ ಕಂಡೋನ್ ಮಾಡ್ಬೋದಾ? ಇನ್ ಯುವರ್ ಮ್ಯಾಟರ್ he has still not.
Yes,
taken
yes,
it.
yes,
ಬೇಡ ಬಿಡು.
yes. Yes.
Serial number 26,
Great.
HR, Samarth Prakash, Ratu.
Consider ಮಾಡಿದ್ರೆ.
No joy of your father.
Appeal on the quantum minutes. We have 70 days.
Oh, we have not seen that. Today our this thing is going very slow.
Till number 26.
26. Oh. Yeah, other side, Samarth Prakash.
Copy has not been served, madam.
Huh?
Serve it to them.
Copy has not been served upon me.
Copy serve ಮಾಡಿಲ್ಲ
I
ಅಂತ.
serve it to them.
Yeah, serve the copy. Where is the proof?
No minutes, no.
Can serve.
Serve the copy.
Delay condone ಮಾಡಬಹುದಾ?
76 days, 76
Copy
days.
serve ಮಾಡಿ. Give him the copies now at least. Very important. They are the parents of the deceased.
Please, ma'am.
Orders and I will not present 24. Accepting the issues assigned to explain the delay of 67 days in filing the appeal is condoned in the interest of justice. I will not present 25, it is closed up accordingly. ಇದರಲ್ಲಿ ಏನು ರೆಕಾರ್ಡ್ಸ್ ಬೇಕಾಗುತ್ತಾ?
Please, ma'am. Please.
ಏನ ಕೇಸ್ ಆಫ್ ನೋಷನಲ್ ಇನ್ಕಮ್ ಆರ್ ವಾಟ್ ಇಸ್
Case of death.
ಡೆತ್ ಇನ್ಕಮ್ ಏನು? ವಾಟ್ ಇಸ್ ದ ಪಾಯಿಂಟ್?
Plus 3 lakhs is there.
ಅಗ್ರಿಕಲ್ಚರಿಸ್ಟ್ ಅಂತ ಅಡ್ಮಿಟ್ ಕಾಲ್ ಫಾರ್ TCS. ನೋಷನಲ್ ಇನ್ಕಮ್ ಆದ್ರೆ ಲೋಕ ಅದಾಲತ್ಗೆ ಹೋದ್ರೆ ಸೆಟ್ಲ್ ಆಗೋ ಚಾನ್ಸಸ್ ಇರುತ್ತೆ, ಅದಕ್ಕೆ ಕೇಳ್ತಾ ಇದ್ವಿ.
Thoughts may be near.
ಏನಿದೆ ಅವ್ರಿಗೆ ಪಾಪ ಪೇಪರೇ ಕೊಟ್ಟಿರ್ಲಿಲ್ಲ.
I have served the caution.
PW1 ಒಬ್ಬರನ್ನ ಬಿಟ್ರೆ ಬೇರೆ ಯಾರನ್ನೂ ಎಕ್ಸಾಮ್ ಮ್ಯಾಟರ್ ಎಫರ್ ಟು ಲೋಕ ಅದಾಲತ್. ಅಡ್ಮಿಟ್ ಕಾಲ್ ಫಾರ್ TCS ಮ್ಯಾಟರ್ ಎಫರ್ ಟು ಲೋಕ.
Till number 28, B. Pradeep, Rangegoda and for R1 to R2.
ಇನ್ನು admission ಇನ್ನು ಎಷ್ಟೊಂದು admission continue in the afternoon.
Serial number,
Huh.
serial number 34 and 55. But I've informed both the advocates, my lords, I have some inconvenience in the afternoon. Would it be taken, my lords, 34 and 55?
55, I am the appellant, my lord. May be taken on tomorrow, my lord.
ಅವ್ರೇನೋ ಅವ್ರ ಪೇಮೆಂಟ್ ಅಪ್ಲಿಕೇಶನ್ ಪೆಂಡಿಂಗ್ ಇದೆ ಅಂತ ಹೇಳ್ತಾ ಇದ್ರು ಅವ್ರು.
ಇಲ್ಲ, ಅದರಲ್ಲಿ
ಅಲ್ಲ ಡಿಸ್ಮಿಸಲ್ ಆಫ್ ದ ಅಪೀಲ್ ಇಲ್ಲ,
ಹೌದು.
ಅದು ಅವ್ರದ್ದು ಇನ್ನೊಂದು ಅಪೀಲ್ ಅದು ಡಿಸ್ಮಿಸಲ್ಗೆ ಅಂತ ಇದೆ, ಅದು ನೋಡೋಣ ನಿಮ್ದ್ರಲ್ಲಿ ಬೇಕಾದ್ರೆ ಆಮೇಲೆ ಟೈಮ್ ಕೊಡ್ತೀವಿ ನೋಡೋಣ.
34, your lordship, I have informed Prasad. That may be, my lords.
Yes, 30.
Serial number 43.
ಸೀರಿಯಲ್ ನಂಬರ್
43.
ನಿಮ್ದು 39
There one matter is there, madam.
ಒಂದ್ ನಿಮಿಷ 39 ಹೇಳ್ತಾ ಇದಾರೆ ಇರಿ, ನಿಮ್ಗಿಂತ ಮೊದಲು ಅವ್ರದ್ದು. ಎಸ್ 30 30.
I appear for the respondent. I'll file it in the counter, my lords. Next month, coming Monday.
Why Monday? You'll have it after vacation only. Otherwise, you come in the afternoon. There is delay. Then after vacation. List after vacation ಹತ್ರ ಬಂದಾಗ ಹಾಕೊಳ್ಳಿ. 36.
Obliged. Number 50, number 52, madam.
Please, ಅಲ್ಲ before vacation.
21-4.
21-4.
52, madam.
43, madam.
Number 52.
ನಾವ್ ಹಾಗಾದ್ರೆ ಬೇರೆ ಮ್ಯಾಟ್ರಸ್ಸೇ ತಗೋಬಹುದಿತ್ತಲ್ರಿ. ಎಷ್ಟು ಇನ್ನೊಂದು
43.
ನಿಮ್ದು ಯಾವ್ದು?
There one matter is there. 503 of 2020.
40?
43, serial number 43. It will be
Notice.
listed along with 503 of 2020.
ಇಲ್ಲ ಇನ್ನೊಂದು ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಇದೆಯಾ?
ಹೌದು.
ಹೌದೇ?
Judgment,
How they are connected? Other.
two petitions. So one is, today it is a wife's petition. It is for divorce. Husband had filed for
But it is
restitution.
submitted that this matter is connected to MFA number so and so. List both the matters together. After vacation, ಅಲ್ಲ ಅವ್ರದ್ರಲ್ಲಿ ಏನಾರ ಇದೆ ಇದ್ರೆ
16-4.
ನೀವು ಇದ್ರಲ್ಲಿ ಏನು ಇಂಟ್ರಿ ಮಾಡೋರಿಲ್ವಾ?
ಇಲ್ಲ.
ಅದೇ you only are saying that it's a divorce decrease past.
Both petitions are dismissed.
Both this. ಹಂಗಂದ್ರೆ ಅದು ಏನು ಅರ್ಜೆಂಟ್ ಇರೋದಿಲ್ಲ after vacation ಹಾಕ್ಬಿಡಿ. 4-6. ಎಸ್ ನಿಮ್ದೇನಿತ್ತು?
52, 52, madam. Second of October. 50, 16. I will inform the other side here.
As requested by respondents, counsel for respondent to list on
22-4.
22.
ಅಲ್ಲಿ ಕೇಳಿ ಸರ್ ನಿಮಿಷ. ಇದೆ ಮಾಡಿ. ಹೇಳಪ್ಪ.
Serial number 42 as requested 22/4. 43 ಎರಡು ಮಾಡಿ ಕನೆಕ್ಟ್ ಮಾಡಿ ಅಂತ ಹೇಳಿದ್ರೆ ನಿಮ್ಗೆ ಕೊಟ್ಟಿದ್ದೀರಾ? ಅದಕ್ಕೆ ಮುಂಚೆ 39
39 ಹಾಗೆ ಇದೆಯಲ್ಲ?
30/21/4.
39 ಹಾಗೆ ಇದೆಯಾ?
34 ಬರೀ ಅರ್ಜೆಂಟ್.
39
55 ಏನು ಬೇಡ. 34 ಮಾತ್ರ.
26 ಅಲ್ಲಿ ಲೋಕಲ್ ರೆಫರ್ ಆಗಿದೆ ಅಡ್ಮಿಟ್ ಕಾರ್ಪೊರೇಟರ್ಸ್ IA1
Admitted properties refer to local government.
IA1 disclosure. ಇದು ಮಾಮೂಲಿ ಅದೇ ಕೊಟ್ಟಿದ್ದಾರಲ್ಲ 25 ಅದು ಅದಕ್ಕೆ ಎಷ್ಟು ಇದೆ 24 IA1 of 20 years closed ಆಗುತ್ತೆ
2 of 24. So admit to list for final hearing after 4 weeks.
ಇದು ಮೇಡಮ್ ಇದರಲ್ಲಿ 25
ಇಲ್ಲೇ ಇದೆ ಲಿಸ್ಟ್ ಅಲ್ಲೇ ಇರುತ್ತೆ ನೋಡಿ. ಇಲ್ಲೇ 25 ಅಲ್ಲಿ ಅದನ್ನ 27 ರೆಸ್ಪಾಂಡೆಂಟ್. ಅದ್ರ ಬಗ್ಗೆ ಏನು ಹೇಳಲಿಲ್ಲ, ಸುಮ್ಮನೆ ಬರೀ ಇದು ಅಷ್ಟೇ ಕಸ್ಟಡಿ ಅಲ್ವಲ್ಲ, ಬರೀ ಆಲ್ಟರ್ನೇಟ್ ಅರೇಂಜ್ಮೆಂಟ್. ನಂಬರ್ ಕೊಟ್ರಪ್ಪ
ವೀಲ್ದಿರ್ಬೇಕಾ? ವೀಲ್ದ ಅಷ್ಟುದ್ದ ಬರುತ್ತಾ? ವೀಲು
ಇದರಲ್ಲಿ 25 27
ವೀಲು ವೀಲು
ಕನೆಕ್ಟ್ ಮಾಡಿ ಅಂತ ಹೇಳಿದ್ರು. 27 ಅಲ್ಲಿ ಅಪೇರ್ ಆಗ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ರು. ಅಲ್ವಾ? ಇದು ಆಮೇಲೆ ಕಸ್ಟಡಿ
ವಿಷಯಗಳನ್ನೆಲ್ಲ ಮಾಡಿ.
ಎಂತಂದಿ ಊಟ?
23 counter
to IA
16 for
ನನಗೆ ಮಾಡ್ಸಿದ್ವಾ?
this
ನನಗೆ
next
ಮಾಡ್ಸಿದ್ವಾ?
15 for ಆಮೇಲೆ ಫೈನಲ್ ಇಯರಿಂಗ್ 21
ಅದೇ IA disposed of 36.
ಅದು ಡಿಸ್ಪೋಸ್ ಆಫ್ ಏನು ಹೇಳಿಲ್ಲ
ಮನೇಲಿ ಕೂದಾಕ್ಬೇಕಿತ್ತಂತ.
ಅದು ಇದು ಏನು ಹೇಳಿಲ್ಲ ಏನು ಹೇಳಿಲ್ಲ
ಚಿಕನ್
ಅಷ್ಟೇ ಅಂದ್ಬಿಟ್ಟು ಏನು ಹೇಳಿಲ್ಲ. ಫೈನಲ್ ಇಯರಿಂಗ್ ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಅಂತ ಹೇಳಿ ಆಮೇಲೆ ಡಿಸ್ಪೋಸ್ ಆಫ್ ಅಲ್ಲ ಏನು ಇಯರಿಂಗ್ ಅಲ್ಲ
ಮೇಡಮ್ ಸ್ವಲ್ಪ ಕಳ್ದಿದ್ದಾರೆ ಮೇಡಮ್. ಇದು ಇಷ್ಟು ಯಾವ್ದ್ರದ್ದು?
ಯಾವ್ದು ಇಲ್ಲ, ಅದು ಕೆಳಗೆ ತೆಗ್ದ್ಬಿಡೋದನ್ನ.
ತೆಗಿಲ್ಲ
ಟಬಾಕು
28 ಅಲ್ಲಿ ಇದು 20
ಟಬಾಕಲ್ಲ
ಇಲ್ಲ ಕೆಳಗೆ
condoned admit to
ಟಬಾಕಿ
corporate
ಬೇರೆ
of
ತಗೊಬಿಡುತ್ತೆ.
PCR.
ಬೇರೆ ಏನಾದ್ರು
19
ಬರ್ಕೊಂಡ್ಬಿಡ್ತಾರಲ್ಲ
ಅಲ್ಲಿ condoned no interest.
ನಾನ್ ಟಬಾಕಿರ್ತೀನಿ.
ಆಮೇಲೆ RG report taken on record or a
ಹಳೆ
vigilant
ತಕೊಂಡ್ಬಿಡ್ತಾರೆ.
corporate PCR. ಇದು 18 ಅಲ್ಲಿ detailed dictation. ನಿಂಗೆ IS ಎಲ್ಲ ಸೆಪರೇಟ್ ಇಟ್ಟಿದ್ದೀನಿ ಅದನ್ನ ಕೆಳಗಡೆ ಫಸ್ಟ್ ಇಟ್ಟಿದ್ದು ಸ್ವಲ್ಪ ನಿಧಾನಕ್ಕೆ ನೋಡ್ಕೊಂಡು ತಕೋಬೇಕು. ಆಮೇಲೆ IA1 of 22/23 ಡಿಸ್ಮಿಸ್ಡ್ ಇದ್ದಾರೆ. 1 of ಜಜ್ಮೆಂಟ್ ಏನಾದ್ರು ಹೇಳಿದ್ರು ಹಾಕಿದ್ದು ಹೇಳಿಲ್ಲ
ಹೇಳಿದ್ರು ಬಟ್ ಅದೇನು ಹೇಳಿಲ್ಲ.
ಬಟ್ ನಿಮ್ ಸೈಡ್ ಏನು ಹೇಳಿದ್ರು ಅವಾಗ ತುಂಬಾ
ಅದು ಕಾಸ್ಟ್ ಬೇರೆ ಆಗ್ತದೆ 10,000
to our
Court officer?
ಸರ್ ಹೇಳಿ.
ಇದು ಸೀರಿಯಲ್ ನಂಬರ್ 55 ಅರ್ಜೆಂಟ್ ಆಗಿದೆ ಮೇಡಮ್?
ಇಲ್ಲ ಸರ್ ಆಗಿಲ್ಲ.
ಆಗ್ಲಿಲ್ವಾ? ಅಲ್ಲ ಅದರಲ್ಲಿ MFA 2787 of 2018 ಅಲ್ಲಿ
Yes, Gina.
Serial number 7.
Huh.
Letter has been personally given by the IO to the Registrar General.
Yes,
Yes, my lords.
they are present.
He is the IO assistant, my lords. IO is on leave presently.
Okay, we have
Okay.
passed order, but ನಿಮ್ ಗಮನಕ್ಕೆ ಇರ್ಲಿ ಅಂತ ಹಾಗಾದ್ರೆ ಅದ್ರ we'll do one more thing. We add one more sentence. Copy of this may be made available to the SPP.
Yes, and because till 7th, my lords, he is on leave, IO. Till 7th of this month, he is on leave. So IO assistant is there.
7th of this month.
Yes, my lords.
It obviously takes at least 2-3 weeks if it goes to the RFSL.
It may take, my lords, so 1 month or 2 months, my lords, minimum. That is the requirement.
And the ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದೀವಿ time?
16/6.
We have given it 16/6.
Yes,
But he should come here and collect.
yes, my lords. In
personally.
fact, yes, my lords, definitely.
Continuation. Serial number 28, B Pradeep. Rangegouda NR.
Judges can no longer live in an
Okay, ಹೆಸರನ್ನು ಬರೆಸ್ಕೊಂಡ್ಬಿಡ ಅಂತ ಹೇಳಿದ್ರು ಯಾರು? Serial number
28.
ಅವ್ರ ನೇಮ್ ಎಲ್ಲ ಡೆಸಿಗ್ನೇಷನ್ ಬರೆದು ಯಾರು ಪ್ರದೀಪ್ ಅಂಡ್ ರಂಗೇಗೌಡ ವಾಟ್ಸ್ ಆರ್ ಟೈಮ್ none appears adjourned.
Serial number 29, Anandishwara DR, Rajshekhar S for R2.
Rajshekhar is
There is a delay of 457 days delay. Injuries.
KSRTC, no?
Injuries.
No, opponents are KSRTC.
KSRTC.
Rajshekhar. How much is the percentage? 65 years.
30%. As per the doctor, 50% is the psychiatrist opinion.
Psychiatrist.
Please.
Yes, sir, psychological.
Head injury, ma'am.
Head injury. Third, considering the fact that the appellant is a serious reason and explanation offered by him, delay of 457 days in filing the appeal is condoned. Head injury. Condoned in the interest of justice. I own official 25 is disposed of accordingly. Admit call for TCS. List of the receipt of TCS.
Serial number 30, adjourned. Serial number 31, CR Ravishankar.
Appellant, my lord. Company appeal.
51 days.
The ground of
Case of
Injury.
injury.
SLS.
And the case, how much is awarded?
29 lakhs and
Issue notice to the respond, interim stay, subject to deposit of 50% of the award amount before this vote within 6 weeks from the date of this order.
Right.
Please Tom.
18-6. Seal number 32, Chandrasekharaya B.
In this case, my lord, insurance company also filed appeal, my lord. Cholamandalam General Insurance Company,
Who is the advocate?
D. Vijay Kumar. That case was posted on 4/4/94, my lord. 9/4.
Is submitted that this matter is
Are-
connected. The number, so it's a verbal code, so it's a list both the matters together on 9/4. It is listed on
9/4 got clear, please.
For admission, seal number 33, L. Shrikant Rao, Raghu R. for R1 to R8.
Yes, I take notice for the insurance company in Karnataka.
Insurance cross objection.
House.
Notice to R1 may be dispensed.
33.1 number. Shri L. Shrikant Rao, the cross objection, cross objection. Understanding consent for. That is fine. 2019 and not clear. Shrikant Rao standing consent for respondent number 2 is undertakes to appear for respondent number 2. Is permitted to file a collective number of and permitted. Now proceed for the apparent service waiver for dispensation of notice to respondent number 1. Under the impugned award, the liability to pay compensation is fastened against respondent number 2, the insurer. Therefore, notice to respondent number 1 is dispensed with as paid for.
Records
Records
ಬಂದಿದೆ.
ಬಂದಿದೆ.
ಬಂದಿದ್ರೆ next week date may fixed up to 10 days.
Case of
Case of 2012.
17.
MA 12 ಮೇಲೆ.
2014 ಅಂತ ಇದೆ.
ಅಲ್ಲ 17.
14.
Okay, miss it.
Date of auction is 12 ಮೇಲೆ.
Hello, no amount is released to you?
No ಮೇಲೆ.
List.
Admission
16-4.
List.
ಮತ್ತು
Seal number 34, urgent. Seal number 35, G. Lakshmish Rao, Ravindran P. This is Sitaram Rao.
Who has moved it? Memo for retirement filed by Shankar.
But I file wakala.
Move ಮಾಡಿದ್ದಾರೆ. First.
You have not moved.
L. Lakshmisha has appeared for the appellant. Shankar. Memo of retirement. Shankar Gowda Ji, Lord Counsel is permitted to retire. 2 weeks time is granted to file the second set. Next ಅದೇನಾ ಎಲ್ಲಾನು 35.1
Please.
ಎಲ್ಲಾದ್ರಲ್ಲೂ ಹಾಕಿದಾರಾ?
Single judge matter, it is being transferred.
35.3 ವರೆಗೂ ಎಲ್ಲ ಸೇಮ್.
Seal number 36, V. B. Sidramaya, H. S. Singraj for R1.
ಎರಡು ಕಡೆನೇ ಇಲ್ಲ. ಸರಿ ಲೋಕ ಅದಾಲತ್ಗೆ ಹೋಗಿತ್ತ ಮ್ಯಾಟ್ರು? ರೆಫರ್ ದ ಮ್ಯಾಟ್ರ್ ಟು ದ ಲೋಕ ಅದಾಲತ್ ಅಂತ ಆಗಿದೆ 2022 ನಲ್ಲಿ. ಮತ್ತೆ ಎರಡನೇ ಸರಿ ಅಡ್ಮಿಟ್ ರೆಕಾರ್ಡ್ಸ್ ಬಂದಿಲ್ಲಲ್ಲ ಇದರಲ್ಲಿ? ಇಲ್ಲ ಕ್ವಾಂಟಮ್ ದೇರ್ ಆನ್ ಕ್ವಾಂಟಮ್ ರೆಕಾರ್ಡ್ಸ್ ಕ್ವಾಂಟಮ್ ಮೇಲೆ ಇದೆ. Admit call for discharge.
This one for receipt of PCLs. Seal number 37, B Pradeep, B.
For the appellate in the matters.
Yes.
Trial court records are required in this case.
ಅಲ್ಲ ಏನದು ಯಾವ ಪಾಯಿಂಟ್ ಮೇಲೆ?
ಇದರಲ್ಲಿ one case I have filed a appeal disputing the nexus between injury and death. And another case may not quantum may not.
Admit call for TCS, this one for receipt of TCS. TCS. ಒಂದು ಬೇರೆದ್ರಲ್ಲಿ ಅದು ಕನೆಕ್ಟೆಡ್ ಅಲ್ವಾ ಅವೆಲ್ಲ?
Connected, ಅವ್ರದ್ದು appeal enhancement ಹಾಕಿದೆ.
ಅಲ್ಲಲ್ಲ ಕಾಮನ್ TCRs ಅಂತ ಕೇಳಿದ್ರು. ಎರಡು ಟೂ ಕೇಸಸ್.
ಹೌದು ಬಂದಿದೆ ಸುಮ್ಮನೆ ಅವ್ರ ಕೇಸಲ್ಲಿ ಬಂದಿದೆ.
37 ಇದೆಲ್ಲ ಸೇರಿಗೂ ಒಂದೇ ಕಾಮನ್ ರೆಕಾರ್ಡ್ ಅಲ್ವಾ?
ಹೌದು.
37 to 37.
Common judgment has been passed.
Admit first for final hearing up to 4 weeks. Cell number 38, Mamta Ji Kulkarni, Sushmita Ji.
Hello, the case of accident wherein to his injuries, my lord. Accident took place on 22nd of February 2021, my lord. And after the claim petition was filed, because of standard operating procedures for COVID-19 situation, the trial could not take place, and it had some gaps in it. And afterwards, because of my negligence and he was a spare time mason, your lordship. He was not a skilled mason, and his employer is not examined by the claimants, and his income is not proved. No examination of the employer is made, and notional income is applied as is applied by the Lok Adalat, your lordship, and it has been taken as exorbitantly as 15,250 rupees, whereas in the village, a non-skilled mason would have earned only about 5,000 rupees or so per month, your lordship. And his wife was also employed in a business, and that's how they were running the family. So these aspects had to be taken care of. But in my absence, whereas even a written statement was not placed.
Some notified by the central government under Workmen's Compensation Act.
My lord, opportunities were granted, but I have not taken it.
Said 15,000 is on the higher side. What is the income notified by the government, central government? Minimum wages in 2021.
Minimum wages, my lord.
Have you any idea?
But even that was not earned by him because he was a spare time mason. He was not employed even at the time of accident. COVID-19 situation was running and he was not employed. But he was not a skilled laborer. So that factor needs to be taken care of. Lord, I'm liable to pay and I'm not praying for any exoneration. But a just amount needs to be decided and it's a matter of trial, your lordship. So my main prayer is that kindly remand the matter to the learned MACT so that I will file my written statement and also adduce evidence to prove the quantum of his per mensum income.
You are represented through a counsel before the trial.
He was represented, my lord. The counsel also, my lord, both were absent, counsel and the party from the proceedings. Initially, it was due to COVID-19 situation because of the standard operating procedure. And afterwards, for inexplicable reasons,
21. Because the date of institution.
it was during the second wave of COVID-19.
Yes, yes.
In this case, I appear for the respondent, my lord. My lord, he was traveling in the tractor, my lord. So because of the rash negligent driving of the tractor, this accident caused and the disease has been death. His death has occurred on spot, my lord. Only ground is reduction. So for the year 2021, according to Lok Adalat chart, 15,000 ought to have been taken, my lord. That is on IR side. In MST, they have taken us 15,250. So that may be reduced, my lord. And all other
How much they have taken?
15,250, my lord. All other grounds, it has been properly
State ಜಾಸ್ತಿ ಇದೆ. ಅಂದ್ರೆ
given.
this consortium ಜಾಸ್ತಿ ಕೊಡ್ಬೇಕಾಗುತ್ತೆ.
Yes, my lord. Sorry, loss of consortium, 1,20,000 ought to have been given, my lord. Yes, but there's no other appeal on beneficiary.
20,000 ಕೊಟ್ಟಿದ್ದಾರೆ. That is 15,000. Both loss of love and affection and consortium, on both ground it is given.
Yes, my lord.
That's all?
That's all, my lord.
Yes.
Only on the substratum of calculation, that's all. Calculations are all correct, but the substratum itself is taken as quite high, your lordship.
No, that is 15,000 only.
15,250,
31 years, my
31
lord.
at the time of death, your lordship.
Would be the future
16, your lordship.
Multiply 16, my lord.
future prospects.
40% future
Even at
prospect
40%.
ought to have been taken, my lord.
15,000 plus 40% ಎಷ್ಟಾಗುತ್ತೆ ನೋಡಿ?
Lord, it comes at around 7,000 something.
6,000. So 21,000 ಆಗುತ್ತೆ. He had 3 dependents.
Yes, my lord. Wife and 2 minor children,
Reduction is 1/3.
1/3.
There's a 2/3 ಎಷ್ಟಾಗುತ್ತೆ?
14,000.
14,000?
14,000.
ಅಷ್ಟೇ ಕರೆಕ್ಟ್. 14,000 into 12 into 16. Multiply 16, correct?
My lord, all the calculations are correct.
Yes, my
by
lord.
The learned MSCT. Calculation itself is, the correctness of calculation is not under the scanner, your lordship. Only the substratum that is taken.
Corrections is that. ಎಷ್ಟಾಗುತ್ತೆ? 14,000.
26,88,000.
26 lakh
88,000.
88,000. Then this 3 ಜನ ಅಲ್ಲ?
3 people, my lord. Dependents.
21. So 44,000 into 3.
1,32,000.
1,32,000. ಅದು 33,000. ಎಷ್ಟಾಗುತ್ತೆ ನೋಡಿ?
Yes, ma'am. 28,53,000.
28 lakh
53,000.
Only 29 lakhs only.
57.
Only this much will be reduced.
Yes, ma'am.
The 1 lakh difference comes. 1 lakh difference comes now. Lord, my prayer is that I will adduce fresh evidence that he was not a skilled laborer and he was not exactly earning as was assumed.
Are you aware what is the minimum wage
Yes, my lord.
certified by the central government?
Lord, if they are regularly employed,
My lord,
that is the
in,
case.
2021
He is not regularly employed.
Minimum wage fixed for unorganized sector workers only, that.
Yes, my lord. In 2021, India's minimum wage rates varied by in state and skill level, with daily rates ranging from around 350 to 1,035.
ಗವರ್ಮೆಂಟ್ ಒಂದು ನೋಟಿಫೈ ಮಾಡುತ್ತೆ ಅದು ಎಷ್ಟು ನೆಟ್ಟಲ್ಲಿ ಹಾಕಿದ್ರೆ ಸಿಗ್ಬೋದು ಸೆಂಟ್ರಲ್ ಗವರ್ಮೆಂಟ್.
Okay.
ಬಟ್ ಎನಿವೆ ಇದೆಲ್ಲ ಅದನ್ನ ನೋಡೇ ಮಾಡಿರೋದು. They're not, no, but you were appeared through an advocate. You have not done the needful. Why should it be remanded?
Lord, now I can also, now my,
Whether the party has taken any action against the advocate if there is any professional negligence or misconduct.
no, my lord. He hasn't taken. Now I cannot claim that my advocate had not.
Yes, sir.
He is only 24 years old, my lord. He's also,
Tractor ತಗೊಂತಾರೆ.
and he is also, your lordship, kind of a daily wage earner. He has to
Yeah, interest, how much is awarded?
6% per annum.
Heard both sides. The appeal is partly allowed. The improved judgment and award is modified as follows. the fiction in MEC number 80K of 2021 is partly allowed. Claimants are entitled to compensation of this 28,53,000 with interest thereon at 6% per annum from the date of the petition till its realization. Apportionment ಹೇಗೆ ಮಾಡಿದ್ದಾರೆ? How the apportionment is made?
40%.
40. It ತಲಾ ಹೋಗುತ್ತೆ. ಮದರ್ಗೆ ಮಕ್ಕಳಿಗೆ ಇದು ಕೊಟ್ಟಿದ್ದಾರೆ. ಮದರ್ಗೆ 50%. She's also highly courteous. Entitled to cover with interest thereon, respondent. shall
ತಲಾ
deposit-
30%.
Huh?
ತಲಾ 30ರಷ್ಟು ಪರಿಹಾರ.
ಮಾಡೋಣ.
ಹಾ.
50, 25, 25.
Yes, madam.
Shall deposit the said amount before the tribunal. On adjusting the amount already deposited, if any, within 6 weeks from the date of this order, or 4 weeks from the date of the receipt of copy of this order.
Or at least time may be extended. He is also
Claimant number 1.
short of funds.
In the award amount, claimant number 1 to 3 are entitled to the shares in the ratio of 25 is to, sorry, 50, 25, 25 respectively. The shares of claimant number 2 and 3 shall be invested in FD in their names till they attain majority in any nationalized or scheduled bank of the choice of the claimants, with liberty to claimant number 1 to draw the interest accrued thereon. That's it. Out of the share of claimant number 1, 50% shall be digitally released to her on furnishing the required documents, and 50% shall be invested in FD in her name in any nationalized or scheduled bank of the choice of the claimants.
My lord,
This has to follow.
I have deposited 7 lakh rupees, madam, with the executive.
Sir, remit the amount in deposit and the TCS to the tribunal for reasons to follow.
Amount in deposit, madam.
ಹೇಳಾಯ್ತು.
Yes, much obliged, my lord.
Obliged.
Sir, amicus curie,
Yes, my lord. Court guardian.
court guardian.
Yes, madam.
ಅವ್ರ ಫೀಸ್ ಕಟ್ಟಿದ್ರಾ?
Yeah, I've received, my lord, kindly. Yes.
ಕೆಳಗಂದು. ಇದು ಪರವಾಗಿಲ್ಲ. Taken up for final disposal. Court places on record the appreciation for the services rendered by
Much.
court guardian, Srimati so and so. Register deposit ಮಾಡಿದಾರಾ ಅಥವಾ ನಿಮ್ಗೆ ಪೇ ಮಾಡಿದ್ರಾ?
They've given it to me only, my lord.
Okay, court.
Yes, my lord.
Then nothing to be paid.
No, my lord.
Finance ಮಾಡೋಣವಾ?
My lord, I am at your mercy. I'll have to pay through my pocket.
ಆಯ್ತು.
Yes, much obliged.
69, Aparna LV, HK Vikram, respondent.
I am for the appellant.
Yes.
My lord, appellant is the wife of the respondent, my lord. Their marriage was solemnized on 16/8/2022, my lord. Respondent is working as an executive assistant engineer in Bescom. Thereafter, after the marriage, my lord, there
She
is
has not
serious
taken
allegation.
evidence.
Well,
Section 9. Restitution of conjugal rights is allowed.
Restitution of conjugal rights has been allowed against the wife, my lords, because she could not, her counsel could not address the arguments and cross-examination was not being done. Because of the illness and mental trauma, my lord, there are serious allegations
No,
against the
She
husband, my lord,
doesn't
like.
want to join.
No, she is not interested to join, madam, because the allegations are very severe and there is forcible, she is forced to have the unnatural sex and other issues, some like watching porn and other some serious issues are there apart from dowry.
Stay
So if she is not contested, it's not stayed.
Call for TCS, issue notice to the respondent. The interim stay of the interim decree. Till further orders, I 2024 is disposed of accordingly. List on date and appearance in
23/4.
Yeah, after vacation.
After vacation. 9/6. Cell number 40, Rajini Prakash, Prasanna DP for KVK respondent.
Yeah, I am appearing for appellant. In the last occasion, my lordships have passed an order and the visiting rights was allowed in the Panchayati Development Officer at Shanwar Sante. And the petitioner wife has to go there. And from 2 to 5, the respondent to bring both the minor children there before Panchayati officer and visit. And more specifically, it was mentioned by my lordship that after dropping the children till the visitation time is over, the respondent shall not show up in the said premises. However, in the first occasion, that was on 15th February, both the minor children were brought by the grandfather and he allowed the children to come inside the premises. They were sitting in the room with the petitioner. They really had a good time for 3 hours with mother. They were very happy. I have the photographs of that.
Correct, now what you want
And
us to
no,
do?
and next occasion, Ranan, let me finish. Next occasion, that was on 1st March. The respondent, he came himself along with the kids and he didn't allow the kids to enter inside even the premises. The kids, both the children were standing in the sun on the road. Development officer came outside. ಅವರಾದ್ರೂ ಹೇಳಿದ್ರು ಯಾಕೆ ಮಕ್ಕಳಿಗೆ ಹಿಂಗ ಬಸ್ಸಲ್ಲೇ ನಿಂದ್ರಿಸಿರಿ ಒಳಗಡೆ ಕರ್ಕೊಂಡು the children have been threatened not to go inside by the father. He is sitting in front of, there is one small restaurant, hotel kind of thing, where he is sitting. I got the photographs. I want to submit this. There is no free access to the children and the minor children are scared. They have been threatened not to talk to the mother. ನೀವು ಚಾಕ್ಲೇಟ್ ತಗೋಬೇಡಿ, ಅವಳು ಏನ್ ಕೊಟ್ರು ತಗೋಬೇಡಿ, ಅವಳ ಜೊತೆ ಮಾತಾಡ್ಬೇಡಿ, ಈ ತರ ಎಲ್ಲ ಅಂದು ನಿನ್ನ kids have, children have told the mother that father has told her not to talk to you. This is not correct. The children's life is in danger. In fact, he said that I'll ಕಾಲ್ ಮುರಿದು ಬಿಡಿ.
Has come up for admission. You want us to continue the same arrangement? We'll continue.
Only thing is the specific direction.
If they have completed, I will submit my.
ಏನದು? What do you want to do? See, now the matters. Correct. ಏನ್ ಮಾಡ್ಬೇಕು ಅಂತೀರ? What do you want us to do?
I want to specify that he should not come.
We have already said, if he has come there, you file a contempt application if he has violated it.
Malad, in respect to that, I will submit Malad.
Kindly please accept this and see the photograph.
In this matter, Malad.
It's not, the children's life is in danger.
That's it, my peruse the.
Correct. See, your client was asked not to show up. We'll
No,
see.
no, Malad.
But ಅದನ್ನ ಏನ್ ಮಾಡ್ಬೇಕು ನೀವು in advance ಆಗಿ ಮಾಡ್ಬೇಕಲ್ವಾ?
In this matter, Malad,
Sir.
in the last occasion, myself has submitted that I have no objection to visitation rights and your lordship has passed the order for visitation rights. There is no doubt. In the first occasion, there was.
ಇದು ಕೂಡ ಒಂದೇ ಸೆಟ್ ಇದೆಯಲ್ಲ? Madam, you want us to see these things, only one set you have given.
No, because I want to show that I'm telling truth.
We have given only one set, how both of us can see?
No, I'm giving second set, which is the Xerox copy. It's a Xerox copy.
And in the next occasion, I supposed to drop the children. I have taken the children to the PDO office. PDO was not present on that day. As such, I have dropped the children and I came out. Thereafter, PDO, after finishing his lunch, he came to the office and he called that without my permission, you have dropped the children. Why you have left the children like that? And again, I have visited and in front of him, again, the respondent has shown the and hand over the children to his custody and he came out, my lord. Thereafterwards, one incident has taken place. After having 3 hours visitation rights, the mother who supposed not to do, after when the father was taking the children to with him, she has thrown the sand on the face of the children and also she has threatened that the husband immediately lodged the complaint with the PDO. Thereafter, he lodged the complaint with the police also and also sought for the CCTV camera which is installed in the PDO office. That much of harassment she is doing, my lord. How can we?
My lordship.
Both of you should come before the court if
My
there is
lordship,
anything.
in that
I have not complained any.
If there was any violation of the court order, you could have reported here only.
Yes,
My
I have not.
lordship, that is not true, my lordship. Why will the mother do
Since,
like?
I have sought for the CCTV
Crime,
camera.
in fact.
You want us
He
to hold?
has gone to the Shaniwar police station and filed a false complaint. Why will I hit my own children? Why will I?
What do you want
I'm-
now?
No, I want to continue, but only thing is he should not come and disturb it. I want a free access with my children. Whatever order was passed, let it
Where
continue
is
for
the
2
copy
more
of
years,
the
2
complaint?
more
What
months.
action is the word
Well,
taken?
Today
No.
matter was,
He have filed the complaint to the PDO. What action he has taken?
he has not taken any action. He has also,
Then
No,
what does it mean?
no, not only, he has not furnished this CCTV camera also, and he advised me to lodge the complaint with the police. I have lodged the complaint with the police. Police have registered the NCR and also directed the PDO to furnish the CCTV camera footages. I am awaiting for such camera footages.
Why did you go before the police when the matter was pending
Yes.
before the court?
No, when they have,
Counsel, please tell us. The matter was pending here.
no, she has
You
thrown,
say, 1 second, you say that she has committed some breach of this order.
not only breach,
She-
my lord,
she used
not only
files
breach
in
of the
methods,
order,
etc.
she has thrown.
But why did you not come back to the court? Why did you go to the police station?
No, immediately she thrown all the mud and some glass pieces on the face of the children, my lord. For that, I forced to lodge the complaint.
My lordship, it is all false. Let Panchayati Development Officer may be called, he can give whatever is good. In fact, he asked, why children are ಯಾಕೆ ಮಕ್ಕಳನ್ನ ರೋಡ್ ಮೇಲೆ ತುಂಬಾ ಬಿಸಿಲಿದೆ ಒಳಗಡೆ. Kids are scared to come inside. He has threatened them. Kids are
My order
threatened,
is
their life
executed.
is in danger. If he can't give visiting right, then give me the custody.
This was up
Give me the custody there.
1st March 2025.
Yes, please, ma'am.
ಅಲ್ಲಿಂದ ಮುಂದೆ ಆಗಿಲ್ಲ. This was last.
And
ಅದಾದ್ಮೇಲೆ 5-3 ಬಂದಿತ್ತಲ್ಲ,
5-3 ಬಂದಿತ್ತು.
ಬೇರೆ ಬೆಂಚ್ ಮುಂದೆ ಬಂದಿತ್ತಾ?
ಬಂದಿತ್ತು ಆ ದಿವಸ
ಬಂದಿತ್ತು.
ಆಗಲಿಲ್ಲ.
And
Petition, right? So
your lordship,
both counsel make
ma'am,
allegations against the parties, saying that they did not cooperate for a smooth visitation arrangement. Appellant counsel submits that appellant did not follow the direction of this court that he should not show up in the PDO's office during the visitation. Response counsel submits that the respondent, while sending back the children, splashed sand towards the children and threatened them. He says that he submits that a police complaint is filed against the appellant since the visitation has taken place. Sorry. He further submits that though he has filed though the respondent filed a complaint to the PDO, no action is taken. Which class they are studying now? They are studying in which class, children?
They are studying in yeah class.
sixth and second, my lord.
ಮಗ 6ನೇ ಕ್ಲಾಸು, ಮಗಳು 3ನೇ ಕ್ಲಾಸ್ ಓದ್ತಾ ಇದ್ದಾರೆ.
ಈಗ ಅವ್ರಿಗೆ ರಜೆ ಬಿಟ್ಟಿದೆಯಾ?
ಇವಾಗ ವೆಕೇಶನ್ ಆಯ್ತು,
ಸ್ಕೂಲ್
ಎಕ್ಸಾಮ್ ಆಯ್ತು.
My lord,
ಸ್ಕೂಲ್ ವೆಕೇಶನ್ ಬಿಟ್ಟಿರ್ಬೇಕಲ್ಲ.
ಅಲ್ಲ, vacation ಅಂದ್ರೆ result ಗೆ awaiting for the result.
ಎಲ್ಲ ಹೋಗ್ತಿರೋದಿಲ್ಲ, ಐ ಥಿಂಕ್ ಕಂಪಲ್ಸರಿ.
ಇವಾಗ ವೆಕೇಶನ್ ಸ್ಟಾರ್ಟ್ ಆಗಿದೆ, ಆದ್ರೂ ನಾನು ಐ ಆಮ್ ರೆಡಿ ಟು ಗೋ. ಐ ಗೋ ಫ್ರಮ್ ಬ್ಯಾಂಗ್ಳೂರ್ ಟು ದೇರ್.
Now there is a vacation, why can't you send the children
But
temporarily
that's the behavior of the mother, my lord, throwing the mud on the face of the children and also with glass pieces like that. That's a very dangerous behavior, my lord. That's what it's very scared to since last 4 years she has not bothered, and also she is leading the.
ಎಲ್ಲ ಹಿಯರ್ ಮಾಡಿ ನಾವು ಲಾಸ್ಟ್ ಟೈಮ್ ಆರ್ಡರ್ ಮಾಡಿ.
ಇಲ್ಲ, last time no, my lord, last time myself has consented, my lord, myself has consented. Your lordship may order. I have no objection to give the visitation.
Let the PD officer come.
And your
He
lordship,
has seen how even he was shocked. Why
find
he
out,
doing like this to the children?
Find out.
my lord,
Between the
otherwise your lordship may have the matter on 7th, my lord. I will keep the children and
PDO
respondent
shall
before the Central Court, my lord.
His report. PDO ಯಾವ ಊರದು?
Shaniwar Sante, my lord.
ಶ್ರೀನಿವಾಸಂತೆ ಪೇಟೆ. ಶ್ರೀನಿವಾಸಂತೆ shall submit his report about the visitation proceedings held on ಎಷ್ಟದು?
1st of
15th
March.
February and 1st March 2025. Further,
My lordship, on the first visiting day, the kids were very happy. They were getting us accustomed to her. On the second visit, he is very jealous. He doesn't want kids to go to her.
She has. to
So he personally came and he's standing, and she given the photograph, he's standing in front. For 3 hours he was in that restaurant, in that hotel.
He was not in the PD office, he was in outside.
Outside only,
Yes.
why is
Sir, madam and Mr. Counsel, you are not in the family, you are in the court.
Yes, madam.
That's all. ಅದು ಹೇಳೋದು ಒಂದು ಹೇಳೋಷ್ಟು ಹೇಳಿದ್ಮೇಲೆ ಮುಗಿಸ್ಬೇಕು, ನಾವು ಆರ್ಡರ್ ಮಾಡ್ತೀವಿ. You cannot take the magnetism of the parties. ಸ್ವಲ್ಪ ಒಂದು ಡಿಸೆನ್ಸಿ ಕೋಡ್ ಡೆಕೋರಮ್ ಇರಬೇಕು.
No, I have stopped, my lord. They are gone submitting that.
My lordship, in one of the photograph, the girl is so scared. She is standing in the
Madam,
window.
1 second, please, for God's sake.
Yeah.
2 minutes.
Much of that.
ನೀವೇ ಹಿಂಗಿದ್ರೆ ನೀವು ಪಾರ್ಟೀಸ್ಗೆಲ್ಲ ಹೇಗೆ ಕಂಟ್ರೋಲ್ ಮಾಡ್ತೀರಿ, ಹೇಗೆ ಅಡ್ವೈಸ್ ಮಾಡ್ತೀರಿ?
I want
How
to
are
come
you
with
to
it.
counsel the parties?
Counsel.
ನೀವೇನ್ ಮಾಡ್ಬೇಕೋ ಅದನ್ನ ಮಾಡೋದಿಲ್ಲ. Professionalism you don't show. If they have violated the order, you could have filed a contempt petition here. ಅದು ಮಾಡೋದಿಲ್ಲ, ಸುಮ್ನೆ ಕೂಗಾಡ್ತಾ ಇರ್ತೀರಿ. Not to achieve anything. Sorry, state of affairs. If she goes to now Srinivas Sante, where does she stay?
She stays in Bangalore.
Correct, visitation ಹೋದಾಗ ಎಲ್ಲಿರ್ತಾರೆ?
ಅಲ್ಲಿ ಹೋಗ್ಬೇಕು ಶನಿವಾರ ಸಂತೆ.
ಯಾರಾದ್ರೂ ಇದಾರ ನಿಮ್ ರಿಲೇಟಿವ್ಸ್? ಅಲ್ಲಿ ಏನ್ ಮಾಡ್ತೀರಾ ನೀವು ಹೋದಾಗ? ನಿಮ್ ತಾಯಿ ಅಲ್ಲೇ ಇರ್ತಾರ? ಒಂದ್ಸರಿ ಹೋದ್ರೆ 2-3 ದಿವಸ ಕಂಟಿನ್ಯೂಸ್ ಆಗಿದ್ದು ಮಾಡ್ಕೊಂಡ್ ಬರ್ಬೋದಲ್ಲ?
ಅಲ್ಲೇ ಕಂಟಿನ್ಯೂ.
2 weeks. ಎಷ್ಟು ಯಾವ್ದು ಬರುತ್ತೆ ಈಗ ನೆಕ್ಸ್ಟ್? ದಿಸ್ ಇಸ್ ಫಸ್ಟ್ 10th to 10th, ಅದೇ 12th ವಿಡಿಯೋ ಆಫೀಸ್ ಹಾಲಿಡೇ ಇರುತ್ತಲ್ಲ, ಸೊ ಹೇಗೆ ಮಾಡೋದು? 7th to 9th ಮಾಡೋದು, ಆಲ್ ವರ್ಕಿಂಗ್ ಡೇಸ್ ಇದೆ. The respondent shall drop the children in the office of PDO Srinivas Sante from 7th to 9th of April at ಮೊದಲಿಗೆ ಎಷ್ಟು ಗಂಟೆಗೆ ಮಾಡಿದ್ವಿ ಹಿಂದೆ?
2 o'clock.
At 2 PM, 2 PM, and pick up the children back at 5 PM. Appellant shall meet the children in the said premises between 2 PM and 5 PM. 5 PM, the respondent, after dropping the children, shall not show up himself in the premises. The appellant also should conduct with the children in a befitting manner. In a befitting, in an affectionate manner. This repeat agಬೇಕು. The same cycle shall be repeated. Vacation ಬರುತ್ತಲ್ಲ, ಮೂರು ದಿವಸ. Between 21/4, same visitation arrangement shall continue for ಇಲ್ಲಿವರೆಗೂ ಮಾಡಿಬಿಡೋಣ, 28 ವರೆಗೂ. In the ಅಲ್ಲಾದ್ರೆ 21st ಅನ್ನೋಕ್ಕಿಂತ Monday to ಅಂತ ಹಾಕೊಂಡ್ಬಿಡಿ. Monday to Tuesday, Monday, Tuesday, Wednesday, Monday to Wednesday ಅಂತ ಹಾಕೊಂಡ್ಬಿಡಿ. Each week the same shall continue up to 28th May. If any day happens to be a general holiday, if out of those 3 days any day happens to be a general holiday, the visitation shall take place on the next working day. List on
Malad, before that, Malad,
after vacation.
one submission, Malad. I will keep the party on next Monday, Malad, 7th. And 7th itself, I will keep the parties and the children present before the court. After this incident, Malad, the children were afraid to go to the school also, Malad, stating that.
ಹಾಗಿದ್ರೆ ನಿಮ್ ಪಾರ್ಟಿ ಇವತ್ತು ಇಲ್ಲಿ
ಅಲ್ಲ, ಇವತ್ತು
ಬಂದಿದ್ರು.
ಡೇಟ್ ಕೊಟ್ಟಿಲ್ಲ, ಇವತ್ತು ಡೇಟ್
ಬಂದಿರ್ತಿದ್ರು ಅವ್ರು, ಅಷ್ಟವ್ರಿಗೆ ಅಷ್ಟು ಕನ್ಸರ್ನ್ ಇದೆ.
and children, he has to look after the children also, Malad.
It is
And
good.
kindly have this matter on Monday, Malad.
Next
Before
year.
that itself,
List
on
on.
Monday, I will keep the
Monday.
party and children's, Malad.
We have started.
Monday it is
Date
not.
Wednesday of,
Otherwise, weekly
alternate week.
one day, Malad, 3 days, there are no persons to look after the children and himself, Malad. And he has to work, Malad, to drop and come back 3 days.
Okay. Contempt will be initiated, let him face it.
ಅಲ್ಲ, 3 ದಿವಸ, ವಾರಕ್ಕೆ 3 ದಿವಸ ಅವನು ಹೊರಗಡೆ ಡ್ರಾಪ್ ಅಂಡ್ ಗೆಟ್ ಬ್ಯಾಕ್, Malad. ಅಲ್ಲ, ಅವ್ರ ಮನೆಗೆ ಹೋಗಿ ನೋಡ್ಲಿ ಸ್ವಾಮಿ, ಐ ಹ್ಯಾವ್ ನೋ ಒಬ್ಜೆಕ್ಷನ್. ಲೆಟ್ ಹರ್ ಗೋ ಟು ದಿ ಹೋಮ್ ಅಂಡ್ see that children, Malad. That's the thing, Malad. In the dropping and picking up, it's very difficult, Malad.
Suspension of.
In the home itself, Malad, let them visit in the home. let her visit in the home itself, my lord. I have-
Counsel, we have passed an order. There is
But-
no further submissions. Yes. Yes, please.
Appearing for state, my lord. The matter is coming for first time. I take notice, my lord, for respondent.
Serve the notice and will.
Yes. I take notice. my lord.
Communicate the copy of this order to PD Srinivasan. Again, he was on bail during trial. Then let him take notice and file objections.
Yes, yes, my lord.
Sir, if any.
All witnesses are not hearsay witnesses. And what the impeachment order.
He can let me sleep when it comes, but he was a party. Correct, Mr. Counsel. He says he wants to file a counter to this. One thing. Second thing, your party was not on bail during the trial. At least ಅಲ್ಲಿದ್ದು ಆಮೇಲೆ ಕಸ್ಟಡಿಗೆ ಹೋಗಿದ್ದಾರೆ ಅಂದ್ರೆ ಬೇರೆ. Not SPP. Your HCP or
SCG.
he takes notice for the respondent and seeks time to file counter to I-1 of 2025. File ಓದಿದ್ರೆ ನೀವು ಎಲ್ಲ ರಿಸಲ್ಟ್ ಒಂದೇ ಇರುತ್ತೆ. Have you gone through the file?
SPP will appear in this matter, my lord.
Charge of the
Yes,
case.
ma'am. That is true.
ಫೈಲ್ ಓದ್ಕೊಂಡ್ ಬಂದ್ಬಿಟ್ಟಿದ್ರೆ ಮತ್ತೊಂದ್ ಸುಮ್ನೆ ಡೇಟ್ ಹಾಕೋದ್ರಲ್ಲಿ ಏನು ಇದು ಇರೋದಿಲ್ಲ.
Yes, ma'am.
ಲಿಸ್ಟ್ ಆದ್ಮೇಲೆ ಪ್ರಿಪೇರ್ ಆಗಿ ಬರಕ್ ಹೇಳಿ ಅವ್ರಿಗೆ. ಲಿಸ್ಟ್ ಡೇಟ್
9/4.
Much.
Cell number 42, G. Narayan Rao.
This case appeared for the appellant.
Respondent husband filed a petition under section 13(1)A and 1B, the Hindu Marriage Act,
Yes.
on the ground that the appellant has meted out the cruelty to the respondent and also she has deserted her. That ground only the trial court has passed the order, please.
Third admit call for TCS. ಅದ್ರಲ್ಲಿ 8 lakhs ಇದನ್ನ ಅವಾರ್ಡ್ ಮಾಡಿದಾರಲ್ಲ ಕೊಟ್ಟಿದಾರಾ?
In
She is awarded permanent alimony of
Yes.
8 lakhs.
Yes.
Whether he has deposited?
8 lakhs, no, not 8.
Third admit call for TCS. Interim stay of impugned judgment and decree so far it relates to dissolution of marriage. Till further orders. I-1 of 2020.
I fought for an interim stay.
Interim stay granted.
Yes.
List on
18/6. Cell number 43 adjourned. Cell number 44, Kashinath JD. Kashinath JD.
application. ಇನ್ನೇನು ಬೆಳಿಗ್ಗೆ ಏನಾದ್ರು ಬಂದಿದ್ರ ಅವ್ರು? ಮದುವೆ ಆಯ್ತು ಅಂತ ಬರ್ತಾರೆ. ಟೆಸ್ಟ್ ಮಾಡಿದ್ದಾರೆ ಯಾರೋ ಅಪೇರ್ ಆಗಿದ್ದಾರೆ. No representation for the appellant. ಬರೀ ನೋಟಿಸ್ ಮಾಡಿದ್ದಾರೆ. No representation for the appellant. List on first time ಬರ್ತಾ ಇದೆ.
Date ಕೊಡುವ.
Date ಈಗ before vacation.
16/4. Cell number 45, GS Marlaya.
How much is awarded? 37 lakhs 34,000. Third admit call for TCS, issue notice for the respondents. Interim stay subject to deposit of 50% of the award amount before this court within 6 weeks from the date of this order. I-1 of 2025 disputed.
18/6.
18/6.
Cell number 46, GS Marlaya.
Separate claim petition. 35 lakhs same previous case ಏನಾಗಿತ್ತು? Previous and ಏನಿತ್ತು ಅದು?
Cell number 47, Nagraj M.
HDFC ಇರ್ಬೋದವ್ರು ಯಾರಿದ್ದಾರೆ?
HDFC, BC Shivanegowda, HS Singraj, D. Kumar, B. Pradeep, N. Krishnaswamy.
BC Shivanagowda, last running counsel for respondent number. Respondent number one. Is requested to accept notice for respondent number one. Then memo for dispensation of notice for R2 ಹಾಕಿದ್ದಾರೆ. Two entry, no? But under the impugned award, liability to pay compensation fastened against respondent number one insurance. Therefore, notice to respondent number two entry is dispensed with as paid for. Admit call for TCRs. This structure is.
Till number 48, Nagarajam.
Same. Release of amount, ಇಬ್ರು ಇಲ್ಲ ಅಲ್ಲ?
48.
48. ಎರಡರಲ್ಲೂ ಸೇಮ್ ಆಗ್ತದೆ ಬಟ್ ಅದಾದ ರೈಸಿಂಗ್ ಕಾಮನ್ ಆರ್ಡರ್ ಇಲ್ಲ, ಎರಡು ಕಾಮನ್ ಆರ್ಡರ್ ಇದೆ. ಹಾಗಾದ್ರೆ ಕನೆಕ್ಟ್ ಮಾಡ್ಬೋದಲ್ಲ?
ಬೇರೆ ಇನ್ಶೂರೆನ್ಸ್ ಇಲ್ಲ, ಟಾಟಾ ಏಜ್.
ಅಲ್ಲ ಅದಕ್ಕೆ ಕೊಡಿ ನಂಬರ್ ನೋಡೋಣ. 2783 3426 ಅಂತ ಇದೆ. ಇದು 3490 of 2022 ಬೇರೆ ಇನ್ಶೂರರ್ ಯಾರು?
ಟಾಟಾ ಏಜ್ ರೆಸಿಡೆಂಟ್ ಮಾಡ್ಕೊಂಡು ಜನಾರ್ದನ್ ರೆಡ್ಡಿ, ಎಚ್.ಎಸ್. ಲಿಂಗರಾಜ್, ರವಿ ಸಂಪತಿ, ಡಿ ಪ್ರದೀಪ್, ಎನ್ ಕೃಷ್ಣಸ್ವಾಮಿ, ಓ ಮಹೇಶ್.
ಜನಾರ್ದನ್ ರೆಡ್ಡಿ. She is Janardhan Reddy, last training counsel for respondent number one is requested to accept notice for respondent number one. This is already India liability. Either 20 and Shangri-La. Number one insurance commission. Under the impugned award, liability to pay compensation is fastened against respondent number one insurance. Therefore, notice to response to entry is dispensed with as paid for. Admit call for his PCFs. ಇವಾಗ 2:30 ಹಿಯರಿಂಗ್ ಮಾಡೋಕ್ಕಾಗುತ್ತೆ ಇದು. ಸರಿ,
Pastor matter, seal number 2. ಅದು 50. Pastor matter, seal number 2. O Mahesh.
I appear for the appellant, my lord. Lord, as per the website thing, my lord, the amount has been deposited.
19 lakh deposit.
And it is 19 lakh 141.48 paisa has been deposited.
ರಿಲೀಸ್ಗೂ ಅರ್ಜಿ ಹಾಕಿದ್ದೇವೆ ಸ್ವಾಮಿ ಅವರೇ.
Pardon?
number 2 ಮಾತ್ರ only for
Mr. Lakshmi.
you represent all the claimants or only one claimant?
Mr. Lakshmi.
R2 ಮಾತ್ರ. one is represented by one Asha Shetty. ಇನ್ನೊಬ್ರು R5 ಸತೀಶ್ ಚಂದ್ರ. 3 and 4 are minus represented by R1.
A copy is not served on me, my lord.
What is your ಆಯ್ತು ಮೇನ್ ಮ್ಯಾಟರ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ.
Yes, my lord. My lord, appeal by the insurance company on the ground, my lord, the finding of the tribunal on issue of negligence, holding, my lord, the rider of the motorcycle or negligent, that is a deceit, my lord, only to a 40%. But in this case, the deceased is one Manjappa, aged about 32 years, my lord, said to be a carpenter and a real estate business. Date of accident, my lord, is 9/2/2017. In this respect, my lord, I would like to invite your lordship attention to the evidence of PW2, my lord, the pillion rider, and his statement. Admittedly, my lord, the deceased, my lord, who was riding the motorcycle was taking a U-turn with utter disregard to, my lord, Rule 12 of the, my lord, Rules of the Road Regulation 1989. What may kindly have, my lord, Rules of the Road Regulations 1989.
Yes, you can read that.
12. Taking U-turn. May I read, my lord?
Yes.
Yes. No driver shall take a U-turn where U-turn is specifically prohibited and on busy traffic road. If a U-turn is allowed, the driver shall show signal by hand as for a right arm, watch in the rear view mirror and turn when safe to do so. Here, my lord, the evidence of, my lord, the pillion rider also indicate, my lord, that he was taking a U-turn. In this context, my lord, I will invite your lordship attention to sketch
He's
one.
not rider, he's the insurance company official.
Pardon?
RW1 is not rider, he's the insurance company official.
Yes, my lord. My lord, I am taking your lordship through the, my lord, the police records.
Yes.
The exhibit P6, my lord, the statement of the, my lord, the pillion rider Krishnamurthy admits that they were taking U-turn. Then, my lord, spot sketch may kindly be looked into, my lord. P7. The point of, my lord, the impact is shown on the right side of the main road. P7, my lord. He was taking a U-turn, and more particularly, my lord, your lordship has to appreciate the pillion rider is not injured. Only the rider, my lord, has gone and dashed against the car which was proceeding on the main road. Pillion rider is not injured and he has not made any claim. So it is
Pillion rider is injured, my lord.
Please, you take your seat. ಕೂತ್ಕೊಳ್ಳಿ, ಅದಾದ್ಮೇಲೆ ಹೇಳೋಣ.
ಆಯ್ತು ಸ್ವಾಮಿ.
Then you have to kindly see, my lord, that the deceased was not wearing the helmet. Section, my lord, 128 and 129 of the MV Act may kindly be looked into.
Copy is not produced.
ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದ್ದಾರೆ ಸ್ವಾಮಿ.
ಎಷ್ಟು ಎಕ್ಸಿಬಿಟ್ ಎಷ್ಟು?
Again, ಚಾರ್ಜ್ ಶೀಟ್ ಇದೆ ಸ್ವಾಮಿ. ಡ್ರೈವರ್ ಇದೆ ಸ್ವಾಮಿ. ಎಕ್ಸಿಬಿಟ್ part 3, my lord. Charge sheet, my lord.
You are not produced. P series.
Please, my lord.
Yes.
But mere filing of the charge sheet, my lord, will not decide the negligence because the bigger vehicle will be charge sheeted normally by the police. But the question of, my lord, the negligence on the part of the, my lord, the deceased who has contributed to the cause of the accident, after appreciation, my lord, has held only 40% instead of 80%. That's the contention of the appellant. In ground number 3 also, my lord, I have made it clear.
Yes.
Ground number 3, my lord, I will read it to you. The tribunal, though pragmatically considered manner of accident in question and held rightly that the deceased was taking a U-turn and was responsible to the cause of the said accident, was not justified in holding that the deceased was negligent to an extent of 40% instead of 80%. Since the deceased was major contributor to the cause of the accident in question by taking U-turn with a pillion rider without keeping a watch for the movements of the vehicle playing on the highway, and with utter disregard to Rule 12 of Rules of Road Regulations 1989 and in contravention of Section 129, not wearing helmet, without wearing helmet, and Section 128 of the MA Act, that is, disregarding the safety of the pillion riders, and accident is not denied, my lord, but only thing is higher degree of contributory negligence should have been considered by the tribunal because he was taking U-turn, and sketch, my lord, exhibit, my lord, P7 clearly makes it clear. And only the rider of the motorcycle, my lord, was fatally injured. He has to wait and see for clearance, and then only he has to take a U-turn.
What is the evidence led by you, sir?
The evidence is, my lord, the evidence of pillion rider, PW2, he himself says, exhibit P5. On behalf of the insurance company, RW1 has been examined and he has produced the photos which clearly show the higher degree of negligence on the part of the deceased.
No repetition, please. No repetition.
That is regarding, my lord, the negligence. On quantum of compensation, would have to kindly look into ground number 5 of my appeal memo. The tribunal grossly erred in allowing rupees 63 lakhs 93,824 as a total loss of dependency, holding income of the deceased at rupees 5,32,818 per annum after deduction of alleged income tax when exhibit P 13 to 17 form 5 were not proved as required under law, since they were mere photocopies with no signature and not accompanied by statement of balance sheet, and that too when exhibit P12 disclosed the license of the deceased to run his alleged carpentry industry had expired in the year 2000 to 2009 itself, not renewed thereafter. Exhibit P12. So under these circumstances, my lord, the award made by the, my lord, the tribunal and the loss of dependency to a tune of 63,93,824, my lord, requires to be reconsidered by this appellate court. And the alleged witness was continued by my lord PW2. And there is only loss of service, not the loss of income. Yes. With these grounds, my lord, the appeal is filed by the insurer.
That's all?
Pardon?
That's all? About
Yes, my lord. Considering the, my lord, the IME report and all that, sketch and all that, my lord, the higher degree of contributory
no
negligence.
repetition ಅಂತ ಹೇಳಿದ್ವಲ್ಲ ನೀವು ಅದರಿಂದ you said you are going to quantum.
Sorry.
Quantum ಮೇಲೆ ಅಷ್ಟೇನಾ?
Quantum, my lord, as in that the income tax forms, my lord, P13 to 17, only Xerox copies not having signature, not followed by, my lord, the statement of balance sheet and all that. And the license to run the industry expired, my lord, on 27/11/2009 and thereafter not renewed. Ground number 5, my lord, in page 6, I have made it clear. Accident is 2017. Statement of, my lord, returns are filed only up to 2014-15. And the license to run the industry, my lord, expired on 27/11/2009. Thereafter not renewed.
The cross examination have disputed the genuineness of these documents. Exhibit P 13 and 15. In the cross examination they have disputed the correctness of these documents. Eyewitness or that complainant.
Please, madam.
His income tax returns were marked in the
They have-
evidence of
Please, my lord, they have filed it, madam. This one, madam.
cross examination ಅಲ್ಲಿ That's all. I think anyway.
In this regard, my lord, charge sheet has been filed against the driver, my lord. It has been not questioned by, it is not challenged in any platform, my lord.
Charge sheet is not.
Yeah, already said that. Please.
Then, much more than that, my lord, the tribunal has taken less consortium, my lord. Only consortium has been paid to wife only, my lord. Children are there. consortium has not been paid.
What do you say about this income tax returns? He was
Income
submitting
with-
that they are only Xerox copies,
The-
they are not
The
produced.
lower court has correctly taken it as correct, my lord.
What about proof of income and proof of, you have produced this
Xerox copies, my,
tax returns.
please, my
It
lord,
was being submitted that they are only Xerox copies. Is
please, my lord,
that correct?
please, my lord.
This is form number 110. What are the other documents you produced about income proof?
In order to disprove those things, they have not provided.
That's being submitted, but they are the Xerox copies, you are not.
Please, my lord, please, my lord.
Original income tax returns, why did you not produce the original?
Right, also, my lord.
ಯಾಕೆ ಮಾಡ್ಲಿಲ್ಲ ಅಂತ?
ಹೈಕೋರ್ಟ್ನಲ್ಲಿ ಮಾಡಲಿಲ್ಲ
Huh?
ಹೈಕೋರ್ಟ್ನಲ್ಲಿ ಮಾಡಿರಲಿಲ್ಲ ಮೇಡಮ್. Xerox
ಟ್ರಯಲ್
ಹಾಕಿದೆ.
ಕೋರ್ಟ್ ಅಲ್ಲಿ ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ ಯು ಹ್ಯಾವ್ ಟು ಸ್ಟ್ಯಾಂಡ್ ಓನ್ಲಿ. ಈಗಾದ್ರೂ ನಿಮ್ಮ ಹತ್ರ ಇದೆ
ಕೊಡ್ತೇವೆ ಸೋಮವಾರ, ಒರಿಜಿನಲ್ ಇದ್ರೆ ಕೊಡ್ತೇವೆ. ಲಾಸ್ಟ್ ಡೇಟ್ ಕೊಟ್ಟರು ಒರಿಜಿನಲ್ ಕೊಟ್ಟು ಬಿಡ್ತೇವೆ ಸೋಮವಾರ.
ಹೋಗ್ಲಿ, ಯಾರಾದ್ರೂ ಇನ್ಕಮ್ ಟ್ಯಾಕ್ಸ್ ಕನ್ಸಲ್ಟೆಂಟ್ ನೀವು ಎಕ್ಸಾಮಿನ್ ಮಾಡಿಲ್ಲ. ಇನ್ಕಮ್ ಟ್ಯಾಕ್ಸ್ ಯಾರು ಸಬ್ಮಿಟ್ ಮಾಡ್ತಿದ್ರು?
ಒಂದು ಹೇಳ್ತೇವೆ ಸೋಮವಾರ ಒಂದು.
Discussion micro industry ಅಂತ ಬಂದಿದೆ. There is evidence that he was running a micro industry.
Please, my lord.
Work with the exhibit P12. Yes, what do you say? Because you have not produced the originals and now you have examined.
Please, my lord.
Income tax consultant.
ಒಂದು ಶಾರ್ಟ್ ಡೇಟ್ ಕೊಟ್ಟರೆ ಒಂದು ಒರಿಜಿನಲ್ ತರಿಸ್ತೇವೆ ಸೋಮವಾರ. ಶಾರ್ಟ್ ಡೇಟ್.
Here the originals of original income tax returns based on fifteen.
Much obliged.
15-4.
Much obliged.
15-4.
Argument. P&W. Therefore, I'm going to consider
49.
ಇಲ್ಲ ಇದು ಮಿಕ್ಸಿಂಗ್ ಮಾಡ್ತಾರೆ
230.
ಫೈನಲಿ
230 matter for further hearing at 230. Till number 63, Hitesh Kauda Piche, Rajita TO.
ಅದನ್ನ ಅಷ್ಟೇ ತಗೊಂಡು ಅಷ್ಟೇ ಬರ್ಬೋದು. ನಾವು 33 ತಗೊಂಡಿದ್ದೀವಿ, ಬರ್ಕೊಂಡಿದ್ದೀವಿ. ಮುಂದಿನ ಟೇಬಲ್ ಮಾಡಿದ್ದೀನಿ ನಾನು. Yes.
I'll tell the facts in short. The petitioners are the parents. And the first petitioner is the mother. I'm sorry, the respondents. The first respondent is the mother and the second respondent is the father of the child, minor child. The first respondent had, admittedly, there was a marriage, there was a matrimonial dispute between themselves. And that was not, it was an unusual kind of a dispute between them. So she had actually, the mother of the child had actually went to the her parents and left the child with them for a short period, saying that she will find an employment and come back and take the child back, or they can shift the child with them. That was the agreement between them. And in fact, she had gone to Singapore. She did not find a job. She came to Bangalore. They were in fact in Pune. The grandparents and the child was in Pune. So when she was in Bangalore, she found out a job. Her husband also joined with her. Meantime, that they got resolved. And then every month she used to go to Pune to visit her child. And that we had produced the air tickets which she used to visit the child in Pune, which has been marked as Exhibit P3. Then the grandparents had refused to bring the child to Bangalore. Then she had actually, they had asked her to shift to Pune to be with the child. So she got an employment in Pune. I had also produced the copy of the offer letter from a company, and which was produced as P4, copy of the computer of offer letter, which she got when she reached Pune. They shifted with the child to Srirangapatna. So in December 2019, she also moved to Pune. From Pune, she went to Srirangapatna and she stayed with them. In January 2020, she was asked to leave the house by the grandparents and she left the house. Her husband also was staying in a hostel. She moved to that hostel and every day she used to visit the child from there. And she was asking them to give back the child. But by the time there was an outbreak of corona, and she was not allowed in the house also. They stopped her completely and they stopped the video calls also. Then again, she constantly requested them to hand over the child so that she can take the child back to Bangalore, which was refused by them. And then she filed a police both of them filed a police complaint. And in that police complaint, my learned counsel was, my learned friend was referring to about around 6 months. That is because they were staying from December 2020 to June 2020 before they filed the complaint, that they were staying in Mysore to take back the child, not because that was the first time they had asked to take back the child. That was the clarification I had to make. Then at that point of time, they were refusing to show the child, saying that the child has got separation anxiety and he has been, that is subsequently which we filed an habeas corpus petition, which was disposed, stating that to profile liberty to be given to the petitioner, the respondents, to file it before the competent court, wherein we had filed GNWC 9 of 2020, GNWC 4 of 2020. On that, we had filed an application for interim visitation, which was allowed by the Honorable Srirangapatna Court. But that visitation was also not complied by them. We had filed a contempt petition numbering 59 of 2020. 59 of 2020. They had actually filed another writ petition of 842 to keep in abeyance with the visitation rights, 8425. In that, the learned single judge had permitted the petitioners, the respondents, to visit the child on whatever occasion with prior intimation, which was never permitted by them. And in that said writ petition, they have again said that the child is frightened to visit, and they sought for an application to be consulted with a psychologist, which was allowed by, and the child was taken to the child psychologist with the psychologist in Pune, in Mysore, which report was given, which is marked as exhibit which is marked as exhibit.
P series or R series? It is marked from your side or their side?
They have marked it,
That is exhibit R5.
Okay. exhibit R,
R5.
copy of the All India R3. In that, it was clearly mentioned that child is not having any problem, and it is, I shall take your tips. The psychological assessment spread over 4 days with gap between 2 days. Integrated summary, prorated average intelligence with poor academic and social skills, discrepancy between the parents and grandparents and aunt, and the clinical observation of the child. Child was able to build rapport with the mother. Parents can exercise visitation rights without any conditions. So again, the learned single judge had passed an order of visitation, which was not permitted by the appellants, and therefore we had moved another contempt petition, 583 of 2022. In that 583 of 22, several orders were passed, and that time they had again come back that the child is having a problem, and he has been consulting with NIMHANS. In that, there was a specific order by the Honorable Chief Justice Court to leave the child with because there was no opportunity given by the grandparents to having consulting with the NIMHANS. So 14 days the mother and the grandmother spent with the child in NIMHANS, wherein there was a clear observation made by the that is exhibit 26, R26, wherein the detailed report of NIMHANS was given. R26. My lord, the first, I would like your lordship to page number 2. Page number 4, my lord, sorry. Here, they had consulted NIMHANS before and they had consulted NIMHANS well before the High Court, Honorable High Court had ordered. And in this, they have given the main reasons for consultation is legal purposes. It is not that the child is suffering. They had gone to the court for legal purposes. At the first time, when they had been summoned to this honorable court, they had actually gone to Coimbatore for consultation to avoid the summons from this honorable court. So in this specifically, they were spread out on this 14 days. There was a report given by the NIMHANS, that is at page number 135.
135 what?
Of the R26.
26. Page number 20?
135 of R26.
And then 35.
Yes, ma'am. It's a discharge summary. Regular discharge, it's a discharge summary. A summary of observation. When upset or uncomfortable, the child tended to use foul language, but with persistence or diversion, they 135, a summary of observations.
Yes.
Yes. I shall read the summary of observation. When upset or uncomfortable, the child tended to use foul language, but with persistence or diversion, he engaged well in few minutes.
No persuasive mood disturbance, anxiety, aggression were noted. Cooperative play and pretended play appropriate for age were present. Rian does have some developmental concerns. While he is verbally able to convey ideas and has knowledge of complicated vocabulary, he has difficulties with reading and writing as per his age. He has difficulties with socio-emotional regulation and in communication of socio-emotional difficulties. He also seems to have restricted interest. However, when engaging with other children, he was able to participate in pretend play outside his areas of interest. Feedback about the above-mentioned observations was given to the mother and the maternal grandmother of the child. They were encouraged to work on interpersonal issues, keeping the best interest of the child. Again, condition at discharge. Rian does not have any persuasive, emotional, or behavioral disturbances. He needs support when dealing with changes or situations at high interpersonal stress. And again, recommended on discharge. 2 tablets were recommended. Child should be provided. The third, child should be provided opportunities to engage with all family members for appropriate and developmental conducive attachment formations. Child needs opportunity to engage with same age peers. Schooling needs to be initiated, assisted by psychological support as needed. Child have a daily routine with multiplicity of activities and several of them involving activities same age peers. Family therapy with all family members to be initiated. Follow-up days in child and adolescent psychiatry. But after this, they have never followed up with NIMANS. That is the main thing I wanted to bring into your lordship's attention. The child was with them even after this for 1 year. They have never made any follow-ups with NIMANS. Only when we had taken in custody, we had visited NIMANS for the first time, and I have a report which has been given day before yesterday. I shall submit that, which says that after this, they have not consulted NIMANS. Next, page number. My lord, I shall take to this report the 9th page also. 9th page of this report, R26.
Same.
Same. As reported.
Where is the page number?
Page number 9. It's R26 page.
R26. Beginning a signal around 27. First, the first page of that R27.
R26. R26, my lord, this NIMANS report.
Parking here. Then to Honorable Chief Justice ಅಂತ address ಮಾಡಿದ್ದಲ್ವಾ?
Sorry, my lord.
R27 or 26?
R26. R26. Same, which have been read, page 9. That.
There's so many records. Out of these documents, some portion is marked. R27 ಇಲ್ಲಿ R27.
Page number 9 in R26. It's a handwritten page.
Handwritten. Resident report ಅಂತ R26 ಅಲ್ಲಿ page number 9.
Third paragraph that as reported by.
Page number 9. Third paragraph.
Yes. As reported by grandparents and aunt, child has been with them since the age of around 2 years, with the child's mother infrequently visiting during COVID-19 lockdown due to fear of infection. Visits by anyone, including the mother, was discouraged. My lord, again, I shall take the same report, page number 12. Unnumbered, the next page, 12, then the next page. In 12, the next page.
grandparents reported that mother Tripti was always in touch and Rian wanted to have Rian with her
Next
due to her
page.
career and some,
Next page.
yes. 1, 2, third paragraph. GPS reported that the mother,
In patient admission and Tashurod.
grandparents seen by Dr. Kavita seated. Page number 12 and the back side of it. It's not numbered, my lord.
ನೀವು ಈಗ ಹೇಳಿದ್ರಲ್ಲ as reported by the grandmother, child is in good terms with our mother ಅಂತ ಹೇಳಿ ಏನು ಹೇಳಿ. Can't report that mother.
Grandparents reported that the mother Tripti was always in touch with Rian and wanted to have him with her.
ಅದರಲ್ಲಿ ಪೇಜ್ ನಂಬರ್ ಹಾಕಿದಾರಲ್ಲ ಸ್ವಲ್ಪ ನೋಡಿ.
There is no number. It's dated 1/11/2022, my lord. Behind 12 it is.
Just
Just
right, we got it. ಅದು ಇದ್ರ ಮೇಲೆ ಪೇಜ್ ನಂಬರ್ ಇಲ್ಲ, ಬಟ್
grandparents,
ಪೇಜ್ ಇದೆ 13 ಅಂತ.
next page of it.
Grandparents.
Third paragraph. Grandparents reported that the mother Tripti was always in touch with Rian and wanted to have him with her. Due to her career and some very difficult circumstances, she had to leave with the grandparents. Details will be attached. Child is going for visitation on every Sunday and is feeling comfortable with the parents. Then the next also, grandparents have been explained the need for involving the parents in the therapy process. Then I would like to draw your lordship's attention to page number 46. Page number 46 of the residence report, it is same. It's about the RRW6 who came without an appointment to name and she tried to influence.
Exhibit documentation.
R26, page number 46, same. When everything was going on smoothly, this RW6 who is the,
It starts like resident report.
yes, resident report, the counselor, the first line, the counselor came without an appointment. She requested for an urgent discussion and update about the child. She was not called there, she went there. That is the witness RW6. And the last line also, it was also assured that the team will be sensitive to the child's needs and they will not be responsible. The next, the team and the demands team will not be held responsible for any kind of intervention followed by the family purely on the advice of the counselor. Next page after that.
And alternative to it to provide a appropriate support which similarly she came without the counselor came without an appointment. She requested for an urgent discussion. Update about the child.
My lord, I would like just one more page number 54. As per the Honorable High Court direction, they had gone for a mediation before the Family Court Mediation Center, and
This document was summoned at their instance or at your instance? These documents were summoned at whose instance?
these their ins-
At your instance.
they had asked them to produce it. Because the child was never with us, so we did not have it.
No, if these documents are summoned by you, they become your evidence. That's why we're asking you.
My lord, again, this page number 54, they had gone for a mediation. After the mediation, he had agreed that the parents to visit their house and interact with the child. Subsequently, the appellant number 2 in 8418 submitted an affidavit, which is, I will just read the paragraph, page number 54, paragraph 14A. 14, I say that the respondent number 2 has executed clause 1 of the mediation report. Since it did not involve any participation of the minor child or put him at risk. However, we find it imperative to pray
That respondent number 2 there?
grandfather.
Grandfather.
The clause number 2 and 3 of the clause of the mediation report to be set aside until the present condition of the minor child is well understood by Dr. Isha and Dr. Kavita. Actually, he had lost faith in NIMHANS also. That is the reason he had said that they had told to interact with the parents, but then also the appellant number 2 had consisted.
Affidavit was filed?
He had filed in CC in the contempt petition. He had filed this to set aside the mediation report. Contempt petition 583 of 2022.
Mediation was held in?
Bangalore Mediation Center. At page number 73 is the settlement agreement which had.
So what happened when they sought this setting aside the mediation?
In that mediation, because in the contempt, they were not allowing mediation, they were not allowing visitation. They had asked him to permit visitation at home because he said the child will get frightened. So when he already agreed for the mother in visiting the child, finally he said to set aside the mediation because I did not consult with my daughter whose lease agreement with her.
Correct. What happened on this affidavit?
This affidavit, he had filed to set aside the mediation. That's what
He
I just.
filed it, but nothing was done.
Nothing was happened. I'm saying about the conduct of that, how he resisted the visitation. Even to visit the child, he had been consistently resisting the parents from visiting the child. That is why the child did not have any interaction. That's what I'm trying to say, bring it.
How the process of NIMHANS anticipation came into picture. So when the honorable bench was of the view, yes, this needs to be looked into, whether the child is anxious or anxious. So this mediation was.
So in response to this affidavit, child was referred.
Then the matter went to the NIMHANS for analyzing the mental health of the child.
Regarding the mental, the report, actually, this is not the case. My learned friend is trying to mislead. What happened is that they never made the child present before NIMHANS, and a team of 5 doctors had come before the chambers and reiterated the matter. The child was never permitted even for consultation. That is the reason there was an order 14 days the child has to be in NIMHANS, and that's as an inpatient as per the direction of this court. Otherwise, he had never taken the child. Throughout the report, it says that he never permitted or allowed the child to come. I would like because since he had said that, I would like your lordship's attention to few pages wherein he never brought the child. One day he had said the child is not willing to come. Other day he has said, he had told that they met with an accident, they did not bring the child. And usually when the child starts to open up, immediately the grandparents interfere and never allow the child to speak even with the counselor. That is where the instance which was brought, the doctors had brought before this honorable court and and that is why this order was, I shall go through that order because it was a detailed order by this, by the Chief Justice Court. I shall take your lordship's attention to page number 96 of this. With your lordship's permission, shall I read?
But they wanted to lay down some guidelines. Yes.
At the very outset, we place on record our appreciation to the positive response by the team of experts consisting of Dr. Isha Sharma, Associate Professor of Child and Adolescent Psychiatry, NIMANS, Dr. Kavita Tangam, Additional Professor of Psychiatric Social Work, NIMANS, and Dr. Thomas Kishore, Professor of Clinical Psychology, NIMANS. During our detailed interaction with the team of experts, which we had on 4/10/2023 at 2 p.m., certain facts were disclosed to us. That though this court had directed to have continued series of meetings enabling the team of experts to submit further reports to this court as per order dated 27/7/2023, it was brought to our notice that except for only one session, the grandparents of the child did not bring.
No, anything specific you want to point?
No, that's what I had. I just wanted to inform, bring to your honorable's notice that this is what they have been doing. They have never brought the child. It is on this.
You read para 3 only, just whatever is in para 3, it is said, suffice it to note that despite the directions being issued by this court, grandparents of child
Are not making the child available.
Ashte one kade elli ready order.
Yes, ma'am. One more paragraph. Paragraph 4. Apparently, the team of experts have shared their opinion on the grandparents of the child that the child could be put to school, and the grandparents had responded by saying the child would be admitted to school as and when he was comfortable. The said opinion of the team of experts was to provide certain exposure to the child to the outside environment of the society, which is essential for its natural and healthy growth. Admittedly, the child is not yet admitted to school by the grandparents, so the child presently aged 8 years.
Special education. Yes.
Inside.
See, there is only 2 points. One is that you voluntarily abandoned the child.
Yes, sir.
So child has developed a bond with them. Therefore, it is not in the welfare of the
Yes.
child to restore the custody
Yes.
to you. That is one point.
Yes.
Second point is that father had some
Financial issues.
allegation, not financial
It's
crisis.
criminal.
ಅನ್ನೋದಿಲ್ಲ.
Yes.
Financial crisis ಇರೋರು ಕೂಡ they can also bring up their children. He was involved some misappropriation, breach of trust or something like that.
Yes.
Only these, otherwise they don't have any legal right to seek the custody of the
Yes,
child.
Those points I have.
Has repeatedly submitted that welfare of the child is the paramount consideration. One thing is mother did not take care, there is no bond between them.
Yes.
Number 2 is, so far as the father, there is,
Yes, sir.
he was fired because he can,
It was that is the reason I have read that the grandparents itself have admitted that Tripti was in constant touch,
That
and I
is-
have produced. Yes, my lord. And then I will like. I would like your your lordship's attention on RW7 Kuldeep Singh. Kuldeep Singh, RW7, which is their witness who had produced the,
The employers.
yes, employee.
Yes.
Yes, my lord, the chief examination of RW7 by Sri SK Advocate. The second line, the service records of 2 years prior to termination, resignation of Apurva Verma, comma, email communication between Swapnil Nagarkar and Tripti Agrawal and stop payment checks issued by Tripti are more than 7 years old, and our origination could not retrieve the document either in the system or physical records. I would like to bring about the employee statement P49. P49 is the email requesting by Apurva Verma to Godrej on 11th July 2024.
Just you can read what is that? Exhibit P49 is the letter of the employer.
Letter of the,
Employer to the father.
yes, exhibit P49. Father to the employer, P49.
P49.
P49 is the email requesting him to send his PF statement from 2007 till date of for my records. So in the chief examination, the employer itself had stated that
Which year is it, sir?
in 2024,
2020.
2024, just before he came in with the production of documents.
Where do we find the date of this communication?
This one,
Then March, Friday.
my lord, on top right.
11/24 ಅಂತ ಇದೆ. ಅಲ್ಲಿ ಮೇಲೇನು Thursday 11 July 10:47 ಅಂತ ಇದೆ.
11th July 2024 at 10:47.
Next, we are reading the next page.
12th July 11, yes, ma'am. The first page is he has requested and the second is their reply. Previously, he had stated in chief examination that the service record for 2 years prior to termination, resignation of Apurva Verma is not available in the system or in physical. But Apurva Verma, when he requested, he got the employment records from them. That is the PF records, which states that it is paid only till, which says that he was paid PF, deducted and paid to the PF account till March 2017. And the records are there.
Correct. See, question is very simple. They say that this man was fired
Yes,
because he misappropriated it.
yes, madam.
Then you try to read from the evidence of RW7 employer that they have examined to prove that because no other inquiry report or any
Yes, madam.
penalty, etc.
Yes, madam.
They have relied on some evidence and RW7.
RW7.
One document which they read out.
Yes.
You try to show from RW1's evidence that he does not know the contents of that document.
Yes.
What is that document?
That document is the termination letter is R.
Documental or RW7 examination, he said he doesn't know the contents of that document at the head. RW7 ಅಂತ. Both of you have to pay additional court fee for this. Handling charges. Yes.
Exhibit 40. RW6.
RW6 or 7?
I'm not aware of the statement shown in R40.
RW6 or 7? 7.
RW7.
Which page?
It is
RW seven page.
cross-examination, second paragraph, third page.
Third page.
I am not aware about the statement shown in R40 about embezzlement of money has been committed either in India or Singapore. The company has not conducted any internal inquiry. Witnesses continues and state as per the document, only internal audit has been conducted. And I am not aware about any inquiry being conducted against Apurva Verma. I am unaware any police complaint being lodged against Apurva.
Well, the domestic inquiry has been conducted against as mandate of law.
Who's RW6?
RW6 is the Debasmita counselor, the psychologist.
With R40 silent inquiry being conducted against Apurva Verma. It is not aware of Verma design. Disciplinary inquiry article. Yes.
I had again saying that he was after that he was employed and he had produced the statements showing that salary has been credited from some other company, and that statement also I had produced. So the termination letter was issued. R40 is issued with immediate effect, which is dated July, but he was employed in June.
He was earlier working in DC Godrej and
Yes,
Godrej. Later he joined.
Lodha Properties. So the termination letter is dated July 2017, which is immediate effect. So my learned friend was saying that he was not paid PF because he was terminated, but he was, according to their termination letter, he was terminated in July 2017 with immediate effect. Then he should have been paid April, May, and June's PF. That is what I was trying to. That's all.
Yes.
Yes, my lord. Before that, one more. This, because they were R27, page number 27. Page number 20, 25.
Page number?
R27, page number 25.
25. Page 25. Yes.
This is to show, just to show the conduct of the, this is appellant number 1, who had given a brief to the Dr. RW5. She certainly did not ask Rian now how he was feeling and whether she could help. Instead, she took the offense to his not holding her hand when she asked, and that in the corridor threatened to tell the judge.
This is all the history given by grandparents.
Yes, my lord, because there is an allegation against the.
Last time we asked him, this is all the history given by them.
Yes, my lord, there is an allegation against the honorable single judge. That's what I just want. Conduct of the parties, just I wanted to.
Last time that was also in court experience. Where is that?
The judge then threatened me to let go of the Rian's hand, and unless I wanted. Fourth line.
Threatened to tell the judge. I was obstructing bonding and walked back. The judge then threatened me to go to Rian's hand, to let go of Rian's hand unless I wanted to face police action. Then so this is given by
Appellant number 1. Aunt. And again, then she says, and then the judge considered a huge success in bonding. This is what I want just to say about the conduct of the parties. Yes, I shall give certain sense. And they are speaking about the welfare of the child always. They have. they are speaking about the welfare of the child. They have consulted at least 5 psychologists and psychiatrists, and they have never made any follow-ups. They have not admitted the child to any school. And they are talking about the welfare, that's
Not taken the consent of the parent for this
yes,
medical treatment.
medical treatment.
Correct.
And not only that, I would, just because one thing there, I had the RW4, in her RW5 in a statement said she did not prescribe any medicines. The grandfather had told that some medicines have been prescribed, and she continued that medicines. There was no initial prescription given. We do not know who prescribed the medicines. That was not.
W5. W5 though, you make a brief note of all this
Yes, ma'am.
because it's very difficult to handle the files.
Yes, my
If
lord.
you give particular this.
That is okay.
And if you have this, you have these copies, make only those specific pages to make.
Yes, my lord.
file
And I will number it and then, yes.
Whatever you rely and whatever you rely.
Yes, yes, yes. I shall produce certain citations and the reason.
The point there. Don't load it.
Yes, ma'am.
Load them here. Tell us what is the point involved.
It's,
We showed him last time, latest judgment 2024. We asked the senior counsel, what is your response to that? It appears he did not make any response.
that also I have, anyway, I'm not, I will
What is
bring
the
about this.
latest one? That
On-
is the latest one.
The latest one is that 2025 judgment of the Honorable Supreme Court, Vivek Kumar Trivedi,
Are they not
Chaturvedi
put it-
versus State of.
The same one which we referred to.
Yes. And
Just those relevant pages and small note of that. if you are-
yes,
Yes,
The-
what is your, that's all.
I shall file, because there is a compliance by the Honorable State to file the report, child's report, every 3 months. So the latest report I've taken.
Whose report?
The Honorable Sri Rangapatna Judge had
Huh.
this is the Nimans report. We had been consulting
The trial court had directed to submit the report, quarterly report.
quarterly report. So that report,
It's a
before,
sealed report.
it's a sealed report, so
Yeah, it was not directly, ordered to be directly sent to the court.
it is given to us. We had requested because we will ask them to send direct.
No,
Because-
we have reached the final stage and will, only thing for us now to dictate is that handling these records.
Yes.
Yes. Yes.
Just cater to the points made by the learned friend, and I will not go beyond that. But to reduce the time, I will find that not with all the relevant arguments between the
Yes.
Working forward.
And the synopsis must be very crisp, concise. Yes.
What we have taken is that admittedly there was a minor dispute. Now this is coming for the first time, otherwise they said it was a innocuous fight between husband and wife. Nothing major to indicate that would lead to issuance of a letter by the mother to the grandfather and giving the custody. Now, difference has to be drawn between an innocuous fight and a fight which leads a person to act in a particular manner, which defies the normal circumstances and makes it extraordinary. Now, definitely, the letter of 23rd of April 2017 is not an ordinary letter given the circumstances. So it was not a simple innocuous fight, it was much more than that. Now, she has continued that same.
We have already asked your senior counsel only whether it amounts to irrevocable surrender.
That letter is only
See,
for
now,
information.
see, are only on 2 points. One is that the child has developed the bond with you. It cannot be suddenly given to their custody. That is one point.
Listen to what points he has made. I just.
And secondly, that you have already argued. Secondly, second one is you said welfare of the child. The father has some antecedents. ಎರಡು ಬಿಟ್ರೆ ಏನಿದೆ ಇದ್ರಲ್ಲಿ?
I will consider to it. So her statement, is there was agreement between the grandfather and the mother that I will take back the child. It does not.
Even assuming that she has given the child to you, that does not amount to surrender.
I have a very, I asked myself,
And even for that also, father's consent is required.
I would rather go slightly different here I asked myself, if parents, one of them is not interested, one of them is not interested in the child. Now, whether his consent comes or does not come, he's not even bothered. For a moment, I'm just trying to impress certain hypothetical situation which possibly will have a relevance to this particular case for your court consideration. Child was 18 months old when he is given or handed over for temporary period. Let me admit to everything. That
See,
I'm going out for a
You have to only supplement what was argued. You cannot again replay that. This was all submitted.
What is it? I definitely stated, a child given at the age of 6, 3, 4, to a child handed over at the age of 8, 9, 10, and as compared to 14, 15, 16, then all three of them paralegally and universally be same. In my humble submission, the answer would be no. Because the requirement of a minor who is 18 months old will be different from a requirement of a child who is 8 years old. And that requirement will be different from a child who is 16 years old. And all three are minor. All three are minor. And I have not been able to find even a single citation which comes closest to this particular unique case. It does not. I have seen not many incidents from various high courts and Supreme Court. I have not been able to find even one which even comes closer to this. Possibly your lordship.
No, what are you trying to say by that?
I'm
If
trying-
mother gives, even assuming that she had given it, I mean, she wanted to part it from the child or abandoned, etc. Does it give you any right to retain the child even when she wants it back?
Lordship, I would only submit, if I simply go by the reading of the legality, that the father is the first guardian and mother is the second guardian, then the whole wording of the Guardianship and Wards Act, that the welfare of the child is paramount, will be rendered over.
All right, you submit only on that point, welfare. Welfare, you have already sufficiently argued that she had abandoned, she did not take care, she did not come back. ಅದೆಲ್ಲ ಏನು ಓದಿ ಹೇಳಿದ್ರು.
Now, look, there are certain points I want to make out because the impression is being given. You cannot read a line isolated from a particular state to say that she was in touch with the child. From 2000, now what she has missed, I would like to reiterate, 8th of August 2018 is the first flight from Bangalore to Pune, first flight. Now, I asked myself, from 23rd of April 2017 to 8th of August 2018, there is nothing to indicate that she ever visited child. Nothing.
The date of letter date was 23/12/2017.
23rd of April 2017. And that letter I am not relying upon as a custody letter. I am not.
So you're trying to say that between this time she did not visit the child.
Even once.
So
First document is flight ticket.
where was she? Where was she during this period?
Admittedly, she was in Singapore trying to.
And that's why she was in some other country.
Yes, even I agree.
When she came back to India.
She used to come back to India, possibly that is how she was hunting for job in Bangalore. And that is how she shifted to Bangalore. But during this time, her priority was job, not the child. Even from 8th of August 2018 to 29th of September 2019, the documents which they are relying upon, the flight tickets, they totally number 11 days. 11 days. So I asked myself, out of 400 days, you visit a child 11 times. Between Saturday and Sunday.
Yes.
8th of August 2018 to 29th of September 2019 are in 5 days. Total number of visits is 11, that is what the 11th is counted and given delegated. Out of 400 days, 11 visits. Then it goes on to this. That there was RD, report by All-India Institute of Speech and Hearing, which says the child does not have any problem. ICE is not qualified to give this kind of a certificate. It does not have a pediatric psychiatrist. It does not have. So for them to even give this certificate is non-existent. It cannot be taken into account. RD has to be held to be a non-document. Now, she has said that when I read to enhance, the document talks about legal purposes. Wherever I have gone with complete disclosure. I don't want to say to a doctor that this is what I need and then I come to court. Because whenever you are intending to use a particular medical document for legal purposes, the concerned professional has to be informed. And that is the purpose of it, not for anything else. Now to bring out an ulterior motive from there is going too far. Now she has also alleged that no follow-up. I ask myself, unlike normal medical issues which affects the physicality of a human being, medical issues are slightly different. In medical issues, there are two levels of treatment. One is psychologist, and the other one, the more specialized one, who are capable of giving medication, are psychiatrists. The job by a psychologist and of a psychiatrist are complementary. Meaning, unless the psychologist tells me that you need to consult psychiatrist, I will not approach the psychiatrist. That is the basic rule insofar as the psychologist, psychiatrist, and mental issues concerning a human being is concerned. She cannot point out even once that the psychologist was not in picture throughout the time when Rian was under treatment. Even first time when I was gotten recommended to Dr. Raghavendra, she said that the prescription came out of her finger. Page 10, page 4 of Exhibit 25A, R25.
Yes.
So sometimes statements have to be made with the concept that you not to mislead. Now, this document has been proved in trial court. It is a document on record, which clearly says, these are the prescriptions, page 4. Dr. Raghavan, he is a trained psychiatrist. He is not a psychologist. And this medication, what was recommended by Dr. Raghavendra, has been continued by Dr. Soumya Bhaskar, a psychiatrist, and then by Vinas also. So for anyone to say that the prescription came from thin air is absolutely unsustainable. And insofar as the issue of follow is concerned, I don't need to visit the psychiatrist every time. It is only when I find the child is improving, I will go to a psychiatrist asking that can the medicines be reduced, or if the child is facing more anxiety, will I go and meet a psychiatrist and then the medication could be increased. These two recommendations are based by psychologists and it need not be followed up with a psychiatrist. He has referred to page 9 that during COVID, visits was discouraged. That was the norm. What do they respond to? What do they respond to? If I'm saying during COVID, please don't come. How is it not in the return of the child and how am I hampering the right?
What about video calls?
They were there. They were happy. She is talking about physical proximity, not about video calls, not even one side like that. Even then, during COVID, it was we, during visitation, we went to the High Court and said, we let the visitations happen by video conferencing. That is what the Honorable High Court single bench allowed. Okay, fine, go by the video conferencing. It is not the case that we did not permit video conferencing. Video conferencing was happening. Thereafter, she has referred to mediation that they should visit each other's house. Not referring a document of mediation itself as impermissible. Even then she is referring to it. I have no say. Thereafter, a lot of water has flowed down the river. The Honorable Division Bench, hearing the contempt matter, CCP 583 of 2022, has clearly later on said, this is what happens to be the welfare. We will follow this particular aspect insofar as visitations are concerned. Now, my humble submission is here would be all the reports of Nimhan, of Soumya Bhaskar, of the Honorable High Court in Division Bench in contempt jurisdiction or in jurisdiction, they were only prescribed for visitation, not for custody. Somewhere down the line, the learned trial court, possibly in her own wisdom, took it as if these dictates were for custody. Now, all these orders were only for visitation, whether visitation can happen or not. So, your Lordship may appreciate that if matter was so contagious to the extent that the visitation itself created such a rift in the mind of the child that he had to be given psychotropic drugs Because psychotropic drugs actually came into picture for the first time on 25th of May 2022. Not before that. I repeat, 25th of May 2022 by Dr. Authorized Kumar, psychiatrist.
Correct. By that time, matter was pending before the court.
Yes.
Did you seek the permission of the court to, for administration of these drugs to the child?
I did not. However, these drugs were prescribed because the
This is a
psychology-
serious
No, no.
matter. For a child of that age, giving some drugs when the child was already, it was de jure custody of the court by that time. Matter was pending, no? These matters
Yes,
were
yes,
pending.
it's 2020.
2020.
Yes.
Any time did you inform the court that,
He had placed all the documents before the trial court. And in fact, trial
no,
court has,
subsequently, before going for this treatment?
Your Lordship, I have a submission to make here. Courts are not empowered insofar as the medical field is concerned to give an opinion because they will actually seek an
Not give
opinion.
opinion. See, even for a small section 52 transfer of, even for a small alienation of the property, when the case is pending, you have to come before the court
Your Lordship, I
and
would
inform the court.
Definitely say yes to that. But insofar as serious issues like
This
psychiatry.
is a very serious administering such heavy dose for a small child.
It would have been heavy if I would have proved wrong. If Niman would have
Yes.
said it is heavy.
No,
I
it was
tried.
being submitted that because it was given earlier, it continued.
Niman sir.
You say,
Niman has not even pointed out that these were unnecessary drugs. They have not pointed out. In
Huh?
fact, it was Niman who increased the dose. In fact, Niman increased the dose.
let her reply this. And one thing, you said the courts are not empowered to deal with the medical matters. See,
I'm saying that court also seek an opinion of the medical expert.
See, generally, if these kinds of drugs are administered, suddenly they will not be stopped. Because persons who are administered with such drugs will be having withdrawal syndrome. ಅದಕ್ಕೆ ಕೊಟ್ಟಿರ್ತಾರೆ, continue ಮಾಡಿರ್ತಾರೆ.
See, there are few very dates, crucial dates.
My lord, just I would like to,
Child was handed over to you on 23/4/2017. Till such time, there was no animosity between you and your daughter.
No,
You are in very good terms. And as you pointed out, the circumstances when the child was handed over, there appears to have been some kind of discord between the husband and wife.
Lord.
That circumstances being justified by them to hand over the child and by you to take the child.
Lord.
When did this situation become very kind of vicious between you and your daughter?
It became vicious as my learned.
When?
senior friend-
Specific date.
Yeah, it became during Corona period.
Date.
But I would then point out to the police complaint. Police complaint.
Police complaints 2020,
2000.
right? The 2.5 years between that period, what was the relation between you and your daughter?
It was fine. She used to visit Pune, yes.
Correct. There's no difficulty there.
Wait, one breath is.
By which time, this husband and wife had got along with them very well.
I have not visited.
You may not be, but the records show.
Father, you do not know whether they have, your daughter is
Now look at the
reconciled.
circumstance, why we are trying to connect these dots of this. You said you have never come across a case of this nature, which is why this is peculiar. It is not very strange case. It's very normal, particularly in household. If a young couple have to settle in their life, they do take assistance of the parents in bringing up the children. Be it the school matter or going abroad, which is normal circumstances. We have come across many cases where a mother working as a nurse abroad, child cannot accompany her, visa may not be permissible. These are circumstances. That is why we asked you from 23rd April 2017 till 2020, there is nothing wrong between you both.
Insofar as the parents and the
Yes,
doctors are
yes.
Parents and
Now,
daughters
the
only.
son-in-law and the daughter and son-in-law got along well. Probably, this is when the situation has gone sour.
I may not have instructions to stay there. Not have instructions.
It's apparent.
Now, as being pointed out here, what was concerning for us is about when the matter is at the peak of the fight, you decided to administer the drug without even consulting the parents. Forget about the court.
my
The
lord,
parent not have been brought to the notice. Yes, here is the child with us. We are administering this drug. Please have a consultation with that.
In normal circumstances.
Even,
what
even
are
a
they
pet, when you kept it home, we discuss.
All these facts were definitely brought to the Honorable Division Bench of the High Court.
No, we are not on that, we are not on that. We are only about the conduct of the parties. We are not happened, what happened, we are not on that. You might have had a justified ground to admit the drug, but where is the material that you as a grandparent, you brought to the notice of the child, natural parent of the child, that this is what the child is suffering. We are administering it. Please remember the question I asked. Your relationship with your daughter was good. You decided to administer this very serious drug. Where is the material that you at least brought to their notice that your child is suffering from so and so? We are going to administer this. Where is the material? Which is what we are asking about your conduct, natural conduct. Sir, human conduct. We are dealing with the emotions here. We are not dealing with in property or number or count or weight measures. Any person who's going to be admitted to any hospital for any treatment, there is a consultation amongst the family members. Should we go ahead? Should we not go ahead? Here you are fighting the bitter battle for the custody of your grandchild when your daughter is there. Was it not required for you to at least put her notice that this is what the doctors have said, this is what the doctor is going to medicine? What do you say? Was it not required?
I would point out from the evidence of the respondent number 1. She was in denial always that my son does not suffer from anything.
No. That is fine, sir. But please show us. Have you called upon? Has there been any consultation? Has been any counseling? Child is suffering, so we are giving this.
The Lordship may,
You can't take your decision on your own. A young child of 2-3 years, tender a child.
the Lordship rightly pointed
Not
out.
only that, please appreciate what must be going to. Child may not know anything what is being administered. What must be going to the parents? What child may not be knowing whatever you give, he'll eat or sleep, be that as it is.
To take
What should
these
be going to the mind of the child?
high dose citizens or high dose Montec, etc. What happens?
My child,
I don't think the minds are no.
absolutely.
This is
That's
very
what our concern is.
unfortunate,
See, we are revolving in the true circumstances. 23rd April 2017, and then we come to 25 by 2022. 5 years, battle going on. Suddenly you start giving the medicine to the child without even bringing notice to the parents.
It was not brought to the parents, but definitely to the local court it was brought.
Maybe after that. Maybe after that.
We have been very.
No, you brought it. to
My
the
lord, they
court.
have consulted through WhatsApp message.
Just that they brought it to the notice of the court to justify the retention of the child, not with the permission of the court.
I would beg to differ because I would never want the child to suffer. Had that been the case, you would have never accepted the child. Maybe after a few months, you would have said, it is your responsibility to take it back. Why would we take care of the child for the last 7.5
Why,
years?
why did you not do that?
That is the prerogative.
See, in any normal household, if they keep like our parents, your parents, if they think that the child is in a little critical condition, then the apprehension will be, parents should be first informed. Tomorrow blame should not come to us. Adalva approach ಹೇಗಿರುತ್ತೆ ಅದು?
I can definitely offer one answer to it, although it may not be recorded anywhere. What I have been told by my client, the elder daughter was a very pampered girl. She came into this
Whose
world.
fault is this?
This was a very pampered child, and she became very headstrong, and often parents had to bend backwards to assimilate her desires. So if she wanted to go to X place, parents will say, fine, go. So when these problems happen, I think possibly on one level, from where I see it, the parents
No,
get
again that may militate against you. If you say she was pampered child, she went astray, then you do not know the parenting. Then how do you keep this? How do you keep this?
This consultation he was reading about it,
I
Dr.
trust
Raghavan.
anything
Yes, we
because
just
we
want to
have
clarify.
long time is
This letter itself says, start with least amount of dosage, what it says. And
Yeah.
I would like to start with keyboard one, because it will not be followed, so that I
But-
will not take up any more time next show. If, or I will take 10 minutes next.
you do one thing. ಇಬ್ರು ಸುಮ್ನೆ ಏನ್ ಸಿನಾಪ್ಸಿಸ್ ಹಾಕ್ತೀರಾ ಹಾಕ್ಬಿಡಿ ಬರೀ ಇದನ್ನೇ ಕೇಳ್ಕೊಂಡು ಆಮೇಲೆ ರಿಸರ್ವ್ ಮಾಡಿದ್ಮೇಲೆ ಸಿನಾಪ್ಸಿಸ್ ಹಾಕಿದ್ದು ಅವ್ರು ಹೇಳಿದ್ ಇವ್ರು ಹೇಳಿಲ್ಲ ಇವ್ರು ಹೇಳಿದ್ ಅವ್ರು ಹೇಳಿಲ್ಲ ಅಂತ ಹೇಳ್ಬೇಕು. See, you submit synopsis, you serve within 3 days.
Yes, yes,
And rejoinder, if any, should be filed by the next hearing date.
yes, yes.
We will file something in 3 days and rejoinder if any before 2 days.
2 days.
If you lost
Next Monday, Tuesday, for history. Heard both sides.
Yes.
Heard both side further. Okay. Both counsel shall submit their synopsis if any within 3 days on serving the copy to the other side. And rejoinder to any such synopsis shall be submitted by next hearing date. List on
8-4.
you should pay extra 40, extra fee handling, file handling fee. That's in Indian.
For dictating judgments, cell number 49. 8-4. For dictating judgments, cell number 49, D. Vijay Kumar.
I am for the appellant, my lord.
Sir, ಏನ್ ಮಾಡೋಣ ಇದನ್ನ? ನಾಳೆ ಏನಾರ ಮಾಡಕ್ ಚಾನ್ಸ್ ಇದೆ? 14%? ಅವ್ರಿಗೆ ಅದೇ ಬಾಲಕೃಷ್ಣ ಫಸ್ಟ್ ಹಾಫ್ ಅಲ್ಲಿ ಫೈನಲ್ ಡಿಸ್ಪೋಸಲ್ ಅಂತ ಇಟ್ರೆ ಅಲ್ಲ ಆದ್ರೆ ಸೂನ್ ಆಫ್ಟರ್ ಈ ಆರ್ಡರ್ಸ್ ಮ್ಯಾಟರ್ಸ್ ಮುಗಿದು ಹಾಕ್ತೀರಾ ಇಲ್ಲ ಅಡ್ಮಿಷನ್ ಆರ್ ಆರ್ಡರ್ಸ್ soon after I orders happen. There is no time. Tomorrow we'll dictate it.
Tomorrow. For final hearing?
Nale.
2-4. Cell number 50, Neeraj Rajiv Shivam, Ananta Krishnamurthy.
We saw you were waiting, but we are also.
Very well.
Now, on the last day, certain copies are missing.
Cell number 50, 50.
Last day, some documents are missing from the paper book. We filed it, the court had asked us to verify and find the paper book, whatever was missing from court file. We filed it.
Everything else in
He
order.
has filed.
Yeah.
You have filed.
Volume 2 was missing from court file. We have filed it in.
Very well.
I have served it. I have served
Yeah,
it.
they have given copy.
Maybe had not be completed. Not be.
ಎಲ್ಲಿ ರೆಗ್ಯುಲರ್ ಫಸ್ಟ್ ಅಪೀಲ್ ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಹೋಗ್ಬೇಕು ಅಷ್ಟೇ. I leave it to your lordships because we are
gossip for the applicant. Synopsis something submits that yes, ನಾವು ಹೇಳಿದ್ವಾ ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ ಬರ್ದಿದ್ವಾ
Before the previous bench.
noted.
On
record ಮಾಡಿದಾರಾ?
on
Yes,
2310 ಅನ್ಸುತ್ತೆ ಸ್ವಾಮಿ.
2310.
2310.
It's directed to verify the records and paper books as to whether paper books something.
After that, volume 2 was.
Has complied the order dated 2310/2014 wills 24. It was take time, adjourn to. And after vacation ಹಾಕೋಣ ಏನ್ ಮಾಡೋಣ?
ತಮ್ಗೆ ಬಿಟ್ಟಿದ್ದು if your lordship has the
Every
time.
Soon after vacation.
2-6.
Otherwise we have to make you.
2-6.
2-6.
Grateful.
Cell number 51, Lata Shetty.
Here for the respondents 2 to 7, my lord.
List after 2 weeks ಅಂತ ಮಾಡೋಣ ಅಷ್ಟೇ. After 2 weeks. List after 2 weeks.
Cell number 52 adjourned. Cell number 53, Hariprasad MB, Harini Shivanand.
List after 2 weeks. Yes.
54, Renuka HR, Palkrishnayan.
Copy for respond in this case, my lord.
After 2 weeks.
Yes. Any, kindly the date may be fixed, my lord.
Vacation ಆದ್ಮೇಲೆ date ಬರುತ್ತೆ.
Yes, please, much obliged.
Cell number 55, Raja Ramesh.
Rajaram time ಕೇಳ್ತೇನೆ.
ಇದ್ರೊಳಗೆ dismissal of
55.1 ಕೊಡಿ.
But in MFA 2787 of 2018, my lord, second set has been filed by our office without judgment. It's ready, my lord. I'll be filing it tomorrow. Kindly grant 2 days time, my lord.
2023 ನಾ? 2023 ಬೇರೆ ಕೇಸಲ್ಲಿ ಇದೆ ನೋಡಿ ಇದರಲ್ಲಿ 21 ಇದೆ ನಾಟ್ 22 ಈ ಫೈಲ್ ಅಲ್ಲಿ ಇದೆ ಅಂತ ಹೇಳ್ತಾರೆ ಇಲ್ಲಿ ಬರೆದಿರೋದು ಆರ್ಡರ್ ಡೇಟೆಡ್ 21/3 ಅನೌನ್ಸ್ dismissal of appeal along with note ಅಂತ ಅಷ್ಟೇ ಹೇಳಿದ್ರು ನೋಟ್ ಏನ್ ಹಾಕಿದ್ದಾರೆ ಇದರಲ್ಲಿ ಎಸ್ delay prolonged appeal excited common decisions delay matter of that ಏನು ನೋಟ್ ಕಾಣ್ತಾ ಇದ್ದೀನಿ ಆ ಪರ್ಟಿಕ್ಯುಲರ್ ಫೈಲ್ ಅಲ್ಲಿ ಇದೆ ಏನೋ ನೋಡಿ ತೆಗೀರಿ 5.1 dismissal of the note dated 10/2/2021 passed on 7896 of 2018. 7896 ಅಲ್ಲಿ note dated 10/2/2021 ಅದೇ ನಾವು ನೋಡಿದ್ವಲ್ಲ ಈಗ 10/2/2020. Time is granted to the this is sorry. Condone ಆದಂಗೆ ಆಯ್ತಲ್ಲ as file municipal disposition no notice ಇಲ್ಲ 10/2/2021 ಅಲ್ಲಿ ಇಲ್ಲ that request nothing is placed before us.
My lord, MFA 2787 of 2018, my lord, second set was filed on 23/3/2013. My office, my lord, by mistake or judgment is not filed. It is ready, my lord. I'll file it tomorrow.
Even that is another. I request.
Maybe call next week, my lord.
2787. 21. Okay. In the print order dated 21/3/2023, the 55.1 number is not complied. Therefore, appeal. Already dismissed, no further orders are required. 55 and ಉಳಿದ ಮ್ಯಾಟ್ರಸ್ ಅಲ್ಲಿ ಯಾರೋ ಟೈಮ್ ಕೇಳಿದ್ರೆ ಅಶೋಕ್ ಪಾಟೀಲ್ ಅಲ್ಲ ಕೇಳಿದ್ರೆ
ಮೇಡಮ್ ಅಶೋಕ್ ಎನ್ ಪಾಟೀಲ್
ಲಿಸ್ಟ್ ಆನ್ ಲಿಸ್ಟ್ ಆಫ್ಟರ್ 2 weeks. Yes.
Still number 56. Yeah, Shardamba, HR Renuka. Still number 57 adjourned, 58 Ravi S. Samprati, KT Gurudev Prasad. Still number 59 Renuka HR, Siddeshwara NK.
Appear for respondents number 1 and 4 in the first appeal and appellant in the CRAB. Willard on 9/12/2022.
Deposited the amount or not?
Madam,
Amount deposit ಮಾಡಿದಾರಾ ಇಲ್ವಾ?
ಇಲ್ಲ ಅದು ಏನಾಗಿದೆ ಮಲಡ್ ದಿಸ್ ಆನರಬಲ್ ಕೋರ್ಟ್ ಆನ್ 9/12/2022 ಮಲಡ್ ಆರ್ಡರ್ ಟು ಬಿ ಡೆಪಾಸಿಟೆಡ್ ಎ ಸಮ್ ಆಫ್ rupees 16 lakh. Mlad only 5 lakh rupees was deposited before the tribunal.
Anyway, it is conditional order, you can execute. No representation from the appellant, counsel.
No, Mlad
1 to 4 alva ನೀವು?
1 and 4 because Mlad
3 are minors represented by
2 and 3 are minors.
So you are representing virtually everything.
Yes, all the respondents. Mlad, it is better to dispose of Mlad. That is the reason.
Respondent number one, who is the guardian of response two and three also. Therefore, his name shall be shown to a response 1 to 4
Yes.
in the cause list. He submits that the appellant has not deposited the amount in compliance with the interim order. If that is the case, response 1 to 4 are at liberty to execute the award.
That records are here. That is the reason, my lord, your lordships can be disposed of. ಅಲ್ಲ ಅದೇ ನೆಕ್ಸ್ಟ್ ಎನಿ ಡೇಟ್ my lord, because
ಎಕ್ಸಿಕ್ಯೂಷನ್ ರೆಕಾರ್ಡ್ ಹಾಕ್ಬೇಕು, ಬರೀ ಡಿಗ್ರಿ ಕಾಪಿ ಹಾಕಿದ್ರೆ ಆಗುತ್ತೆ ನೀವು. ಫಾರ್ ಫೈಲ್ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಪಿಟಿಷನ್ ಯು ಹ್ಯಾವ್ ಟು ಪ್ರೊಡ್ಯೂಸ್ ಓನ್ಲಿ ಜಜ್ಮೆಂಟ್ ಅಂಡ್ ಡಿಗ್ರಿ. ಲಿಸ್ಟ್ ಆಫ್ 2 weeks.
ಎನಿ ಡೇಟ್ my lord.
ಆಯ್ತು, ಅಪ್ಲಿಕೇಶನ್
4-6.
Public.
Seal number 60. Matsudan GR, Trimurti KP.
Your Honor, this is with regard to 3741, IA number 2 for stay. That is for maintenance of status quo. Ever since the petitioner, appellant and respondent got married.
is passed. Any interim order is passed on?
No, not yet.
No order is passed.
Yeah.
Why it was not listed for a hearing? Application one of them. IA 2 of 2024 is for maintenance. You have not filed a statement of objection. You have filed.
ಹಾಕಿದ್ದೀನಿ.
Any amount was being paid earlier?
ಇಲ್ಲ.
No, nothing,
The trial court, you have not filed any application for.
nothing.
ಅಲ್ಲ ನೀವು ಹಾಕಿಲ್ವಲ್ಲ ಅಪ್ಲಿಕೇಶನ್ 24 ಹಾಕಿದ್ರ ಕೆಳಗಿನ ಕೋರ್ಟ್ ಅಲ್ಲಿ?
ಇಲ್ಲ.
One was her petition, the other one was his petition. Her petition was filed.
Conjugal rights. Conjugal rights.
And his petition was for divorce.
Yes.
They have children.
No, one was their girl, but she committed suicide by burning herself with kerosene oil.
How old was she when she committed?
She was 13, 14 years, I suppose. 14 years, yeah.
15 ವರ್ಷ.
15.
So no other 125 proceedings, DV Act proceedings, ಯಾವ್ದು ಇರ್ಲಿಲ್ವಾ?
ಯಾವ್ದು ಇಲ್ಲ.
For all these years, you have not sought maintenance 2013-14 in the.
Actually, she is unaware of all this. She is an illiterate lady. And then you see, even after this, order was passed by the Honorable Family Court, she just kept quiet. But ever since then, the respondent got encouraged and he started pressurizing, threatening, coercing to see that she is driven out from the premises where she is staying now. And then only she tried to contact other people and then got guidance.
Examined before that, because it was her petition only.
Yeah, now.
The court ಮುಂದೆ ಅವ್ರದ್ದು ಎವಿಡೆನ್ಸ್ ಆಗಿತ್ತೋ ಇಲ್ವೋ?
ಆನ್ ಮೆರಿಟ್ಸ್ ಮೇಲೆ
ಇಲ್ಲ.
She is illiterate, she was not aware ಅಂತ ಏನೇನೋ ಹೇಳ್ತಾ ಇದ್ದಾರೆ.
Your Honor, she is an illiterate lady. And afterwards only when people guided her, then only she came.
Objection to payment.
ಇಲ್ಲ, ಶಿ ಇಸ್ ವರ್ಕಿಂಗ್ ಪೆಟಿಷನ್ ಅಲ್ಲೇ ಹೇಳಿದಾರೆ ಅವರು.
ಏನಂತ? She is
Your Honor,
ವರ್ಕಿಂಗ್.
she is working.
task.
Yeah, okay.
She is working as.
ಶಿ ಇಸ್ ವರ್ಕಿಂಗ್ ಇನ್ ಅ ಗಾರ್ಮೆಂಟ್ ಇದೆ, ಅವರೇ ಪೆಟಿಷನ್ ಅಲ್ಲೇ ಹೇಳಿದ್ದಾರೆ. ಗಾರ್ಮೆಂಟ್ ಅಲ್ಲಿ ಕೆಲಸ ಮಾಡ್ತಾ ಇದ್ರು.
Garment factory ಒಳಗೆ ಇರೋದಿಷ್ಟು.
11,000 ಬರ್ತಾ ಇದೆ ಅಂತ ಅವ್ರು ಹೇಳಿ. ಹಿ ಈಸ್ ಇದು ವಾಟರ್ ಟ್ಯಾಂಕ್ ಅಲ್ಲಿ ಡ್ರೈವರ್ ಅವರು. ಹಿ ಈಸ್ ಅರ್ನಿಂಗ್ 15,000.
May I submit?
Till these proceedings are pending, you have to pay some maintenance now because now there is.
ಇಲ್ಲ, ದಟ್ ವಾಸ್ ನೆವರ್ ಎನ್ ಇಶ್ಯೂ. ಇನ್ ಫ್ಯಾಕ್ಟ್ ಅವ್ರ ಅಪ್ಲಿಕೇಶನ್ ಕೂಡ ಹಾಕಿಲ್ಲ ಅವರು.
ಹೇಳಿದ್ವಿ ನಾವು ಅದನ್ನೆಲ್ಲ, but whatever it may be, now these matters are.
That was never an issue before the trial court.
Your Honor,
You are insisting on IA 2 of 2024?
pardon?
You are insisting on IA 2 of 2024?
Yeah.
ಅದಕ್ಕೆ IA ಇನ್ನೊಂದು
ಅಯ್ಯೇ ಇದೆ.
ಮೇಂಟೆನೆನ್ಸ್ ಹಾಕಿದಿರಲ್ಲ?
ಹಾಕಿದ್ದೀನಿ.
ರೆಂಟಲ್ ಇನ್ಕಮ್ ಬರ್ತಾ ಇದೆ ಅಂತ ಒಪ್ಕೊಂಡಿದ್ದೀರಿ ಅಂತ ಹೇಳ್ತಾರೆ. Page number ಎಷ್ಟು?
In fact, divorce grant agovargu, there was a medical shop that was belonging to the respondent husband. She was taking the
But
rent.
yes,
Evidence ಅಲ್ಲಿ ಬಂದಿದೆ ಅದು.
after the verdict,
ಮಲಾಟ್ಸ್ ಒಂದು ಡೇಟ್ ಹಾಕಿದ್ರೆ we will argue the matter.
But divorce decree stay, has he remarried?
ಇಲ್ಲ ಅವ್ರು ಇನ್ಫ್ಯಾಕ್ಟ್ ಪಿಟಿಷನ್ ಇದು ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ ಬಿಫೋರ್ ದ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಇಟ್ ಹಸ್ ಕಮ್ ಈ ವಾಸ್ ಲಿವ್ ಇನ್ ರಿಲೇಶನ್ಶಿಪ್ ಅಲ್ಲಿ ಇದ್ದಾರೆ.
No, it is there just
ಲಿವ್ ಇನ್
because.
ರಿಲೇಶನ್ಶಿಪ್ ಅಲ್ಲಿ ಇದೀವಿ ಅಂತ ಈ
Yeah.
ರೆಸ್ಪಾಂಡೆಂಟ್ ಹಿಮ್ಸೆಲ್ಫ್ ಹಸ್ ಅಡ್ಮಿಟೆಡ್ ಇನ್ ದ ಎವಿಡೆನ್ಸ್ ಬಿಫೋರ್ ದ ಟ್ರಯಲ್ ಕೋರ್ಟ್.
Adultery alva.
Yeah, adultery.
The dissolution of
ಅಲ್ಲ
marriage.
ಆಗಿದೆ ಅದು ಇಟ್ ಹಸ್ ಕಮ್ ಇನ್ ಎವಿಡೆನ್ಸ್ ಆಲ್ಸೋ.
Your Honor, may I submit
ಪ್ಲೇಸಿಂಗ್
something?
ಇಟ್ ಬಿಫೋರ್ ದಿ ಕೋರ್ಟ್.
My lord, can I submit something?
Living relation with whom?
May I submit one?
ಸಿಸ್ಟರ್ ಇನ್ ಲಾಸ್ ಸಿಸ್ಟರ್,
Another person.
Relatives alle.
ಅತ್ತಿಗೆಯ ತಂಗಿ.
May I submit one thing, Your Honor?
ಅಲ್ಲ ಇನ್ಫ್ಯಾಕ್ಟ್ ಲೋಕ ಅದಾಲತ್ಗೆ ಹೋಗಿತ್ತು. ವಿ ಟ್ರೈ ಟು ಅಲ್ಲ ಮೈಲಾಡ್ ಈ ಇದ್ರಲ್ಲೇನೆ ಲೋಕ ಅದಾಲತ್ ಕೂಡ ಹೋಗಿತ್ತು. ಸಮ್ ರೀಸನಬಲ್ ಅಮೌಂಟ್ ಮೈ ಪಾರ್ಟಿ ಇಸ್ ರೆಡಿ ಟು ಪೇ. ಇವ್ರು 25 ಲಕ್ಷ ಬೇಕಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ.
She has to live with that amount only because.
ಈವನ್ ಹಿ ಹ್ಯಾಸ್ ಟು ಲಿವ್.
Both of you have to produce assets and liability statement. ಹಾಕಿದೀರಾ?
ಏನು ಮೆಟೀರಿಯಲ್ ಇಲ್ಲ ಅದು ಇನ್ಫ್ಯಾಕ್ಟ್.
Affidavit of assets and liabilities.
ಹಾಕಿದೆ.
ಹಾಕಿದ್ರೆ
ಇಲ್ಲ, ಇಲ್ಲ.
ಇದೆ ಅಂತ ಇದೆ.
ಅಸೆಟ್ಸ್ ಅಂಡ್ ಲಯಬಿಲಿಟೀಸ್ ಹಾಕಿಲ್ಲ.
Assets and liabilities ಅವೆಲ್ಲ ಏನು ಹಾಕಿಲ್ಲ.
ವಿ ವಿಲ್ ಫೈಲ್ ಒನ್.
Lord,
Both the parties may be directed to produce the submit.
my lord, can I submit one thing?
60 ಅಲ್ಲಿ that is not wished. Interim stay of the interim decree judge. Divorce decree stay ಮಾಡ್ತೀವಿ. Till further orders, 2024 is disposed of accordingly. 60.1 ಅಲ್ಲಿ as admitted during the pendency of the proceedings, no interim entrance was sought. Response counsel submits that there was an attempt of settlement and appellant sought huge alimony, use permanent alimony. Both the parties shall submit the affidavit of their assets and liabilities in terms of the judgment of Supreme Court in Rajneesh versus Neha. This term
9-6. Bill number 61, PB Appaya.
6 much obliged.
9-6. 9-6 June. Cell number 61, PB Appaya. Respondent.
not possible, it will not be able to take up today. In after vacation, both parties shall present. Who
Parties are present.
Present, in settlement,
Your lordships had suggested that they be present to see if there's a possibility of a settlement.
They have children?
Yeah.
They have children in the marriage?
Yes, 25-year-old daughter is there.
They are also aged now. There are no other allegations of any, huh? Farmer? She has not. ID proof issued by Karnataka State Court. She is advocate anta idala on retaining. Nave ಹೇಳಿದಿವಿ. Since respondent is a qualified advocate, she is permitted to conduct the case in person anta ಹೇಳಿದಿವಲ್ಲ. ಯಾಕೆ ಏನು? There are no other allegations of any other extramarital relationship ಏನು ಅಂತದೇನು ಇಲ್ವಲ್ಲ.
That allegation was made in her counter before the family court.
ಆಯ್ತು, presently
Presently, no, he lives with his mother. The daughter lives with the respondent, but works in the appellant's college.
last time ಇವಾಗ just for some time back we said ಇಲ್ಲಿ ಬರ್ತೀವಿ ನಾವು ಕೋರ್ಟ್ಗೆ. Some people may not share good relationship with everyone. ಆದ್ರೆ ಬಂದು ಹೋಗಿ ಮಾಡ್ಕೊಂಡು ಹೋಗ್ತೀವಿ. ಈ ವಯಸ್ಸಿಗೆ ಯಾಕೆ ಬೇಕು ಇದೆಲ್ಲ?
There was a demand, if your lordship sees the petition in the family court, the wife had made a demand for permanent alimony of 20 crores. That was of course rejected because the petition for divorce was dismissed. That is the stumbling block now. That is the stumbling block. If they appreciate the fact that there is a 25-year-old daughter, family is a fairly prominent family, my lord. Because of this marital imbroglio, even the daughter's marital prospects are being jeopardized because they all feel that giving a boy to this hotly contested family.
Daughter is sharing good relationship with both of them.
Daughter maintains good relationships with both of them.
So even if they do not live together also, Is it okay for you?
Yeah, my lord, yeah,
Stand
my
for
lord, yeah,
that?
yeah.
Because after so many years,
No, I have no issue, my lord. Nothing is there. There is nothing issue. Only thing, because of the trust, nothing personal issue here.
last week, dispute started in the management of the trust company. She has any role in that trust?
Yeah, I'm the equal to trustees. We both are the only trustees, ma'am. And I'm not at all allowed to,
Dispute is business dispute. rather
business
than-
dispute, no personal dispute. I'm not at all allowed to. go to
Validation ಗೆ
the-
refer ಮಾಡಣ್ಣ.
No, what had happened, my lord, this business dispute led to very unpleasant scenes in the college campus, in the office of the principal, abuse, insults. That naturally led to a great deal of humiliation because after all, he is the managing trustee of a college and being accosted in his own campus and with all these,
It affects both of them. In the eyes of all the
and there are 2 criminal cases pending against her where she has been charge sheeted for trespass.
response.
It has been proved that she has come and trespassed, created scenes. In fact, I'm told that the evidence, the appellant has to give evidence in one of the criminal cases in the coming week.
My lord, trespass is for going to the college, to my own college, trespass. And 2 criminal cases is for that only. I'm not allowed to come.
Complaint is filed by your side, whether she has implicated you in any criminal case.
No,
Wait, please, Your Lord.
She has implicated you in any.
No. She attempted to, those were all closed. The 2 criminal cases he has filed, she has been charge sheeted in both. She filed a suit for her declaration that removal from trusteeship was invalid. She had filed a suit
Right.
saying that her,
Now there is no chance of settlement.
no, there is no chance of a reconciliation, but there is definitely a possibility of a settlement. If she has something reasonable in mind, I will ask my client to seriously consider it. Let them part ways amicably.
Correct. Now, before the child marriage of the daughter, if they get divorced, does it not affect the prospects of the daughter?
At least if they are peacefully divorced, people will understand. But viciously fighting each other in the court, people wonder what's going on.
Just you think about it.
no, my lord, at this age, what I will do?
Both parties.
Now, because this divorce will cause, this divorce will cause me a great, bad impact on my,
Madam, there is no chance of this.
pardon?
There is no chance of you, both of you reconciling, it seems. I mean, at our intervention, if you reconcile, it is possible.
No, I am
somewhere-
ready. I am ready, ma'am. I have nothing to tell.
Court interacted with the parties. Court's attempt to bring reconciliation did not materialize. For hearing, list after 2 weeks.
Normal course, Madam.
Normal
Very well.
signature.
Cell number 62, G. Lakshmi Shrav,
Much obliged.
Mohammed Gurfan,
ಆಯ್ತಾ? ಇನ್ನೂ ಮಿಗಿಲಿದ?
Two weeks. Wait, ma'am. ಹುಡುಕ ಅವ್ರಿಗೆ. ತಗೊಳ್ಳಿ. ಹೊರ್ಟೋಗ್ಬಿಡ್ತಾರೆ.
Parties present.
Both parties are present.
Ma'am, when
And after that,
they get the case,
list after 2 weeks.
can it be postponed?
No, it will be 2 weeks. What she told.
Case starts, huh?
Mm.
Because
Still,
last time I told after vacation because I'm not
It will
prepared.
come after vacation only.
After vacation, ma'am.
After vacation ಬರುತ್ತೆ ಬಿಡಿ. ಇದು ನನ್ನ ಪ್ಯೂರ್ ಸರ್ಜೆಂಟ್ ಅಲ್ವಾ?
Well.
Madam, you just sign there, direct.
ಅದು ಕೇಸ್ ಆರ್ಗೆ ಹೇಳ್ಬೇಕಲ್ಲ 7.
ಇದು ಫರ್ದರ್ ಹಿಯರಿಂಗ್ 230 ಬರೀ ಆರ್ಡರ್ ಕೊಡ್ಲಾ? Both sets ಅಲ್ವಾ sir?
Copy of this order may be made available to learn SPP.
ಅವ್ಳು ಹಾಕ್ತಾಳೆ. ಸರ್ ನಿಮ್ ಅಡ್ವೊಕೇಟಿಗೆ ಹೇಳಿ ಮೆಮೊ ಸಬ್ಮಿಟ್ ಮಾಡೋದಕ್ಕೆ. ಅವ್ರು ನಿಮ್ ಮೆಮೊ ಸಬ್ಮಿಟ್ ಮಾಡಿದ್ರು, ಅವಾಗ ಜಡ್ಜ್ ಹೇಳಿದ್ರು ಆಸ್ ಪರ್ ಸೀನಿಯಾರಿಟಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಆಯ್ತಾ? ನೀವ್ ಇಲ್ಲಿ ಬಂದು ಇದ್ ಮಾಡ್ಬಾರ್ದು.
ಅಲ್ಲ ಮೇಡಮ್, ಮೇಡಮ್ ವಕಾಲ ತಗೊಂಡಿದೆ ಇದು ಮತ್ತೆ ಮೇವ ಹಾಕಿದ್ವಿ ಮೇಡಮ್, ಮತ್ತೆ ರಿಶ್ಯೂ ಮಾಡಿ ಟಿಫಾರ್ಮೇಶನ್ ಮಾಡ್ತಾ ಇಲ್ಲ, ಅದಕ್ಕೆ ಐಎ ಮತ್ತೆ ಅಫಿಡೇವಿಟ್ ಹಾಕೊಳ್ಳೋದು.
ನೀವು ಮೆಮೊ ಹಾಕ್ಬೇಕು ಅಷ್ಟೇ. ಬೆಳಗ್ಗೆ ನಿಮ್ ಅಡ್ವೊಕೇಟಿಗೆ ಹೇಳಿ ಸಬ್ಮಿಷನ್ ಮಾಡಿ.
ಮೇಡಮ್ ಯೂನಿವರ್ಸಿಟಿ ತಗೊಂಡಿದ್ದಾರೆ ಏನಾದ್ರು
ಏನೋ
ಯೂನಿವರ್ಸಿಟಿ ತಗೊಂಡೋಗಿದೆ.
ತಗೊಂಡಿದ್ರೆ ನೀವು ಬೇರೆ ಅಡ್ವೊಕೇಟಿಗೆ ವಕಾಲತ್ ಹಾಕ್ಸಿ ಆಮೇಲೆ ಮೂವ್ ಮಾಡ್ಬೇಕು.
ಇಲ್ಲ ಮೇಡಮ್, ಇದು ಅಫಿಡೇವಿಟ್ ಮತ್ತೆ ಇದು ಮಾಡಕ್ಕಾಗಲ್ಲ ಮೇಡಮ್. ಅಫಿಡೇವಿಟ್ ಫೈಲ್ ಮಾಡಕ್ಕಾಗಲ್ಲ ಮೇಡಮ್.
ಕ್ಯಾಪ್ಟನ್ ಸಮಾಚಾರ
ನೀವ್ ಏನ್ ಹೇಳಿದ್ರು ಅಷ್ಟೇ, ನಾವು ಕೇಸ್ ಎಲ್ಲ ಪೋಸ್ಟ್ ಮಾಡ್ಸಕ್ ಆಗಲ್ಲ.
ಅಲ್ಲ ಮೇಡಮ್, ಇದು ಅಫಿಡೇವಿಟ್ ಮತ್ತೆ ಇದು ಐಎ ಹಾಕೋದಾ ಮೇಡಮ್? ಅದು
ನಮಗ್ ಗೊತ್ತಿಲ್ಲ ಸರ್.
ಅಲ್ಲ ಮೇಡಮ್,
ನಮ್ಗೆ ಏನು ಗೊತ್ತಿಲ್ಲ. ನಮ್ಗೆ ಅದ್ರ ಬಗ್ಗೆ ಎಲ್ಲ ಕೇಳ್ಬೇಕು.
ಅವ್ರದಾ
ಅದು ಅವಳೊಂದು ಕೊಡ್ತಾಳೆ.
ಪೃಥ್ವಿ ಹೊಡಿಯೋದು ಅಂತ ಇದೆ.
ಚೇಂಜ್ ಮಾಡ್ತಾ ಡೇಟು ನನ್ನ ಕ್ಯಾಲೆಂಡರ್ ಚೇಂಜ್ ಮಾಡಿ
ಅಲ್ಲ,
ಮಾಡಿಲ್ಲ.
ಈ ಕೇಸಲ್ಲಿ ಏನಿದೆ ಅದಷ್ಟೇ ಮಾಡ್ಬೇಕು. ಯಾರ್ದಿದ್ಯಾ ವಕಾಲತ್ ಇದೆಯಾ ಅದ್ರೊಳಗಡೆ, ಯಾರ್ದಿದೆ ಅವ್ರದ್ದು ಹಾಕು ಅಷ್ಟೇ. ನೀವ್ ಬೇರೆ ಇದೆಲ್ಲ ನೋಡಕ್ ಹೋಗ್ಬೇಡಿ. ಸರಿನಾ? ಸರ್ ನಮ್ಗೆ ಸುಮ್ನೆ ಈ ತರ ಡಿಸ್ಟರ್ಬ್ ಮಾಡ್ಬಾರ್ದು.
ಒಂದೇ ಒಂದು ನಿಮಿಷ, ಇದು ಯೂನಿವರ್ಸಿಟಿ ಕೆಟ್ಟಿದ್ದೀವಿ ಮೇಡಮ್, ಮೆಮ ನಾವು ಹಾಕೋ ಆಪ್ಷನ್ ಇದೆ.
ನೀವು ಫಾರ್ಮ್ ಸಿಗ್ ಹಾಗೋ ಕಮಿಟಿ ಮುಂದೆ ಹೋಗಿ ಬರ್ಬೇಕಾಗತ್ತೆ.
ಇಲ್ಲ ಮೇಡಮ್, ಅದು ಮತ್ತೆ ಇಶ್ಯೂ ಮಾಡ್ತಾ ಇಲ್ಲ, ಅದಕ್ಕೆ ಮೇಡಮ್.
ಮತ್ತೆ ಇಶ್ಯೂ ಮಾಡ್ತಿಲ್ಲ ಅಂದ್ರೆ ನೀವು